Okay, if we could go on the record now, please.
You're on the record, Your Honor. Thank you.
Good morning. Welcome to the Maryland Public Service Commission's evidentiary hearing in case number 9490, Phase 2, captioned in the matter of the application of the Potomac Edison Company for adjustments to its retail rates for the distribution of electric energy. This Phase 2 is regarding depreciation rates. Counsel, please add video and identify yourself for the record.
Good morning, Your Honor. My name is Chris Gunderson. I represent the Potomac Edison Company. I'll be joined today by my colleague, Mr. Joseph Curran, and Mr. Jeffrey Trout, counsel for the company, is also online today.
Thank you. OPC?
Good morning, Your Honor. Gary Alexander and Patrick McLaughlin for the Office of Appeals Counsel.
And staff?
Good morning, Your Honor. Michael Dean on behalf of staff. I'd also like to enter the appearance of Mr. Lloyd Spivak.
Good morning. Mr. Gunderson, any preliminary matters before we get started?
No, Your Honor.
Okay. Would you like to call your first witness?
Yes, the company calls Mr. John Spanos to the stand.
Good morning.
Good morning. Could you please raise your right hand? Do you swear or affirm under the penalties of perjury that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please proceed.
Thank you, Your Honor. Mr. Spanos, do you have before you a document entitled The Direct Testimony of John J. Spanos, consisting of 22 pages and 3 exhibits?
Yes, I do.
Your Honor, we've pre-marked Mr. Spanos' direct testimony as Potomac Edison Exhibit 1.
Yes, so marked.
And Mr. Spanos, do you also have before you a document titled The Rebuttal Testimony of John J. Spanos, consisting of 75 pages and 7 exhibits? And I believe there are also 3 data request responses that are appended to that testimony.
Yes, I do.
And Your Honor, we have pre-marked this Mr. Spanos' rebuttal testimony as Potomac Edison Exhibit 2.
So marked. Mr. Gunderson, is it possible to turn down your computer? I can hear
The volume.
well on the feedback. I can hear myself and Mr. Spanos on your.
Yep. Is that better?
Well, I don't know until I talk, but yes, I think that's better.
Okay. Mr. Spanos, were these testimonies prepared by you or under your supervision?
Yes, they were.
And do you have any corrections, additions, or deletions to your testimony?
I do have one correction to my rebuttal testimony. Page 53. There's a table 4 at the top, and the amount under the discounted amount for the 7.15%, instead of $6,290.60, it should be $6,314.20, which is consistent to the reference on page 52. That's the only change I have.
Okay, thank you.
Your Honor, can Mr. Spanos say the correct number again, please?
Sure.
Can you repeat that?
Yes. The correct number should be $6,314.20. And again, just to help you along there, that number is referenced on page 52, line 18.
Okay, thank you, Mr. Spanos. If I asked you the same questions today that are contained in your direct and rebuttal testimonies, would your answers be the same?
Yes, they would.
And is your testimony true and correct to the best of your information, knowledge, and belief, with your one correction?
Yes, it is.
Your Honor, we respectfully move Potomac Edison Exhibits 1 and 2 into evidence.
No objection, Your Honor.
Thank you. Hearing and seeing no objection, Exhibits 1 and 2 will be entered into the record. And just for the record, we will start with Exhibit 1, but these are Phase 2, obviously, Exhibit 1. There's probably Exhibit 1 in Phase 1.
Thank you. Your Honor, we do have some brief rejoinder from Mr. Spanos regarding Mr. Guerin's rebuttal testimony. May we proceed with that?
Yes.
Okay, thank you. Mr. Spanos, do you have a copy of Mr. Guerin's rebuttal testimony in front of you?
Yes, I do. Just getting to it.
I'll first direct you to page 4 of his testimony, table 1.
Yes, I am there.
Okay, if you refer to the line for the year 2013, is there any reason why there would be a change in the recorded net salvage for the company in 2013?
Yes, there's actually a couple reasons for that particular amount. First, there was ownership change in 2011, which obviously takes some time to incorporate. So there was a catch up on the recording of all entries, retirements, and all planned transactional entries, including the net salvage. So as you can see, 2012 is a very low number because the recording had not been updated to that point in time. So that 2013 incorporates more than 1 year's worth of accounting entries because it was very difficult to do all of those duties while there was a transition of ownership. I think the other thing that's important to note that around that time period, there were policies and practices, not only for this particular company, but for all within the electric industry that had duties related to the safety and requirements for replacing assets, such as certain poles could not be treated in one fashion or another. So the overall expectation of assets and the cost to remove those assets would have changed during that time period. So that is why you're seeing the increase not only in 13 and beyond, but the two pieces are why 13 changed itself.
Okay, thank you. Can you then turn to page 5 of Mr. Guerin's rebuttal testimony? And specifically,
yes, I am there.
Yeah, lines 19 to 22. Just want to reference you to that testimony. Do you have any response to why the situation that Mr. Guerin presents here is to be expected?
Yeah, so I'll first add that again, based on where we were, and this kind of leads from the first question, the retirements increased considerably during this time period. So when retirements increase, then cost of removal needs to increase. And when we're looking at the accrual and why the net salvage accrual would be higher than what's incurred is because the incurred costs relate to a much smaller asset base, and accruals relate to those assets that are in service today that will be retired into the future. So we are going to expect, because you are recovering the net salvage component over the life of the assets, and the net salvage accruals that we have should be higher because we have growth in the plant investment and the cost to remove that investment. So that's why you see a much higher level, and that's an expectation all across the industry.
Thank you. Next, I'd like to have you take a look at page 10 of Mr. Guerin's rebuttal testimony, and in particular at line 10.
I am there.
And I just wanted to know what your response was to the statement that Mr. Guerin makes that, quote, future net salvage is fundamentally unlike plant investment. Do you agree with that statement?
No, I don't. The net salvage component is part of the service value, and that's described in the uniform system of accounts that the proper recovery of an asset class is the overall recovery of the full service value, which is the plant investment as well as the net salvage or cost removal and gross salvage. The only difference between the two is one occurs at the beginning and you place the asset in service, and the net salvage is incurred at the end of life. However, the overall concept of the full service value is no different, and they should not be treated any differently. So based on my review of his testimony and the concept that we're talking about here, there's no difference between the net salvage component and the plant investment component.
Okay, and right above line 10, Mr. Guerin says at lines 4 to 5 that net salvage should be treated as part of the service value of the plant itself and allocated across the service life of the plant. Are there authoritative texts or the uniform system of accounts that support that statement?
Yes, I think it's very clear that the uniform system of accounts explains what the service value is, and the fact that net salvage is a part of that service value, which is a recovery that the utility should incur and that ratepayers should be paying for, and the fact that this component is what, again, should be done. So you see that in the FERC uniform system of accounts, you see that in the NARUC manual, you see that in the Wolf and Fitch depreciation systems, which are all the key authoritative texts on this issue, and how the net salvage should be recovered as part of the service value over the life of the asset.
Okay, thank you. I'll next direct you to, let's see, how about page 17, well, page 16 through 18, Mr. Guerin, in his rebuttal testimony, discusses case 9092. Do you know whether any party in that case proposed depreciation rates using the present value method with a discount rate that used inflation?
No, that was the first case that we had the concept of the Maryland present value approach brought up. And so the issue was the traditional method versus what was determined to be the Maryland present value approach. So there was not any alternatives to what was proposed as the present value method in Maryland at that time.
Okay, thank you. Next, turn to page 19 of Mr. Guerin's rebuttal testimony. And at line 8, Mr. Guerin states that the present value technique he uses is intended as a means of accounting for cash flows. Do you see that?
Yes, I do.
Is depreciation intended as a means to account for cash flows?
No, not at all. Depreciation is a process of cost allocation. Additionally, as I've discussed previously, FAS 143 was designed to recognize liabilities and not for depreciation. It doesn't apply to depreciation, and why we're not seeing it anywhere else in the country is being utilized is because it's not, its intended purpose is for depreciation and recovery of utility service value.
Okay. And then turn to page 20 and lines 9 to 10. Where Mr. Guerin refers to the effect of the straight line method as ratepayers making a permanent increasing loan to the utility. Is that, how do you respond to that?
Well, depreciation is not a loan concept, and loans represent lending money that will be paid back, often with interest. Depreciation is an expense that is part of the cost of providing service to customers. It is not a loan, that will be paid back. Instead, customers receive a service. In this case, it's electricity, and pay for that cost of the assets that provide the service, including the net salvage component.
Okay, thank you. Just a couple more questions. On page 21 of Mr. Guerin's rebuttal testimony, at lines 1 through 8, the first Q&A on that page, Mr. Guerin claims or implies that you previously recommended the credit adjusted risk-free rate as the discount rate. Can you clarify?
Yeah, I've not recommended that nor any other present value method in my process. The portion of my testimony cited by Mr. Guerin, I merely pointed out the present value method is not consistent with FAS 143 and that the 2.5% component is a rate of inflation. That's been my position all along.
Okay, thank you. And finally, page 25 of Mr. Guerin's rebuttal testimony. Starting at line 12, and then it goes on to the next page. Mr. Guerin claims that for account 365, he did not use the mathematical curve fitting results for his life estimate instead of going with the 82-year life estimate that he proposed in phase one. Do you feel that that's a valid response to your rebuttal testimony?
No, I don't. His only reasoning for not using the 01 type curve is to basically say he used the second best mathematical curve fitting. So that doesn't, to me, with any other reasoning for explaining his estimate, which is outside industry norms for this type of account, it's just not to me, a supportable position to say that he didn't do mathematical curve fitting when he just utilized the second best mathematical curve fit. And the other accounts, he does use the mathematical curve best fit. And as I've explained, and NARU explains, and all other authoritative texts explain, that you should be doing more than just a statistical calculation when determining the life characteristics of assets. And there's nothing in his testimony that says otherwise.
Okay, thank you. Your Honor, that's all the rejoinder we have for Mr. Spanos, and he is now available for cross-examination.
Getting there, Your Honor. Your Honor, may I begin? You weren't. I saw your lips go yes, so that's okay. I'm there.
Yes, please proceed.
Okay. Mr. Spanos, my name is Gary L. Alexander, and I am an associate People's Counsel with the Assistant People's Counsel with the Office of People's Counsel. Good morning.
Good morning.
Thank you. You said, just the last thing you said when you were critiquing Mr. Guerin's rebuttal, that in formulating the best survivorship curve, you should use more than math, basically. Does that include visual curve fitting?
Visual curve fitting should be included as part of your analysis, as well as informed judgment that allows you to understand not only what's going on in the industry, but the specific types of assets that occur. And for this particular scenario, we have overhead conductor for the count 365 that we were just talking about. So a 8201 type curve or a 76 R0.5 type curve is not reflective of what we would anticipate for these types of assets on a go-forward basis. And we have to remember that the survivor curve is...
I'm sorry, Mr. Spanos, it was a yes or no question.
Well, I'm not sure that it was, but I gave you my answer.
Okay, thank you. You also, at the beginning of your rejoinder, said that there was an ownership change in 2011, and that should be accounted for in the calculation of the survivor lives for this depreciation. Did I get that right?
Not exactly. First, in that particular area of testimony of Mr. Guerin, I was talking about net salvage. Now, it may apply to life characteristics as well, but the focus of that point of my discussion was on the net salvage. And the concept that I was explaining was just because there's ownership change is not the cause for the data, but the fact that there are practices in the industry and practices since the ownership change that reflect the way the data is represented. And that was the key component that I was trying to explain there, particularly the fact that more retirements are going on. That's very important to understand.
Mr. Spanos, I'm just trying to get my hands around. For net salvage, as you just said, is knowing that there was an ownership change in 2011 important?
I don't think ownership change is as important as the fact to understand that the data in 2013 and 2012 combined, the accounting for that was important to understand. There was ownership change so that you can see why one year had $281,000 worth of net salvage and the other had 11.6 million. So
All
it's
right,
not,
Mr.
that's the
Spanos,
important part to understand.
Mr. Spanos, I have to ask you again, is the ownership change, knowing that, important in with regard to your rejoinder in the calculation of the estimation of future net salvage in this case?
It's important to note that why those particular 2 years have changed. So that's the importance of the ownership transition, and the fact that policy and practices in the industry as well as through ownership have changed since that time period. So that's why it's very important to understand those two concepts.
Okay,
Together.
so I looked through your direct testimony, and then I looked through your rebuttal testimony, and I didn't see anything about an ownership change in 2011. Did I miss something? And if I did, can you point me to it?
Well, one, I did not specifically state it in my testimony because this is phase 2 of the proceeding. So it was something that was, in my understanding, was part of what would have been done in the last phase. And that's why there wasn't a need to specifically reflect that. And if you are looking at all of the data and doing the full analysis, you will see those types of things that would be a common question that would happen in conducting a depreciation study and understanding that data.
But in this depreciation study that you conducted and produced for this case, the ownership change is not mentioned, correct?
I did not mention the ownership change in my depreciation study. Again, that's not the biggest impact here of the data. It's the impact of those 2 years. So I think that's again, I'm trying to emphasize why it's important to understand. It's just a representation of the 2 years, not necessarily the data itself.
And you said that around 2012, a number of utilities, poles needed to be replaced for reasons related to safety and I assume reliability too. Is that correct?
The overall transition in the industry was that there were safety requirements. So you had more crews and personnel that were assigned to remove assets. And I think that's, again, a practice in the industry, and why you're seeing this all across the country, including the other 3 electric companies in that I've been aware of in Maryland, that these standards and practices have been in place for about the last 10 years, not quite. So that is a well-known industry bit of information, and that the requirements for removal or the duties involved require more people to be there, and that will increase your cost of removal.
If you'd bear with me 1 second. Okay, again, Mr. Spanos, let me get back to here. I, again, looked through your testimonies and I could have missed something, but I didn't see anything about this change of poles needed to replace related to safety. Did I miss something in your testimony or in the depreciation study? Was it mentioned there?
In my field trip notes, there's discussion related to the duties that are involved. That was the degree of discussion that I had on this particular topic. It's not in my testimony. Again, it was not something that I viewed that was necessary to put in my testimony, as it's part of my overall judgment and what I incorporated in the analysis for doing studies in the electric industry. It's not something that's new. It's been in place for 10 years. So it wasn't something I felt necessary. You see the trends of the assets since 2012, both for retirements and cost of removal. This is common in the industry, so I did not feel it was necessary to put it in my testimony.
Um, You can tell me I'm wrong, but as far as I know, your notes are not evidence and they were not attached to your testimony. Did I get that wrong, or is that correct?
Objection, Your Honor. Whether it's evidence or not, it's not within Mr. Spanos' expertise.
Mr.
Okay.
Alexander, can we move on?
Okay, sure. Well, I do have one more question, Your Honor, if that's okay.
One more question is fine, but the particular topic you were on, I think we've exhausted any relevance.
Okay, Your Honor, I'll move on. If you could pull up your rebuttal, Mr. Spanos, at pages 2 through 3. You state that OPC proposes significant changes to the service lives that it proposed during the phase 1 portion of these proceedings for many accounts, and substantially increases the average service life by as much as 26 years from the average service lives that the commission improved in phase 1 of this case. Did I read that correctly?
It sounds, but I was not on the line that you started to read when you started. So if you, since you're asking me to confirm that, could you tell me the lines you were on, please?
Well, it goes from page 2 if you go to the bottom through page 3.
Okay, so you were talking at the bottom of page 2 to the beginning of page 3 and what you were reading.
Yes, and it starts with OPC proposes.
Yes, based on what you read and what's written on the bottom of page 2 to the beginning of page 3, you read that accurately.
Okay, now, do you have on hand order number 89072, which was issued in the first phase of this case? Well, let me ask you first, did you read that order?
I have, and I do have it on hand.
Okay, and I am looking, let me get a page for you. Your Honor, if you just give me one more second, please. I'm sorry.
It's fine.
Thank you. Oh, all right, I've got it, Your Honor. Now I just got to find my page. All right, so if you would turn, please, to page 2 of the order.
Okay.
On the last sentence that goes over from page 2 to page 3, it states that additionally, given that several studies provided by Potomac Edison's were outdated, including its depreciation study, approximately 25 years old, and certain cost of service studies, also approximately 25 years old, the commission is requiring the company to file updates to the studies. And then it says that Um, This isn't working too well. If you go to page, well, first of all, isn't it standard in the industry for depreciation studies to be conducted somewhere between every 3 to 5 years, not 25 years?
Well, each jurisdiction has their own guidelines. As a depreciation person, I prefer to have depreciation studies done every 3 to 5 years. I think that's the most reasonable, but there's no requirement or standard. There are some states or utilities that haven't had studies done for many years. But I would say in the current practice, a more short-term renewal of depreciation analysis is done than 25 years.
Thank you. And if you go to page 34 to 35, and that means it goes from the bottom of 34 to 35, it says OPC witness Garin calculated a depreciation expense of 16.6 million. Given that Potomac Edison had not performed the depreciation as part of its filing in phase 1, Mr. Garin propounded numerous data requests in addition to the data requests propounded by commission staff related to depreciation. And Mr. Garin testified that OPC was provided the plant and retirement data necessary to perform an updated depreciation. And then I'm going to focus you on the next sentence. Mr. Garin specifically stated that he did not perform a comprehensive depreciation study utilizing this data and his own analysis. Mr. Garin proposed adjustments to the depreciation rates and accruals utilized for plant depreciation. So I just want to know, do you agree that in phase 1, as the commission stated, Mr. Garin did not perform a comprehensive depreciation study because he had to put one together by himself?
I don't understand what that means, that he had to do it one by himself. Obviously, if you're recommending depreciation parameters, you would have to do all the required things in a depreciation study, which is following the NARUC manual to do a comprehensive depreciation study. So he recommended, in his testimony in phase 1, he said he did a depreciation study and recommended depreciation expense. The qualification of a comprehensive depreciation study, I'm not sure why he didn't do that part of it. All the things necessary, that you have to ask him.
Okay. Now, in this case, Mr. Garin has adjusted your proposed service lives of only 3 accounts: 362 station equipment, 364 poles, towers, and fixtures, and 365 overhead conductors and devices, correct?
Those are the only 3 accounts. He recommended a different estimate than I did for this case. Yes.
Okay.
This phase.
Thank you.
Excuse me.
I'm sorry. No, excuse me. I interrupted. If you would, please go to account 362, which can be located at your direct testimony at pages, well, it's 7, but it's VII Roman numerals -8 through VII -10 of the depreciation study that you prepared and is attached to your direct testimony. And please tell me when you're there, and I'll tell you when I'm there too, if that's okay with you.
That works.
Gary, can you repeat the page number, please?
Yes, I can. If you can hear me, it's VII or 7-8 through VII -10.
I
Thank you.
located it at page 102 of 237 of the PDF, if that helps.
Yep. Thank you.
And
Mr. Alexander, I will add that I think it's important to also include through pages 7-13. That's the full analysis for account 362. You only took one of the life tables. Just so you're aware, if you're going to focus on my study, there are a couple more pages in there that need to be included.
Oh, I'm going to talk about, well, that's what 7-9 is. You can, after I get through with this, you can point me to another page
Okay.
and then I'll take a look at it, but please don't go into a explanation before I get a chance to look at it.
Sure.
Okay, so what I'm going to do is, first of all, I'm going to go to page, I'm just, instead of saying Roman numerals, if it's okay with you, I'm just going to say 7-9. Is that okay with you?
That works for me. I can handle
Okay.
that. Thank you.
Oh, thank you. So, well, the page before that has the original and smooth survivor curves, which we're going to get back to, which we're going to do in a second. That's at page 7-8. And so that curve is based upon this data on 7-9 to 7-10, correct?
Again, I'm going to.
And
Rick, go ahead.
I understand that there may be judgment. I'm just asking about the act right now. I'm asking about simply, this is the actual data that is the basis for this survivor curves on page 7-8. Just, I'm talking about the actual data, not how you derive the curve yet.
I understand. And that's what I was trying to explain to you, is that the original survivor curve, there are two. One is the 1997 to 2019 historical data, which is on pages 7-9 and 10, and then, and through 11, excuse me. And then there is the 2013 to 2019 original survivor curve, which is also presented on 7-8, which goes through pages 7-13. So it's important to note that's the full analysis that's going on for this account. And that's why I'm trying to state that for you, is that that is what's on the survivor curve. You can see two original curves, and it's important to note that both of those were part of the overall analysis.
Okay. For the 1997 to 2019 experience, those squares are, I'll go on for a second. I'm going to look, the span of your triangle's narrow band 2013 to 2019 has 16 years less data than the other experience band. Is that correct?
It does, and the reason why we've selected that band, as we talked about earlier, that's the what's going on most representative in the industry has been the last 7 years worth of data. So we show you both the overall historical band of data that's available to us, 1997 through 2019, and then we also show you what's happened over the last 7 transactional years, which is most common to be doing going forward. So we give you both in the analysis so you understand that there are trends that are to be built in and considered, as well as an understanding of the data that is consistent with what the company is going to be experiencing going forward. And that's what
Okay, so the triangles, the narrow, represent the narrower band 2013 to 2019, correct?
It represents the more recent band only. It relates to vintages 1940 to 2019, but it's the transactional year 2013 to 19, which is the more recent period of time, and shows exactly what we were talking about earlier, what's most consistent with what we expect to see going forward, given the scenario.
Mr. Spanos, it has 16 years less data than the other band. Is that correct? Yes or no, please?
It has 16 years less transactional data.
Okay, going to the next question. I'm going to go back to page 7-9. Now, the age at beginning of interval, this is the x-axis on the graph, the page before the account 362 station equipment. Is that correct?
Yes, the age at the beginning of the interval represents the x-axis.
Okay, and you go across the page to the y-axis. I'm sorry, the percentage of survivor beginning of interval. That's your y-axis. That's vertical, correct?
Percent surviving is the y-axis, yes.
Okay, now I'd like you to go to page 7-10, which is the next page. And you cut off the data after 64.5 age at the beginning of the interval. What I mean that is it's not shown on the graph of the Iowa curve. Is that correct? And let me just say, you're going to explain it, but can I get a yes or no first?
The answer to your question is yes, we do not present that data on our curve because it's not part of my judgment in determining the representation of the life characteristics of this account. So again, we start off with zero exposures, $106 million. When we get to age 64 and a half, we are at 467,000. The assets that are remaining at that age interval, I do not consider to be representative of life characteristics for this account, which is why you need to use informed judgment to understand the data and why you could, in this particular case, would not consider that to be a driver for what the assets and the recovery pattern of station equipment would be going forward. Station equipment relates to transformers, circuit breakers, control equipment, regulators, reclosers, all those types of assets at a substation. There are some assets in here that would be foundation, but most of it's in 361. So that would be the only assets that go beyond this period of time and should not be considered to be a driver for the life characteristics and why we don't present it. We keep it in the life table so you see it all.
In looking at the graph, I wouldn't be able to see that you didn't present that data, correct? I don't see it.
You don't, but it's all listed on the life table. So again, we don't put it in because it's not part of our judgment. It does not have any effect on our analysis.
Mr. Spanos,
Yes,
can you please try to answer the question?
sure.
You're going well beyond the question.
Okay.
It was a simple question.
Okay.
Is there any way to know, going down these tables, how do you know that at 64.5 you don't consider the rest of the data? Is it stated on this document, or we already talked about the graphic set? Is it stated on this original life table on page 7-10? It's just yes or no. Or I guess.
Sorry. Let me. Again, you're trying to not completely understand the process that's being done. There's nothing on the life table that tells you that data here is not being considered. All the data is being considered. It's not a driver for my survivor curve judgment, which is what I have on the graph.
But
So
I'm just asking you, would I know, how would I know that you cut it off at 64.5 afterwards? Just simply looking at 7-10. Is there something that tells me there that I'm overlooking that you haven't put that in the graph?
Not on 710, but that's why you look at the graph and the graph stops the points there. So that's how you know where I stopped it. So if you want to understand what the process of informed judgment and making a life characteristic, I can continue to explain that. But to answer your question, you look at the chart, you see that the points stop there. That's on how you tell on 7-10 that the rest of the analysis was not the primary focus. It is still there, and that's why we show it, but it's not the primary focus of our judgment.
Okay, so are you saying in your judgment that the data that goes beyond 64.5, are you saying that in your judgment, it's insignificant relative to dollar amounts in exposure at younger ages?
That's not the only factor. It's not significant in determining the life characteristic of the assets that are in service today, because a survivor curve is to estimate the future expectation of life. And in
Okay,
this case, those assets are not what I would view to be primary factors for determining the life characteristics going forward of the assets in service today.
Mr. Spanos, are the exposures in this table recorded at original cost? Yes or no, please?
Yes, the exposures are original cost at each age interval.
So that means that the exposure data at age 70.5 are in dollars at value from 70.5 years ago. Is that correct?
There is still surviving $52,363 of assets that have made it to age 70.5.
I'm not sure that answered my question, so I'll restate it. The fact that the exposures in this table are recorded at original cost, does that mean that exposure data at age 70.5 are in dollars at valued from 70.5 years ago? I'm not sure you're quite getting the concept. It means that there are $52,000 that are still in service today of assets that have made it to age 70.5. So you can't answer the question yes or no, because I won't pursue it if you can't.
I think I'm answering your question. I don't know. Again, you have to understand what a life table is. It's not specific dollars at one point in time. It's specific dollars that have made it to a certain age at that point in time. And in this case is December 31, 2019. So
Yes, so I've asked you, that means at original cost, the exposure data at age 70.5 are in dollars of value from 70.5 years ago.
it's the plant and service that's still surviving that has made it to 70.5 years. Some of it could be
in
older,
other words,
some of it.
Mr. Spanos, it's just, if you can't answer it yes or no, please just say, I can't answer it yes or no. That's all. If that's right, I'm not going to challenge you on that.
Mr. Alexander, I'm trying to explain to you what a life
Yeah,
table is, and the
I
answer
didn't-
to your question
Mr.
is not yes or
Spanos,
no.
I'm only, okay, so you can't answer it yes or no, correct?
I'm trying to give you an
No,
answer to your
no.
question,
No,
and that's what
no.
I'm
My
trying to do.
question is a yes or no question, and if you can't answer it yes or no, please just say so, and I will move on.
I don't know how to answer you any further than what I have to explain to you what a life table is.
So you can't
That wasn't
answer
the
it.
question, Mr. Spanos. You testified that the amounts in that column, exposures at beginning of age interval, were in original cost. Did you not?
They are original cost at the
So
age
then,
interval.
Mr. Alexander is just trying to confirm that the $52,363 shown at 70.5 years, again, at original cost, would be a value 70.5 years ago. Can you answer that or not?
It's at a value 70.5 or longer.
Thank you.
Thank
Does that
you,
help?
Your Honor. Yes, it does. I can now move on.
Great.
All right, let's try the next question. Did you take that into consideration when you determined how much of this data is significant in your application of judgment?
All of the data is significant in my judgment. However, not all of the data is considered to be indicators going forward for life characteristics.
So did you perform a present valuing calculation on the exposures to be able to make a direct comparison of the different exposure values?
No, that's not something that's required under standard practice in conducting life analysis.
Okay, thank you. Move on to the next. And thank you, Mr. Spanos, for bearing with this. If we go to your, I want to make sure that I've got the direct or rebuttal. I think it's going to be a rebuttal. No, actually, it is your direct. At page 19, lines 7 through 11, you said, excuse me, there's a Q&A. And the question is, please provide a FERC, that's for the report of Federal Energy Regulatory Commission, citation rejecting the present value method. And you answer in FERC docket number ER 2001-001, Charles King of the firm Snavely King, who has testified on behalf of the Office of People's Counsel in the past, proposed the present value method, which was referred to as the SFAS 143 methodology in that docket. FERC rejected the present value method. Is that correct? Did I read it correctly?
You read the question and the beginning part of the answer correctly. Yes.
Yes, I'm just focusing on that right now. And if you think the rest of it is relevant, you can certainly bring that up. And I don't think it is for my questions, I mean. At FERC, companies like Potomac Edison, for their transmission plan, can use formula rates rather than test year rate cases, correct?
They can. That's not all the things that reside in front of FERC, but yes, they can for transmission produce formula rates.
And doesn't Potomac Edison use a formula rate at the FERC?
The recovery for depreciation purposes is being evaluated by FERC for Potomac Edison transmission assets currently. And it's conducted a depreciation study that's the same way that we do the distribution assets.
I'm sorry, maybe I didn't make my question clear. At the FERC, does Potomac Edison use a formula rate?
I don't know what the current practice is. I know that in front of FERC right now, they have a depreciation study that is reviewing the same practices that we have in the distribution asset. So I don't know if that's been resolved yet or not, to answer your question as far as currently.
Isn't the depreciation part of their formula rate, of the company's formula rate?
It may be, but I know that I've conducted the depreciation study for Potomac Edison's transmission assets that are being reviewed in the same fashion that have been reviewed here, and I have not been exposed to any challenges that what I have done there are inappropriate.
So, Mr. Spanos, you don't know. And that's what I'm hearing. I'm just saying, don't they use a formula rate? And what I'm hearing you saying is, I don't know. Is that right?
Currently, I don't know what they utilize. I'm
Fine,
telling you
thank
what I
you.
have performed.
I understand that. Isn't it true that even though the Maryland Commission recently approved a 3-year rate plan for BGE in case number 9645, the commission made it clear that it was not approving the use of a formula rate? Would you agree with that? Since you mentioned BGE at other parts of your testimony, I assume that well, let me ask you this. You mentioned BGE and other parts of your rebuttal, correct?
I have mentioned BGE as they filed in Maryland, yes.
Okay, so are you aware that they filed a 3-year rate plan in case number 9645 and that the commission has issued an order generally approving that plan with some qualifications? Are you aware of that?
I'm not aware of the order number that you referenced or the case number you referenced. Could you give me a little more insight on that, please?
Okay, we'll take the case number out. So are you aware that the Maryland Commission recently approved a 3-year rate plan for BGE?
I'm not aware of that specifically sitting here right now.
Okay. I can move on. I'm going to go a little bit into the discount factor, that there is you'd agree that there's a controversy in this case about the percentage of the discount factor used in the calculation of the estimation of future net salvage. Is that correct?
Well, I use the traditional method, so I don't use any discount factor.
Okay.
Mr. Alexander, it's obviously in dispute. Why don't you just
Okay.
move to the first question?
I will. Thank you, Your Honor. I appreciate your patience. If you go to your direct testimony, on page 17, lines 8 to 11, it says that SFAS 143, and the SFAS, can you say what that's an abbreviation for, what an acronym is for?
Standard Financial Accounting Standards.
Yes, is that also known now as FASB, FASB as in boy?
It might be the FAS. I still refer to it as FAS 143. That's been what's been in front of me all along.
No, I just want to say it so that we understand it. So that's how I'll use it. FAS 143 in page 17, lines 8 to 11, requires that the estimate of a future liability be based on the, and now I'm quoting here, the cost that a third party would incur in performing the tasks necessary to retire the asset and the use of a credit adjusted risk-free rate as the discount rate. Is that correct?
You've quoted my testimony accurately, but this does not talk about the Maryland present value approach or whether FAS 143 applies to depreciation.
I understand that, Mr. Spanos. Believe it or not, I have some other questions that follow it. In your rebuttal at page 13, lines 9 through 14, your question and answer is as follows. SFAS 143 requires the use of a credit adjusted risk-free rate as the discount rate. Is this the same as a utility's cost of money or rate of return? You answer no. The credit adjusted risk-free rate is generally lower than a utility's cost of money or rate of return. As a result, the use of the credit adjusted risk-free rate would result in higher depreciation expense than that proposed by staff or OPC. Is that correct? Did I read it right?
I apologize. I didn't, it sounded correct, but I didn't see the page reference. I thought you said page 13, and when I looked at page 13, I did not see that language. So could you rephrase it,
Okay,
please?
I want to make sure that I gave you the, whether it's the rebuttal, I believed it is, but I want to make sure.
Yeah, Mr.
Yeah, it's
Alexander,
the-
the only time you go slowly, or the only time you go quickly, I'm sorry, is when you give a page reference.
Okay,
So if you could give a page reference and then a
yes,
line reference, and we can all get there, and then you can go back to your slow pace of questioning.
Your Honor, I will, that's what happens when you come from Brooklyn. But I will do as you ask.
Gary, it was the rebuttal testimony, page 13.
Okay, so, good. Thank you. Thank you, Chris.
So which lines were you on, Mr. Alexander?
I'm going to get them for you, and then
Okay.
I am going to say them slowly.
Actually, Mr. Alexander, you don't have to say the lines. If you can have him read the lines to himself, and then you can go ahead and ask your question.
Okay, so this is indeed page 13, lines 9 through 14, where you talk about the requirement of the credit adjusted risk-free rate in the application of FAS 143. Is that correct?
So I've read lines 9 through 14. Is that what you've asked me to read? On page 13?
Lines 9 through 14, yes.
I have read that, yes.
Okay, and it discusses the credit adjusted risk-free rate, correct?
It does, yes.
And you state that FAS 143 requires the use of a credit adjusted risk-free rate in its application to legal asset retirement obligations, correct?
I do, yes. That's FAS 143 does require that.
Thank you. Would you agree that a risk-free rate, just the risk-free rate, is generally taken to mean treasury bill rates because the US government has never defaulted on its debt?
If you continue to use the word generally, then I think that's a fair assessment.
Yes, generally. I think I said it, but yes, absolutely. Because it gets into some subtleties and we don't need them here. Now, would you agree that while inflation rates affects treasury bill rates, they are not the same thing?
I agree those two things are not the same.
Okay.
They're correlated, but not the same.
Yes, okay. So something, for example, when inflation rates are higher, let me ask you this. Can inflation rates be higher than the returns on treasury bills, to your knowledge?
I can't think of a circumstance, so I would, I don't know that for sure, but my answer would be no.
Okay. Would you agree that inflation affects treasury bill rates is also because of how the Federal Reserve targets the money supply?
I think that's, again, there's a correlation there, but again, we're getting outside of depreciation in my area of expertise.
Fine, thank you. So one question, in in your view, for the application of FAS 143 to legal asset retirement obligations, did the Financial Accounting Board get it wrong by using an adjusted, credit adjusted risk-free rate, and instead they should have used the rate of inflation? Do you agree with their decision? And if you want, I'll say the question again.
No, I understand the question. Are you asking, I'm assuming for asset retirement obligations and for liabilities, FAS 143 method, which is not what's in this case, but the FAS 143 method, you've described its credit adjusted risk-free rates appropriate.
Okay.
That's not what we're dealing with here.
Good. Now, would you agree that the CPI, let me say it this way. While you say, for example, in your testimony that there are certain different measures of calculating inflation, would you agree that the best measure of inflation and the one most used is the consumer price index?
I think that's most commonly used for inflation. It's supported by the Livingston survey that I brought up. So yes, both of them are what I would be the most appropriate way to determine inflation, which is part of the concept that we're trying to talk about here.
Thank you. Now, the consumer price index, the CPI, I think I got it right, has classified all expenditure items into more than 200 categories. Would you agree with that? That's from the Bureau of Labor Statistics that I got.
Yes,
that.
there's definitely a lot of categories. I don't have the total number.
No, that's okay. And would you agree that some of those items or groups are food and beverages, housing, apparel, transportation, medical care, recreation, education, and communication? Again, I'll represent to you that I got that from the Bureau of Labor Statistics, the Federal Bureau of Labor Statistics. Would you like me to read that to you again slowly, or did you get it?
I believe I got it. And I agree that there are a lot of factors. Some of the ones that you brought up are included in that. But again, this is an overall measure of inflation, and that's what the CPI is represented to do.
And so I just want to make sure it's the CPI that that if the commission stays with its present value method of calculating future net salvage, your recommendation is that the discount factor should be the inflation as represented by the consumer price index. Is that correct?
If we are determining depreciation rates and the concept of net salvage through the expectation of FAS 143 method for these types of concepts, the 2.5% rate, if we were forced to stick with the Maryland present value method, then 2.5 would be the most appropriate percentage, which is based on inflation. And that would be consistent with what I view to be how net salvage should be recovered. Again, I've tried to explain why that's not appropriate for depreciation, but under the question that you've aligned, that would be what I would suggest would be the most reasonable way to look at it.
And so if the commission accepted the CPI of is the CPI about 2.5% currently, give or take?
Right. It's actually a little bit lower than that right now, but the most common factor when taking into consideration all of the net salvage estimates that we've put in, that would be a reasonable guideline given again, everything that we know about not only inflation, but also the data that we have.
Thank you. And so I just want to make sure that, for example, for food and beverages and the CPI, the increase due to inflation that I pay when I go into a supermarket for purchasing apples, asparagus, milk, that's the number that should be used for calculating net salvage of utility plant. Is that correct?
No, you shouldn't be focused on what you do going into the grocery store and determining inflation. And the inflation that we're talking about is the labor value and increase that is being applied to services to retire investment. Yes, the CPI includes a lot of information. I think if you were to segregate what you were looking for this, the labor increase, 2.5% would be still a reasonable percentage, since, as I mentioned, currently CPI is less than 2.5. So it kind of extracts some of the things that you were trying to get at there.
Well, but it includes, for example, the inflation for the new shirt that I just bought. Correct? The CPI I'm talking about.
Again, the CPI and the focus of what we are including here does include other factors that you may be describing, but the labor inflation that we are trying to isolate here related by CPI still would be 2.5%.
Okay, thank you. For this question, I used an inflation calculator, so I'm not going to ask you to agree on a specific number, but I'd like to know if because you've used in your job or your field of expertise, present value or FAS 143 methodologies. I'm assuming that you know something about the dollar's worth of today and the future. And let me tell you what I got and then see if you can relatively agree or not.
Mr. Alexander, can I ask you a
Yes.
question?
Sure.
Is OPC disputing the rate of inflation that Potomac Edison has proposed?
Oh, no, we're not opposing. No. Mr. Guerin accepted the number as the CPI.
So I guess I'm a little confused about this line of questioning.
Okay, what we're disagreeing with it is whether the CPI as a consumer concept or application is relevant to the discount factor for the calculation of net salvage in this case. So we're not disputing the 2.5, we accept it. And Your Honor, I'll just add, because of what the commission said in its order on appeal of, I forget which case it is, but it was your decision that said there wasn't sufficient evidence of whether of whether the discount, of whether the inflation was 2.5%. In this case, that's taken out of the equation. At least I think staff too, but Mr. Guerin has accepted that as a number that is accurate for the CPI. We're disagreeing on its relevance to this case, not the amount. Does that help?
Yeah, I guess I would look to see that your questions are more narrowly focused toward that then.
Okay, actually, I'm kind of, well, I don't think I have many more questions on this. So I'll try it, Your Honor, and if you think I'm out of bounds, I'll just move on, if that's okay. I'll try it, give it a shot and see. So, Mr. Spanos, using an inflation calculator, I took $100 and started in 2001 and went to 2031, and it would be worth $194 using an inflation rate of 2.5%. Does that generally sound right to you? And if it doesn't, or you can't do it, please just say, I can't. I'm not able to off the top of my head.
I'm sorry, could you give me those numbers again, please?
Absolutely. I took $100 from 2001. And then I jumped to 2031. So that's should be 30 years. 30 years forward, and using an inflation rate of 2.5%, which is what you're recommending if the commission disagrees with you and applies the present value or 143 methodology, that $100 in 2031 would be around $194. Does that sound right to you? Or if you can't do it, please just say, I can't do it off the top of my head. I can't agree. I don't want to force you to do something.
No, I can't do that in my head. I would say that an increase is definitely a number higher than $100. I can say is true. Whether it's 194 after that time period, I couldn't. And again, I'm not sure how that really applies to depreciation. So I'll end that there.
Okay, that's fine. I'm going to move on, Mr. Spanos. Thank you. If you go to your rebuttal testimony at page 48, lines 7 to 14,
I am on page 48 of my rebuttal, and I see lines 7 to 14 ends partially through that response, but I do see those lines.
okay, and in those lines, you discussed case number 9644, and you stated that in his explanation of the line of cases dealing with calculation of net salvage before the Maryland Commission, you said Mr. Guerin failed to mention this case 9644 in his timeline, correct?
Yes.
Okay, and then in the settlement, you state that the discount rate was lower than the company's, that's Columbia Gas's rate of return. And that was agreed by the parties and eventually approved by the commission, correct?
Yes, that's correct.
Okay, now I searched through your rebuttal, but I couldn't find the discount rate to which Columbia Gas agreed in that settlement that you discussed. Did I miss it? If so, can you point me to where it is?
I did not state that discount rate from that settlement. Again, based on what we're seeing here and Mr. Guerin's process of having to go through all these different reiterations, it kind of didn't add nearly as much value in the discussion of my rebuttal. So and why we have to change methodologies using this Maryland present value approach each case. But I did not mention it in there.
And would you agree that it was a 6.1% discount rate? Or should I show you the order where it states that?
No, for that settlement, for that particular company, that was the agreed upon discount rate for them. Very different situation what you have here with Potomac, Maryland, but that's what they agreed upon in that settlement.
And now, thank you. And in Columbia's, the overall rate of return was 7.16%. So you'd agree that the 6.1% that was settled was indeed lower than the rate of return of 7.16%, correct?
Yes, 6.1% is lower than the rate of return. Again, a very different company and under those circumstances, but to answer your question, 6.1 is lower than the rate of return that they had in the case.
And that is not the current. Let me strike that. Since you seem to quote this settlement favorably, would you accept 6.1% as the discount factor in this case?
No, I don't think there's any correlation between, as I mentioned in my response, between Columbia's situation and Potomac Edison's situation. Very different environment, very different asset base. So no, again, first of all, it's not my position, but if you're asking my opinion, I've already stated that the traditional method's the right way to do this. So I still think 2.5 would be the only thing that you would consider under these criteria, which is what I've stated in my testimony.
Okay, and did it occur to you that Mr. Guerin didn't include this case in his history of this issue because indeed it is a settlement and can't be used as precedent for other companies?
I don't know why Mr. Guerin didn't include it. I was just stating that it wasn't included, and the fact that 2.5% was considered at least initially as a reasonable expectation. But again, we're FAS 143, or in this case, the Maryland present value method, I'm not agreeing with. So it's kind of hard to know what Mr. Guerin was trying to write in his testimony.
I've got to I want to get there before I ask this question. I think it's going to be your rebuttal, but I want to make sure so I don't confuse things. Nope, I'm wrong. It's your direct. And it's at pages 21 through 22. And it starts on line 3. And it pertains to what you say is a generic proceeding that was before the Michigan Public Service Commission.
I am on pages 21 and 22 of my direct testimony.
Okay. And this Michigan case that you reference, you reference it favorably, correct?
Just stating the facts, I do think it's very clear that the present value approach is not utilized anywhere else, and so if you're reviewing that as favorable and that the traditional method is appropriate, that's what I'm stating here.
Yes, you agree that the Michigan ruled in favor of the traditional accrual method, and you agree with their ruling.
Yes.
Okay. So now, when you go from lines 13, you quote the order about the method proposed by the Attorney General, which is similar, the Michigan Attorney General, which was similar to what the commission, the Maryland Commission, has been doing here since 2007. Is that roughly correct?
I'm sorry, can you ask that question again, please?
Sure. From what I gather, the quote in the order that discusses the attorney, let me do it this way. Did the Attorney General in this generic Michigan generic proceeding argue for the use of a present value approach to the calculation of net salvage in forward depreciation?
They argued for a present value method, not the same as what's in Maryland, and it was not accepted.
Correct. But was it similar to what Maryland does? Or you could say this is, how was it different? Was it different in any significant way?
Yes, it was significant in that it did not include the rate of return as the discounted rate. The rates were utilized there were much closer to an inflation rate. And the individuals that have recommended that don't recommend it anymore. So that's the significance of this type of concept.
Okay, so if we take out the discount factor and we just look at the present value method, is that what the Attorney General was recommending and was rejected by the Michigan Commission?
Well, I think it's more than that, but yes, they were rejecting any present value method in this particular case, which was recommended by the Attorney General.
Okay, so now I want to, rather than reading through this long quote, I want to point to your attention from line 23, starting near the end of the line, that sentence. It says, finally, the commission finds that the Attorney General's proposed method significantly decreases the cash flows available to utilities to meet their infrastructure and other public service obligations. Do you agree with that sentence?
I do agree with that sentence. And in the case here, that's exactly what we're, first of all, cash flows aren't the focus of depreciation, but the fact that the net salvage component as to how much is being accrued versus what's being incurred is the issue, which is the same thing that we have described in that sentence, and that the company is incurring more cost removal than it's accruing. So the concept is the same, but the cash flow aspect of it is not a depreciation related issue. Depreciation is a valuation, or excuse me, a cost allocation, not a valuation analysis. So the statement is a little bit off base in the direct relations to what we're talking about here, but it is correct.
Okay, so for the discount factor, would you say roughly that the company will have greater cash flow if your recommended 2.5% discount factor is used rather than either the credit adjusted risk-free rate or the overall rate of return?
Again, outside of depreciation, I'll answer the question in that depreciation will be higher, rate base will be lower if we continue to move with my analysis using the traditional method. That's the degree that I can, bring out in this discussion is that if you use the traditional method, you have higher expense and lower rate base. If you use a present value method, you will have less expense and a higher rate base.
Okay, so I just want to make sure. So then you're unable, it's beyond your expertise to talk about the relationship of the company's cash flows with regard to if the commission uses the FAS 143 or the present value method, you're unable to talk about the relationship between the various recommended discount factors and how that affects the company's cash flows. That's what I'm hearing. Did I hear it incorrectly? And
That's
please
correct.
correct me. Okay.
You are correct. I can
Very
only
good.
tell you about depreciation expense.
Okay. Now, it also, in that quote, and now I got to get back to it again. I scroll down to something. There's a following sentence that I'm back in the Michigan case,
Yes, I'm there.
and your quote from line 20, it's hard for me to know, 26, which
Yes,
says this, comma, in turn, comma. Are we all there?
I
It's
am.
page 21, starting at line 26. This in turn has a negative financial effect. They're talking about the Attorney General's proposed present value method. This in turn has a negative financial effect on both the utility and its customers by requiring that such obligations be met with more expensive sources of external financing, and by driving up the cost generally of obtaining money in the capital markets. Do you agree with that, or is that also beyond your arena of expertise?
I agree with it in the fact that I know how depreciation expense affects these numbers, and that's the reason why it's included here. And so that's the part of my focus. Obviously, I gave you the entire description there that discusses the concept and what was accepted, but my response is really just related to depreciation expense and how that affects a company.
Okay, can you point me to anything in your testimonies or anybody else's that if the commission applies the present value methodology to the calculated estimation of future net salvage, the company will need to obtain more expensive sources of external financing?
I don't have anything in my testimony that gets to that degree because again, that's outside of depreciation. The part that I'm explaining is that if the company incurs more than it accrues, which is the case if you use the Maryland present value method, which we know is happening at least over the last 8 years, but specifically the last 3 years since it's been applied, that scenario will happen as far as depreciation expense is concerned. And that's the degree that I can answer your question.
Okay. Now, I'm going to go back one sentence in the same quote from line 20. And again, they're talking about the Michigan Attorney General's recommendation of a net present value approach. And that starts at 20. And it says, therefore, it is appropriate to ask current customers to pay for future cost of removal at inflated price levels. And as Mr. Watson pointed out, the rate base offset compensates ratepayers for the prior payment for the cost incurred by the utility. Do you agree with that sentence? Or is that beyond your level of expertise?
No, I agree with that sentence. And again, that's kind of relating to why I keep saying that the amount of incurred cost cannot override the accrued cost because of the fact that you have a growing asset base. And if you are spending more than you are receiving in recovery of that, this is just going to get continually magnified, which is why utilities in Maryland have regulatory assets under these circumstances. So that's exactly what we're seeing here and why I agree with that statement.
Okay, and I just want to focus now. I've read the entire statement, so we get a context. But I'm going to go back to line 21, where the Michigan Commission says customers pay for future cost of removal at inflated price levels. It's appropriate to ask current customers to pay for future cost of removal at inflated price levels. Do you agree? Again, I understand that the rate base offset, but I'm just focusing on the future cost of removal under the traditional approach. I believe this is saying that the customers pay for future cost of removal at inflated price levels. Now, do you agree, understanding that you think it's offset, do you agree with this part of the sentence?
Yes, I agree with the fact that they should pay for inflated levels. That's in all authoritative text. And when you are assessing the service value under the uniform system of accounts, the full service value is what you pay for the asset when you put it into service and what you pay in cost of removal at the time of removal. During that period of time, there is an inflation component, but that is the full service value of the asset, including any inflated scrap value that you may receive. So all of those things are net together to be the full service value and what is expected to be recovered through depreciation. So that particular statement is correct.
Thank you. And would you tell me if you agree with the following sentences? Although depreciation, and it's not in your testimony, although depreciation expense is claimed for both financial and income tax reporting purposes, no actual expenditures are made by a company. Instead, the depreciation expense acts to reduce the income upon which taxes are calculated. Thus, in effect, depreciation creates a cash flow for a company. Do you agree with that?
Again, a little bit outside of the area of depreciation, but I didn't see anything in there that I disagree with, except for the fact that, again, that cash flow has to be, it's not part of depreciation because depreciation is a cost allocator, not something that's described in cash flows. So it's a little bit outside of my area, but the concept, again, we don't necessarily have that here because we have incurred cost removal that's exceeding accrued cost of removal.
Well, I hear what you said, and I'll try asking this question. And it may be out of your expertise.
Well,
And
that,
so
Mr.
please just
Alexander,
tell me.
what I got from his response was the limit of his understanding.
Okay, then
of
I'll
your
go
question.
on. I'll move on, Your Honor. If you go to page 6 of your rebuttal testimony, and I have to do that too. On page 6, lines 4 to 7. You state that the significant issue with the present value method is not isolated to only Potomac Edison, and you say that BGE, Pepco, and Delmarva Power and Light have also been denied the opportunity to recover their net salvage cost over the lives of the related assets due to the use of the Maryland present value method. Did I read that correctly?
You did, yes.
Okay, so based on your assertion, isn't it fair to assume that the bond ratings for these three companies would be negatively impacted by these three companies' inability to recover the lives of the related assets due to the use of the Maryland present value method?
I don't know that answer. I can just tell you that they're all in regulatory asset scenarios, which means they're not getting full recovery. That's the degree that I can answer.
So you don't consider that a negative for them? Or do you do? You consider it a negative for these three companies, but you
I think
don't, but you don't know how it's valued.
Again, based on the proper recovery for depreciation expense under all standards, it is a negative that the company is incurring more than what they are accruing. And that's because of the Maryland present value method. So that's my
Okay.
answer to the best I can give you.
Okay, and I'm just clarifying this, is that you don't know how that flows through either of any of these three companies in their S&P or Moody's credit ratings. And that's what I heard you say, correct?
That's correct. I don't know that.
Okay, then I'm going to move on. Um, Your Honor, based on those answers, I'm skipping through. I'm skipping some questions. All right, if you can go to, stay with your rebuttal testimony and go to page 62, it goes over to 63.
I am there.
Okay. And it starts on line 17 of 62. Hold on, I gotta turn off this phone. Sorry. It says, does the rate base impact of the Maryland present value method proposal result in intergenerational inequity? And you say, yes, future customers will pay the cost of retired assets for which they receive no benefits, but they'll also have to pay a return on a higher rate base due to the fact that previous generations did not pay the full cost of their service. And that's your testimony, correct?
Yes, it is.
Okay, and then now I'm going to point you back in your rebuttal to page 22 at lines 8 to 14. And just tell me when you got there, because the judges told me that I go too quickly.
I am on page 22 of my rebuttal, which is a question.
At lines 8 through 14.
Yes.
And it's a question and answer. When using the PV method, do today's ratepayers pay their fair share of costs in real dollars? And you say, no, I'm not going to go through the rest of it. And that's right. That's what you say, right? They don't pay their fair share of cost in real dollars.
Yes, and I explain my response to that as well.
Yes, I'm sorry. Yes, you do. I'm just, I just want to make sure. Now, you don't have to turn to it, but I'm just going to, for one sentence, one question, return to the account 362 that we discussed previously. You don't need to go to it because I'm just going to ask you a simple question, as a general question, not about any numbers. When does this account end?
I don't understand what the word end is, what that
Well,
means.
okay. So say you have a pole, electric pole that lasts 30 years and it's paid for by ratepayers in some method or another. And the pole, say in 30 years, gets eaten by termites, has to be replaced. So at the end of 30 years, there's a removal cost, correct? In this hypothetical.
For poles, yes, there'd be a removal cost.
Okay, so there is an end to that pole's life, correct?
That singular pole,
Yes.
yes, there's an end of that singular pole's life.
So I would like to know, when poles are in an account, does that account ever end?
We're talking about group depreciation and life characteristics of all of the assets in that category. So mass accounts, which the poles account would be, which is account 364. So it's not 362, but it's account 364. The expectation is that you'll continue having life cycles that are consistent for all these assets. There could be a time when we no longer have poles or need poles, but at this point in time, while the company is operating, the life cycle anticipates that will continue to move forward. So we have a depreciation rate, but the life characteristics, I can tell you for poles, based on my judgment, I anticipate poles ending with reasonable service life at around 102 years.
So is it fair to state that that poles account, unless Potomac Edison goes out of business, which I hope not, I certainly hope not, or say their entire service is undergrounded and they don't need poles anymore, that account will last for 80, 90, 100 years based on your and other experts' estimations of a pole's life that would otherwise, unless the pole is prematurely damaged. Would you say that's correct?
No, I think that there's a possibility that a small percentage of poles, based on all the forces of retirement, could make it to 100 years. However, many poles will be expected to be replaced because of all their forces of retirement well before 100 years. Some will be in age 1, some will be age 2, all the way down to 102 years. But the understanding of the poles account is that we expect replacement of poles due to all the forces of retirement by the time they get to 102, and only a small percentage will make it that far. And if
Okay,
you look at the survivor curve, you can see what I just described.
Okay, so I'm just trying to get this. Let me see if I can just phrase it this way. The account for poles, barring some unforeseen or foreseeable circumstances that are drastic, it's going to go on for a long time. Is that fair?
I think we're going to have poles in place, maybe different than what we have today, but we will have poles in place for a while, yes.
Okay, so hypothetical. Say that I am a 23-year-old Potomac Edison ratepayer. And 10 years later, when I'm 33, I'm still a Potomac Edison customer. And then say that now I'm 43-year-old Potomac Edison ratepayer. won't I keep paying less every year under the present value methodology than under the straight line methodology until either I die or the depreciation account ceases to exist?
You're asking me this question on depreciation expense only, or what the customer actually pays?
I'm asking you about the impact of the straight line. I'm asking about the impact of the present value method of calculating net salvage. And I'll say the question again. I'm 23. I'm a Potomac Edison ratepayer. Then 10 years later, I'm 33. I'm still Potomac Edison ratepayer. And now I'm 43, and I'm still a Potomac Edison customer. Won't I keep paying less every year under the present value methodology than under the straight line methodology from being 23 to 43?
I'd have to calculate where the changeover point in time is for that particular asset class. Obviously, it's not just polls that are a focus. You have to look at all the distribution accounts in this case, but there is a changeover point in time. But again, my point is, in your example, if that person was in service or a customer beyond 43, they would have a tremendous amount more to pay than if they had the traditional approach, because they would have been paying their fair share up through that point in time. So I guess again, and then there's rate cases involved and life characteristics involved. So it's very hard to answer your question. Although it is a hypothetical, I can only tell you that what's left to pay under the present value method will be tremendously more than what there is to be paid under the traditional method. And there's a point in time where that changeover occurs, which my graphs and my testimony show. Each account is different, but that's what's the case going on. So paying less today when you're not paying your fair share to get to the end point is what we're trying to explain. That's not fair and equitable under intergenerational equities.
Well, what I'm trying to get to is that when I'm 23, 33, 43, 53, 63, what I'm paying will all work out to the right number under the present value method, except now under today's dollars, I pay less than the straight line method. They both get you to the cost. Well, let me just stop that for a second. I'm a ratepayer for 50 years, so I'm going to pay more later on, but the me now is going to pay less, and overall, I may be paying the same. Is that correct?
So you've basically said that intergenerational inequity exists because you're paying less when you're 23 than when you're 43 or 53. So it kind of takes away from your the original question, and that yes, you will pay less when you're 23 under the present value, the Maryland present value approach. You won't be paying your fair share, and you'll be paying more at the end of your life. And more importantly, those ratepayers that come in, 20 years down the road are going to have to pay a lot more for assets they didn't get benefit for. So you've kind of walked through the process of why the present value method is not equitable and does not meet the standards of the uniform system of accounts of a systematic and rational method, fair to all customers and all generations.
Well, that's what I'm saying is, who's the generations? It's me through 50 years, and every 10 years, I'm going to get the benefit of the present value method because those accounts are mass accounts. And so if you look at one person, I'm always going to get the benefit of the present value method. And I don't understand why I won't.
If you get to the same endpoint, you're not going to get the benefit. Again, as I mentioned, if depreciation expense is less each year, then rate base is going to be higher. So there's other factors in place as to what the customer will have to pay each year. So you're going to pay more. You're only looking on a depreciation expense side of things. You got more to pay when rate base is higher. Your revenue requirement's going to be higher. And on top of that, again, you're one customer. Now let's talk about the customer that comes in 2030. They're getting the same benefit for that asset, but they have to pay a lot more for that asset because you underpaid for the last 10 years. And so why
Actually-
is that fair?
Well, because they're going to pay the present value too, so they will get the benefit of the present value method because these accounts never end. Would you agree? Let me say it this way. Would you agree that as a general rule, these accounts, as they go on in time, have more plant than less plant as a general rule?
Generally, there is growth. So yes, there is more plant, or at least more plant dollars. So you will continue to, have more to recover. But again, if you recover the full amount of the service value and you're paying less early on, then you're going to have to pay more at the end if you get full recovery. I mean, that's a bottom line. So at some point, there's no straight line, and you are paying a lot more for the same asset, regardless of whether you're adding growth or not. And that's not equitable. And that's what we're trying to say here.
Well, I think this is almost it. I think it is it. Mr. Spanos, you said when you get to the end. That's what I ask you to start this. For our purposes in the next 20, 30, 40 years, where's the end of this polls account? Isn't it true that there is no, for practical purposes, end to the polls account?
Mr. Alexander, you have to develop depreciation expense based on the life cycles of the assets. So in this particular case for polls, there are assets that are existing today that will have an end. There will be more assets added to keep the company going. But again, you can't look at the fact that there's no end. So that means we never have to get full recovery of our investment, which is what you're basically saying. We are trying to get full recovery of your investment, whether it grows or not. If you continue to pay less now, you're going to have to pay more later. And that's what FAS 143 and particularly the Maryland present values method version of this requires a tremendous amount paid at the latter stages of the asset class than at the early stages. And just because you don't expect the account to end, the life cycle of existing assets will end. And that's the part that you end up asking future ratepayers to pay a lot more for than what current ratepayers are paying.
So again, you're saying that the present value method will have present ratepayers paying less and sticking later generations of ratepayers with more. But isn't it also true that if you use the straight line method, because the asset account will never end and it's growing, then you will have every generation paying more than they would in the present value method because the account is going to go more. They're paying more now, as we discussed under the straight line. And there's nothing I see that would mean that in 20 years with an asset account that doesn't end, they're going to pay less. And I'm gathering you disagree with that. Is that right?
I do agree with what you have portrayed with the straight line method. Obviously, the straight line method's being accepted by all other jurisdictions to understand the concept that we're trying to explain. And if you're trying to isolate specific assets with who pays what when, the straight line method is the fair approach to make sure everyone pays their fair share during the life cycle of the existing assets. And yes, you will have new assets to come in that start a new life cycle, and this is a revolving door process, but the aspects of recovery and again, isolation at each point in time, which is what you're trying to do, that isolation will ensure that you will pay more under the present value approach in the long run, and you will pay more specifically in each period of time, and new generations for the existing assets will pay more than the current generations will pay. All of that is intergenerational inequity, and why FAS 143, and particularly the Maryland present value method for recovery under these types of criteria does not work, and why you're getting regulatory assets by the electric companies in this state. And that's what I can tell you. That's the example that shows it's not being fairly recovered. And I don't know how else to explain that to you. And your example is not fitting what a mass property account and the recovery pattern of those pieces are. So that's kind of my direction to the response to your question.
Your Honor, Mr. Spanos, thank you for your patience. Your Honor, thank you for your patience. That's the end of my cross-examination.
Thank you. Mr. Dean,
Thank you.
do you have any cross-examination for this witness?
Briefly, Your Honor, about 20 minutes, maybe. Mr. Spanos, turning to your direct testimony on page 22. At line 18, you have a recommendation for new plant for depreciation rates for electric storage battery and EV charging stations.
Yes, I do.
Could you tell me what that's based on?
The parameters that for each of those accounts is listed there on lines 22, where we have a 15L3 and 0% net salvage for the battery storage account. And then for the charging stations, we have a 10 S3 survivor curve with 0% net salvage for those assets as well. And that's based on understanding of the new assets that will be placed in service and their expected life characteristics.
And you're not expecting any salvage or cost of removal for these?
Right now, the net component that we anticipate for these new assets is 0%, which was stated on lines 22 and 23. So any cost of removal that might be incurred right now, we are assuming will be offset with any scrap value. So for both areas, that's the expectation with these assets currently.
Thank you. Turning to your rebuttal testimony on page 8 at line 19.
I'm sorry, what line, sir?
19.
Okay, thank you.
It says the company's current depreciation rates based on the Maryland present value method have resulted in recovering less in net salvage over the last 2 years than the company has incurred. What exactly do you mean by that? Because I don't believe you're currently using the Maryland present value method.
Well, the Maryland present value method was part of phase 1. So the calculations that we incorporated to explain this would be if you are using the Maryland present value method that was discussed in phase 1, you would not you would not accrue as much as you would incur over the last couple of years. And that's what the explanation that we have in bullet point 1 there.
All right, thank you. At page 55,
On page 50, of my rebuttal, I'm assuming we're still on.
yes.
Okay.
Here you discuss the 2.5% inflation as used as the discount rate.
That's part of the discussion in this section, yes.
And you state that you calculated the depreciation rates and expenses in Exhibit JJS-7R.
Yes, under the Maryland present value method using a 2.5% rate of inflation, but as the discount rate. That's correct.
Turning to that exhibit,
Just to be clear, is that should be exhibit attachment E, is that correct?
I've got it as Exhibit JJS-7R.
Yes, that it was referenced a couple ways in the attach, but yes, that's the 2.5% discount rate using the Maryland present value method. Is that correct?
Yes.
Yes, I have that.
Okay, and just because of the fine print on this page, I'm going to read the values and just make sure that you agree with them. For miscellaneous intangible plant, you have an expense of 2.7 million and 12.35% as the rate.
That's correct.
And distribution plant is 26.8 million and 2.32 million as the rate.
That is correct.
And general plant, $2.5 million and 4.21 as the rate. And then
For the
lastly,
individual accounts, yes.
lastly, as the total overall, you have $32.5 million and 2.64% as the rate.
That's correct. The only thing that you left out was the reserve for general plan amortization of 524,000, which is at the bottom there. That is built into the total, which gets you to the 32.6 million and 2.64. So just making sure that that's clear, that that's included in that number.
Thank you for that correction or clarification. Turning to page 4 of your testimony,
I'm sorry, direct or rebuttal?
rebuttal.
Okay. I'm on page 4.
At table 1 here, would these rates from that former exhibit, would these be comparable to the expenses and rates that you have here if the Maryland present value method with a 2.5% discount rate was used?
I'm sorry, which rates are you referring to?
The ones on table 1?
So there are 4 categories in there. There's current expense and rates. There's Potomac Edison expense and rate. There's staff expense and rate and OPC expense and rate. So I wasn't sure which you were focusing on.
for all of them together, if you took the values that we just went over from the from that exhibit, is there anything that would prevent comparing the values for intangible distribution, general plant, and the total plant for expenses and rates? Is there any reason why you cannot use those as another example in direct comparison with the rates and expenses listed here?
They are slightly different. First, we don't include the that general plant piece that we just discussed. The current estimates relate to the approved life characteristics, so that's slightly different than what we have in the Potomac category. And the Potomac category incorporates what our parameters are in place now. So those are slight differences. For staff and OPCs, those reflect the discounted rates that they incorporated. So they're roughly comparable numbers, but in my testimony, I kind of explain what each one means. So hopefully it's not an exact comparison to the exhibit we just went over.
Oh, thank you. Turning to page 42 of your rebuttal testimony.
Yes, I'm there.
At line 13, you list various steps to be used in implementing the Maryland present value method, as you call it.
Yes, there are additional variables, but yes.
When you created that table for exhibit JJS-7R, did you undertake any of these steps?
Yes, determining the historical net salvage percents to estimate future net salvage. That is part of what we would do in a standard traditional method, as well as the method that you would use. Again, one of the key elements here is the net salvage percents that we have established are less than what the historical data is showing. Then determining the average age of retirements, that is done so that you can compare whether the historical retirements are less than or more than the average, so you know what's going to happen going forward. Then steps 3, 4, and 5 are only required if you do a present value method, not required if you do the traditional method, and that's determining the discount rate to use. Again, I state that it should be based on inflation and not rate of return. Then using the net salvage estimates, average age of retirements, all that is the tables that are part of the development of the discount rates, which again, would be additive only to this particular analysis and would require changing every year. And then recalculating each year to account for each year's inflation and changes to the age of assets. Again, that has been done, but that would need to be updated each year if you continue to use the present value method and for Maryland. It's not required on the traditional method. So steps 3, 4, and 5 are additive, but have been done in the table you're describing.
Thank you. I believe in response to a Office of People's Counsel question, you recommended that depreciation rates be performed every 3 to 5 years. Is that correct?
Yeah, as I mentioned, I think that's the most reasonable expectation for reviewing depreciation parameters, meaning the life and salvage parameters. So that to me is what's most realistic. I wouldn't say that that's not the case if you're doing the present value method. I think a more you most appropriately should do it every year. But For doing depreciation studies and understanding life and salvage characteristics, I think a 3 to 5 year cycle is the most reasonable and most commonly used in the industry.
Thank you. If a company went much longer, say 10, 12, or 15 years without doing a study, could you discuss what might happen as a result of such a delay?
Well, there's a lot of things that may happen. Let me just kind of hit on some of the key things. Obviously, the life characteristics of an asset category may be different. I don't foresee that being a huge change in some of the accounts like mains, or excuse me, polls, which is the main account, or the biggest account, or conductor even. However, I do think station equipment, not doing studies as often, you could see variability in your life characteristics. The net salvage, I think, is one area that changes by not looking at these things on a more regular basis, because the cost of removal have continued to increase in the industry based on requirements to be done. So I think it's an account by account basis as to what may happen to the depreciation expense and or rate, depending on if you go too long of a period of time. So obviously, which is why we're looking at these now, is because it's needed to be looked at. It was part of phase one's requirements. So we are reviewing that, but you could have more variability in the depreciation expense and or rates than if you're looking at it on a more regular basis, but every account's different. So it's hard to give you a more defined answer than that.
Did you discover any of these factors present for any of the accounts when you performed your study for Potomac Edison?
Yes, there was considerable changes since 1993. So one of the things that, again, that practices in place are different. The types of assets are different, some lasting longer, some not as long. So we do have a mix. I would see that in any study. We just may have seen in some accounts a bigger change than what we would have seen if we had done things more regular. I think the net salvage component is has changed quite a bit over time. That's all within the industry. So we would have seen this in the last couple of years. But again, my estimates are less negative than what the statistics are showing, to try to make sure that we take into consideration the fact that we haven't viewed all of these parameters in a while, and to estimate the net salvage as high as the statistics would show would not be appropriate. So that's why we have recommended less negative salvage than what statistics show we should be charging.
Thank you for that. Turning to page 20 through 22 of your rebuttal testimony.
Yes, I'm on page 20 at this point.
Just paraphrasing your statements here. I think you state here that the reason that the Commission adopted the SFAS 143 or Maryland Present Value Method was concerns over present customers overpaying for salvage due to future inflation. I think that's what you're saying here.
I think that's a general paraphrasing of the topic. There's probably a little more to it, but I think that's fair.
In your opinion, was the Commission's concern in this any way justified?
I think in my opinion, it wasn't necessarily justified by using the discount rate that was selected. I don't think they had all the information in front of them to make a quality response. And we have shown again, in my testimony and in cases that it didn't work. And
That
which is
wasn't
why,
the question, Mr. Spanos. The question was whether the commission's concern about ratepayers only paying their fair share in real dollars, was that a valid concern? That was the question. Right, Mr. Dean? Mr. Dean, are you still with us?
Thank you, Your Honor.
Was the commission's concern at all justified? That's the question.
Yes, can you hear me?
Now, you're
I
kind
can
of,
hear you again. Yeah, you're going
Yeah.
in and out. Yeah. So I think I answered the initial part of the question is, I don't necessarily, sorry, go ahead.
you don't necessarily what?
I don't necessarily feel as though with the information that was available to them at that time, that they were justified in making that decision.
That wasn't the question. It wasn't whether their decision was justified. It was whether their concern was justified. Do you understand the difference?
Kind of. I think it's kind of hard to answer whether their concern was justified when it's really not an appropriate method. So I think looking at it was definitely, looking at it was justified, but the result, I would say, was not. So if that answers the question more accurately, hopefully.
Mr. Dean, are you still with us? Okay. At this point, I think we're going to move on to my questions. And then maybe Mr.
Yes, I've
Oh, you're-
turned off my video in an effort to help.
Okay. Do you have a lot more questions? Okay. Mr. Dean, even turning off your video isn't solving I think the bandwidth issue you're experiencing. So I'm going to ask my questions.
Just
and if
one more.
Oh, okay.
I just had one more question, if that's all right.
Yeah, if you can get that on the record.
Do you agree with the statement that customers eventually pay for all depreciation? Your Honor, I think you may be experiencing a time delay for some reason.
I wasn't able to hear your full
Mr.
question.
Spanos, do you
Yes.
agree with the statement? Do you agree with the statement that customers eventually pay for all depreciation costs and costs of removal incurred by a utility?
Are you asking that under the present value method, or are you asking that under the traditional method?
You could answer both ways if you wish.
I do think under the traditional method, customers pay for the full service value of their assets. It's the current present value method in Maryland. You should, if you continue to reevaluate this on a more regular basis, you should get to that point, but it won't be straight line.
Thank you. Your Honor, I have no further questions.
Okay, thank you. Mr. Spanos, you started off with rejoinder with regard to Mr. Guerin's rebuttal testimony and table 1. At the bottom of that table, we have a 5-year average, 2015 to 2019, and then we have a total average of 2001 to 2019. Wouldn't both of those averages take care of the change that you were making note of between 2012 and 2013 related to whatever it's related to, but don't the averaging out of all of these numbers take care of that?
I'm sorry, I'm going to go to that table just to make sure.
Sure. It's page 4 of Mr. Guerin's rebuttal.
Oh, that's right. Sorry, I was going to my rebuttal.
We had a lot of discussion about those numbers, not
Yeah.
all of which I believe was relevant. But my point is, if you take an average of those numbers, don't you take care of the issue of the fact that there was an underreporting apparently in 2012, and then you had to catch up in 2013?
You will definitely pick up on that in the overall average, because it takes away a little bit with the way the table is put together, but it will cover the fact that all net salvage is recorded during that 20-year period. I think the key point is what's been the most recent time period and how that compares to what is being accrued. And that was really my point, that retirements have gone up considerably in the last 7 years as compared to prior to that point in time. So too
But
much
that would be taken
averaging is
care of in the 5-year average of 2015 to 2019, correct?
you are correct that it is taken care of in the overall in the most recent 5-year average, which is again the starting point for what's been incurred, and that's what that is. It's not necessarily reflecting what's been accrued.
And you stated several times that future customers will pay more under the SFAS 143 method. Is that because, as you say, other utilities in Maryland are having to establish regulatory assets, and eventually those regulatory assets will need to be paid?
That is part of it. I think the key element that I was trying to express there is that when depreciation expense is lower, then rate base is higher.
No, I understand that.
Yeah. Okay.
My
That was
question simply goes to,
Good.
you, I think, either intentionally or unintentionally missed Mr. Alexander's point. He's trying to get you to acknowledge or agree even that if you continue to use the present value method, as you call it, the SFAS 143 method, if you continue to use that, then there is no crossover. There is no point at which future customers pay more because you continue to use that method. You didn't agree with where he was going, and that's fine, or you wouldn't answer his questions to get to where he wanted you to go. But you kept saying that future customers will pay more. And my question to you is, because of the present value method or the SFAS 143 method, I understand about rate base. I'm talking about, you also mentioned that utilities are having to establish regulatory assets because they're not accruing net salvage to the degree to which they are incurring it, right?
That's correct.
So will future customers pay more because those regulatory assets will need to be paid by those customers?
The answer to that question is yes. And the reason why you won't get to that full recovery, again, that comment was related to the existing assets. You're continually having additional assets being added in, which is why the discussion I was having with Mr. Alexander was not as straightforward as he had hoped. But for the existing assets, there will be a crossover time, and ratepayers will have to pay more for those specific assets. And it's very hard to isolate specific assets to answer his question when you do have a perpetual asset class that's going on.
No, I understand it was difficult to
Okay.
answer his question because of that. But what I'm trying to decide is, or trying to determine, is whether future customers actually pay more. How do they pay more? Do they pay more because they're paying off that regulatory asset?
That is part of it, but they also have a higher rate base over time. And then that increases your revenue requirement, which requires you to pay more because of that.
Okay, but otherwise, other than the rate base portion of it, it would be paying off the regulatory asset.
Those are the key components, yes.
Okay. All right, we talked about your testimony to the extent that the SFAS 143 method requires use of a credit-adjusted risk-free rate as the discount rate. Do you know what a credit-adjusted risk-free rate is?
I believe so. I mean, it's the concept is definitely clear to me.
Well, you testified what a risk-free rate was, and you agreed with Mr. Alexander that it's generally tied to the T-bill rate, right?
That's correct.
So do you know what a credit adjusted risk-free, how does that risk-free rate, generally based on Treasury bill rate, how has that become a credit adjusted risk-free rate?
Well, normally it includes what the cost would be to get, for example, additional funds. So that's kind of how it's built in. But again, we're talking about things outside of depreciation expense. So how those numbers are determined.
Well, I'm trying to stick to your testimony the best I can. You also testified that changes in the discount rate can have a dramatic impact on the resulting depreciation expenses, correct?
That's correct. And I show the differences in the tables and how those, if you're discounting something at a 7.15 versus discounting it at a 2.5, you get much different annual recovery. And overall, you'll get more to be recovered using the 7.15% in total. And that's what my tables show later on in my rebuttal.
Much more, right?
And much more. That's correct.
So would you say that it is very important to get the discount rate correct?
It is very important to get an appropriate discount rate. Again, it's
I know you
hard for
don't,
me
I
to.
know you don't agree with the
Yeah, I
method,
know.
but you need to try and
Right.
answer the questions.
Yes.
Your exhibit JJS-7R that I believe Mr. Dean was just asking about sets forth depreciation rates and expense using 2.5% which is based on a rate of inflation as the discount rate, correct?
Yes, that is correct.
Is it also correct that you didn't calculate depreciation rates using a credit adjusted risk-free rate as the discount rate?
I did not in my study. I just did as part of this response, I did a 2.5%.
Okay, so if it's important to use the appropriate discount rate, which you testified to, and if it is under the SFAS 143 method, a requirement to use a credit adjusted risk-free rate, why didn't you use a credit adjusted risk-free rate as the discount rate in your analysis?
Well, the credit adjusted risk-free rate that the company has expressed to me to be the most reasonable. Again, and Mr. Valdez could kind of talk about this in his testimony, was for asset retirement obligations, they are using 2.5% in their most recent plan. So that's why 2.5 was what we continue to use here, because it's one, for FAS 143 methodology, inflation is what was intended, and two, because what the company views to be the most reasonable. I think that it's actually a little bit lower for them. So
Are you
that's why we did
testifying
that.
that 2.5% is the company's credit adjusted risk-free rate?
It's what they're using for asset retirement obligations, and
Where is that
that's
in your testimony?
it's not in my testimony. It's been,
It's just been told to you.
yes.
And
that's why I
you
said,
think you said Mr. Valdez is going to testify to that?
he can explain what the most common percentages have been that would relate to this, that help support why I felt 2.5% as an inflation rate is consistent with what would be used for asset retirement obligations, which is the intent of FAS 143.
All right, no, I understand your
methodology.
testimony. I just want to make sure the record is clear that your testimony is not that you used 2.5% as the discount rate because you believed that was the credit adjusted risk-free rate for the company.
I'm using 2.5% because I feel it's in the inflation percentage, that rate that's appropriate. And again, it's justified because of what the company has for their asset retirement obligations, which is what FAS 143 is related to. That's the basis for it.
Okay, turning to page 63 of your rebuttal testimony at the very bottom, you testified that the company's current estimates are not based on Potomac Edison's actual plant data, correct?
Sorry, I want to get to
Sure.
the context.
Yeah, but it's pretty basic. You've talked about it before, that the company's current estimates are based on, they're not based on Potomac Edison's actual plant data because that plant data wasn't available in phase one of this case. It was 25 years old. And so the best alternative that was offered to the commission was to use Mon Power as a proxy, correct?
That's correct. And I see you're talking about the life parameters in our discussion here, and that is correct, that the life parameters were determined based on Mon Power, which has obviously as very similar assets and similar life characteristics because their lines are tied together.
Right, but then you make comparisons between the company's current estimates and what you're proposing in this case, correct?
That's correct. And some of the things that Mr. Guerin had done when he worked on the comparable data that he had, because he did a analysis on this back in phase one, and he's coming up with very different estimates, even though there's only 2 years difference in data. So he
Yeah, but
initially
wasn't he
looked at the data.
using 25-year-old data because that's all the company offered in phase one?
No, I believe he used the updated data through 2017 to come up with his estimates. But I did not do a study then. I came in afterwards when he did his review.
So would he have good information if you hadn't provided that information? Aren't the witnesses in this case taking your analysis and using that as a starting point and going from there?
They are now in this phase. They weren't in phase one because I wasn't involved in the beginning part of phase one. I came in the rebuttal stage, so I didn't do a study on the data through 2017.
You criticize Mr. Guerin's service life estimates because in some cases they are as large or larger than 20 years, different from the current estimates, correct?
That's correct.
But again, the current estimates are not based on Potomac Edison's actual plant, correct?
That's correct. And that aspect of it.
And they themselves are how old? Using Mon Power as a proxy, they're already
They were 6 years old. 7, I think. I'm sorry, 7 years old. They were as of 2000 and well, it's 6 years from the test year date, it was 2013, and the test year date is 2019. So it's a 6-year difference as far as the data that was worked on in the Mon Power study and what's being done in this 2019 case.
So outside your 3 to 5
Yeah, but again,
desired year.
Yes, it is outside of that. In 2017, it was still within that range, but not now.
Okay. And then at page on 65, you have a table 6, and you include in your table staff's proposed curves. Is it your testimony that staff proposed survivor curves in this case?
No, based on their work, I'm saying that they're agreeing with what mine are, and so because they do have comparable parameters that they're using, I'm saying that staff used the same parameters I did. So maybe the word proposed may not be as accurate, but they are consistent with what I have proposed.
Your testimony starting at line 8, you say the over-reliance on mathematical fitting results would be the only explanation for significant changes in life estimates by Mr. Guerin in such a short time period. Is that really your testimony?
Yes, I mean he had, for example, he estimates for account 365, he estimates a 76 R0.5 now, but in 2 years ago with the same data, except 2 years less, he offered an 8201. So that's a 6-year difference in estimation on just 2 years more worth of data. So that's very unusual unless you're just matching
Okay, and again,
points.
it's your testimony he had all of the data from 2017 that he would have needed.
Yes.
Okay. Turning to account 362, station equipment, which you talk about starting on page 70 of your testimony. At the bottom of page 70, starting on line 11, you state, for this account, the data points I have emphasized are those which have more than 500,000 in investment. These are also most of the data points for which exposures are greater than 1%. What do you mean by most?
Again, and this is where we were going with Mr. Alexander. Once you get beyond $500,000 of investment on an age basis, you're at age 74, or excuse me, 64 and a half. So that's where I'm representing when we're talking about all the data points that I've shown on the curve represent investment up through that point in time. So I'm taking $106 million and it goes down. And when you get to age 64 and a half, then you have investment that's $500,000 or less. And those are not presented on the curve. And that's what I'm trying to explain here, which was why we were going back and forth, is making sure we understand that, and that
No,
we
I
use it.
understand that. I'm kind of homing in on the word most. Is it all or is it most? And why is it just most? And what's most mean?
Well, the actual at 64 and a half is 467,000 versus the 500,000. So I rounded. So again, the most is just related to the data points that I'm presenting on the curve.
And the older data points are less relevant for this account.
Yes, I view them to be less relevant as far as determining a life characteristic of station equipment going forward with what exists today. It's not being ignored. It's just not considered to be a driver for the life characteristics of new assets and what we have in service today.
So in your figure 3, when you compare the companies and OPCs, because it's not staffs, it's the companies and OPCs proposed survivor curves for account 362. Not to oversimplify things, but isn't the point of fitting a curve to the data to arrive at an appropriate average service life?
It is. But again, for determining life characteristics, you're not trying to fit the data. You're trying to develop the appropriate estimate of the assets you have. So
To get to an average service life, correct?
an average service life and dispersion pattern, which is the curve. So in this case, a 65 R2.5 is the best representation of the life characteristics of station equipment, which relate to circuit breakers, transformers, electronic
What
equipment,
comes out of the
etc.
curve? What do you take out of this curve?
There's an average life of 65 with a dispersion pattern of an R2.5. So that means we expect the mode to be just to the right of 65, and the fact that we expect retirements to increase as they age once we get to age 60. And again, we're trying to reflect what's reasonable for the types of assets in here. There isn't anything in this account that we're going to expect to continually last beyond 65 years. So we need to start depreciating those assets that are too old. Just the nature of the asset class, and to assume based on Mr. Garrett's estimate that station equipment is going to last 145 years is not reasonable.
All right, the next account was account 364, poles, towers, and fixtures. Can you explain, again, you're criticizing, I guess, the increase from the current average service life. You say it's not in line with the concept of gradualism when it comes to depreciation parameter estimates. Can you explain gradualism when it comes to depreciation parameter estimates?
Sure. If you have a change in your account recovery pattern, where let's say your assets were going along at a 50-year life period of time, and then the statistics say, okay, we haven't had retirement, so now we think the estimate should be 60 years, even though we've only gone 2 or 3 years. Well, there's a degree of what I call gradualism that says, well, we know there's a 10-year statistical impact, but that's not reasonable expectation for these life characteristics. And they should not, when you take into your full judgment, slowing down that impact from one period to the next is important when you're really focusing on what the estimates relate to. And again, we're dealing with assets that were initially reviewed in 93, then Mr. Garrett looked at them again in 17, and to create some type of major change in the life expectancy, not only from what we had in 93, but even what we have now in 17 or 19, doesn't make sense to go to the extremes. And we particularly when we know that assets are going to be replaced at a more rapid pace going forward, which is what we've seen over the last 7 years. So you don't want to go just hitting the statistical points, and you have to take into consideration judgment. And that's what we're focusing on when we say gradualism, is you want to make sure, and what we're doing with net salvage is not go to the extremes. And that's what we're trying to emphasize here.
But does the change in depreciation rates from what's presently being used, even if the change is what you would consider to be too much of a change, does that have any impact on the ratepayer? Any direct impact?
Well, if you go to lives that are much longer, then obviously the recovery patterns would be inconsistent with how the assets are going to be utilized. So it does have an impact on ratepayers, because now they'll be paying a lot less because you're spreading it out over a longer period of time. And that doesn't necessarily make sense to go to an extreme like that, when you can slowly move it in that direction to smooth out the process and, again, make sure rate base is aligned properly.
If the ratepayers should be paying less, you think it should be smoothed out so they don't get the benefit of paying less until later?
No, I don't think the ratepayer should be paying less in a sense that we're describing here. I feel that the life characteristics should be most reasonable with what we expect, and not making extreme changes based on statistical analysis, and why with Mr. Garen's estimates are moving to unrealistic statistical life characteristics that would not be appropriate going forward. And that's the concept that I'm trying to do. And what we do have a slightly unusual circumstance, is that the parameters in place right now based on phase one are not based on the life characteristics of these particular assets, but we know that those life characteristics are much better than the ones being recommended by Mr. Garen. And that's why we're taking a little bit different approach to getting to the right life estimate and the recovery pattern consistent with that. So we're trying to do what's fair to the recovery patterns, not only of what's happened in the past, but also what's going to go forward for each of these asset classes. And these particular three categories, the estimates are outside the norm of what we would expect. So doing a major change like this would not make sense, and that would be unfair to future ratepayers as much as the benefit that current ratepayers would get.
Well, which is it? Is it the change is the problem, or what we're changing to is the problem?
Both. I'm not sure how you do a distinction. I mean, obviously, the estimates
If you're
that are being
changing, can you change to that same degree but get to the correct place? If you agreed with where he ended up, would the change itself bother you?
I definitely look to do what's most appropriate. And so, to me, the change to what he has is inappropriate.
I
And
understand that you
the
disagree with where he ended up, but if you
yeah.
agreed with where he ended up, would you consider the degree of change? Are your estimates based on what you believe the data shows, or are they tempered by what you think should be a smaller change?
I don't look at impacts of expense in my decision making. I look at what's the most appropriate life characteristic. So if I'm not affected by impact, I don't um, look at an assignment and say, okay, I only want to have change by X. That doesn't fit into I'm trying to determine what's the most appropriate life characteristics and net salvage, and how that should be recovered based on those parameters. So I
if
don't care.
If Mr. Garen had come up with the most appropriate parameters, it wouldn't matter the degree to which that was a change from existing, would it?
If his parameters that he came up with were consistent with what I felt to be the most appropriate, then I would not have an issue there. But when you then top it on,
I think we've got it. You start talking about at line 5, the ranges of estimates.
Page 66. I'm sorry.
Oh, no, we're on page 73.
Okay.
We've been on 73, but
sorry.
that's okay. starting on line 5, you reference, well, I guess line 6, the range of estimates in the industry that are typically used for distribution poles.
Yes.
Did you, the range of estimates in the industry? Are we talking about BGE? Are we talking about Pepco?
I'm talking about all utility companies in the US. The general range is 45 to 65 years for these types of poles.
Did you review the average service life of distribution poles for BGE or Pepco?
I don't have those right in front of me, no.
Did you review them? Can you try to answer the question asked? I asked if you reviewed them. I didn't ask if you had them in front of you.
They are part of my industry statistics. I don't know exactly which ones BGE and Pepco are.
Your industry-wide across the country. They're part of that, you're saying?
Yes, they are.
Okay. So on page 74, at lines 2 to 4, now we're talking about different plant, but you talk about the exposures are greater than 1% of the largest exposure, which are also those based on more than 1 million in investment. So before you were, your cutoff of dollars was 500,000, but for overhead conductors and devices, that was for overhead conductors and devices, you used 500,000. But for poles, towers, and fixtures, now your cutoff is 1 million. Can you explain why the difference?
Yeah, total exposures are much higher. So both of them at 1% of the total exposures of that specific account. So because there's more dollars that were exposed in the poles category, that's why you have a higher threshold than what you might have in, sorry, the 1 million's for overhead conductor. So there's more exposures to overhead conductor from the beginning point in time to where we cut things off. So it's the 1% threshold from total exposures is the key element.
Okay. And so again, the typical industry range for this account, you're stating at lines 9 to 10, is 45 to 65 years. Did you attach to your testimony any backup for that assertion?
It's not in my testimony. I believe it was part of a data request that I responded to given the industry statistics, but I did not include it in my testimony.
So it's not in the record in this case, correct?
I don't believe so, and I don't remember if it was in the record at the time in phase 1, but
Okay. Mr. Gunderson, any questions based on my questions? Or any
No,
redirect?
Your Honor.
Okay. All right. I assume also the same for you, Mr. Alexander. Limited time opportunity, Mr. Alexander.
No, and you're right, Your Honor. I don't have any questions.
Thank you. And Mr. Dean, if you're with us.
No questions, Your Honor.
Okay, this witness can be excused, and I also think it makes sense to take a break at this point, and we will come back at, can we come back at 1:45 with Mr. Valdez? Okay, see everyone at 1:45. We are in recess.
Thank you.
thank you. Bye now.
Off the record, Your Honor.
Thank you.
Hey, Your Honor, just wanted to test my mic if it's working.
Yes, it seems to be.
All right, thank you. Go back on mute.
Mr. Court Reporter, are you ready whenever we are?
Anytime you say, Your Honor.
Okay, thank you. Mr. Alexander and Mr. Dean, are you ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Okay, I'm going to resume the recording now. We've been live streaming, so we are still live streaming. We are back on the record in case number 9490, Phase 2, the Potomac Edison Company depreciation matter.
You're on
And I
the record,
believe,
Your Honor.
thank you. Sorry, I forgot to say that. We're on the record in case number 9490, Phase 2, the Potomac Edison Company depreciation matter. And we are up to the company's second witness.
Yes, Your Honor. For the record, Joseph Curran on behalf of the Potomac Edison Company. And at this time, we would like to call to the witness stand Mr. Raymond E. Valdez.
Mr. Valdez, can you please raise your right hand? Do you swear or affirm under penalties of perjury that testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Proceed.
Thank you, Your Honor. Mr. Valdez, let me ask you, do you have a document before you that is entitled The Direct Testimony of Raymond E. Valdez, consisting of 5 pages and no exhibits?
Yes, I do.
Your Honor, at this time, we would like that document marked as PE Phase 2 Exhibit 3.
So marked.
And sir, you also have before you a document entitled The Rebuttal Testimony of Raymond E. Valdez, which consists of 9 pages and no exhibits.
Yes, I do.
And Your Honor, we would like the rebuttal testimony marked as PE Phase 2 Exhibit 4.
So marked.
Mr. Valdez, were these testimonies prepared by you or under your supervision, sir?
Yes.
And do you have any corrections, additions, or deletions to these testimonies?
No.
If I were to ask you the same questions today that are contained in your direct and rebuttal testimony, would your answers be the same?
Yes, they would.
And are these testimonies true and correct to your best of your information, knowledge, and belief?
Yes.
Your Honor, at this time, we would respectfully move that PE Phase 2 Exhibits 3 and 4 be moved into evidence.
Any objections?
No objection, Your Honor.
None here either, Your Honor.
With no objection, PE Exhibits 3 and 4 entered into the record.
And Your Honor, we have some very brief, limited rejoinder. I'm sorry, could you hear me?
No, are you and Mr. Gunderson in the same room?
We are.
Okay. I was attempting to mute. There's a little bit of an echo, and I apologize. I was trying to get rid of that, but when I muted him, it turned out to mute you. So if you could go back.
Okay. I'll try to turn down my volume. Is that helpful?
Yes.
Great. Your Honor, I was saying we have some very limited live rejoinder that we would like to ask Mr. Valdez based on the serve rebuttal testimony that was filed in this matter.
Whose?
The first one would be in response to Staff Witness McCullough's serve rebuttal.
Okay, proceed.
Mr. Valdez, do you have before you Mr. McCullough's, the Staff Witness McCullough's serve rebuttal testimony?
Yes.
And if you would be so kind, can you turn to pages 2 and 3 of the serve rebuttal?
Okay.
Let me know when you're there.
I am there.
Okay. And this is the section of Mr. McCullough's testimony where he is referencing your discussion of the PEPCO case 9385 in terms of the company's recommendation for the effective date of any adjustments to rates as a result of this proceeding. Do you see where he references the PEPCO matter?
Yes.
And do you have any response to Mr. McCullough's recommendation there?
Yes, Mr. McCullough tries to draw a distinction between PEPCO's standalone petition to change its depreciation rates, which were ultimately deemed appropriate to wait until the next base rate case to adjust such rates, as compared to Potomac Edison's September 2020 petition, which was a phase 2 of the last distribution rate case, instead of being a standalone petition. And I believe that is simply a matter of semantics, since Potomac Edison's September 2020 filing was still a standalone petition, regardless of whether or not it would be considered phase 2. And more importantly, it does not address the point that, consistent with distribution-based rate making, Potomac Edison proposes to put any depreciation rate changes approved by the commission into effect at the time distribution-based rate changes are made in its upcoming base rate case.
Thank you, Mr. Valdez. Let me ask you, do you have a copy of Staff Witness Patterson's serve rebuttal in front of you as well?
Yes, I do.
And with Staff Witness Patterson's serve rebuttal, I'd like to refer you to page 5 of his testimony and let us know when you get there.
I am there.
And specifically on page 5, starting around line 21 and carrying over to page 6, Mr. Patterson discusses the company's most recent credit-adjusted risk-free rate as being 4.54% for the Pennsylvania Electric Company. Do you see where he states that in his serve rebuttal testimony, sir?
Yes, I do.
And that was about 2 years ago. Is there any more recent any more recent risk-free credit for First Energy or Potomac Edison?
Yes, First Energy's most
Excuse me, this isn't responding to his testimony. This is providing additional direct testimony. You have to unmute yourself.
Yes, Your Honor, I was going to object, and also because nothing's in evidence about this in anybody's testimony, I think. The only thing we got was the sister company from 2 years ago, I think. So this is new.
Your Honor, if I may, this is responding to his serve rebuttal in which Mr. Patterson is saying that the most recent credit-adjusted risk-free rate for Potomac for First Energy is 4.54. Mr. Valdez has an opportunity through live rejoinder to respond to the last piece of testimony that was in by Mr. Patterson on serve rebuttal.
Are you saying that his response to staff data request to phase 2 4.4 is inaccurate and he'd like to change that response?
He's about to say that there isn't a more recent credit adjusted risk-free rate.
So he is changing his response to this data request.
This was also provided in discovery as well, this response.
Do you have it somewhere?
Yes, it's been provided in discovery. It is the company's response. I will locate that, Your Honor. It is a response that was provided to staff on March 11th. It's the company's response, staff phase 2, 4.3.
Do I have that?
We can provide it to you as a data response. He was about to provide that number through live rejoinder.
Well, my reading of 4.4 is what you're about to provide would directly conflict with it, so I'd like to see it, yes.
Okay.
Can you email it to me?
We can do that, yes.
All right, just a second.
Your Honor, this is Mike Dean. I believe if I'm looking at the list of exhibits correctly, PE exhibit number 21 is the response or staff DR 4-3.
Okay, then I do have it. Let me take a look at that. Thank you.
Okay, thank you. Thank you, Mr. Dean.
Although I don't believe it helps my cause.
Okay.
Your Honor,
Uh,
I still
yes.
want to, I'm sorry, I still want to raise my objection because the company is trying to introduce its own response to a data request that will modify Mr. Valdez's pre-filed testimonies. And so they're introducing new evidence in this case through their own DR. And even though it wasn't presented by Mr. Valdez.
Well, you said modify, and then you say wasn't presented. I was going to ask you to point to me where in Mr. Valdez's testimony it was presented that he's modifying. But then you said it's not there. So do you know which is?
I'm sorry, I misstated, Your Honor. It's not there.
Okay. So what he's trying to do is respond to Mr. Patterson's testimony, which referred to a data response. Mr. Curran, could you ask your question again?
Yes, Your Honor. Mr. Valdez, on line 21 and carrying over to page 5 and carrying on to lines 1 and 2 of page 6, Mr. Patterson states that the most recent credit adjusted risk-free rate for First Energy Corp is 4.54% from January of 2019 for Pennsylvania Electric Company, an affiliate of PE. Do you see that line?
Yes, I do.
Okay, my question is, since January of 19, are there any other more recent credit adjusted risk-free rates for First Energy Corp?
Yes.
And can you tell us what that is?
First Energy's most recent credit adjusted risk-free rate is 2.5%, which was utilized in recent entity evaluations performed for goodwill impairment analysis and was based on a normalized 20-year yield on government bonds at December 9th, 2020. As mentioned previously, this was provided during discovery.
And if you know, do you know when that information was provided?
I see the date on the discovery is March 19th, 2021.
Thank you, Mr. Valdez. Your Honor, that's all the rejoinder that we have. Thank you. Sorry, I stumbled on the question that may have caused some of the kerfuffle, but that's the extent of our rejoinder testimony.
That's okay. We will work to clear up the confusion between the two responses. If Mr. Alexander's not successful and Mr. Dean's not successful, I'll give it a shot myself.
All right. Thank
Mr.
you.
Alexander,
Okay,
do
well,
you have cross-examination for this witness?
yes, but not long, although we know that attorneys always say that and
You in
they make
particular,
it up.
perhaps.
Me in particular, perhaps. We go back a ways, do we not, Judge Lawrence?
Yes, we do.
I'm going to renew my objection, if I may, before I start, and move that that testimony be struck from the record because it's not the credit adjusted risk-free rate of the company. It's that of the parent. And there's been no testimony about the relationship between First Energy and Potomac Edison, other than we know that First Energy, from the first trial or even from testimony here, is indeed the parent of Potomac Edison, and I'm not challenging that. But there's no testimony as to why the cost of the risk-free rate of the adjusted risk-free credit, the adjusted credit risk-free rate of First Energy should be imputed to Potomac Edison.
Okay, well, that's all of what you're saying, I think, can be the subject of vigorous cross-examination. Instead of striking his testimony, why don't we develop it and understand what his testimony really is?
Understood. Thank you, Your Honor. Mr. Valdez, in any of the discovery that Potomac Edison provided in this case, is there any DR response that presented the adjusted credit, I think I did it again wrong, risk-free rate of Potomac Edison?
Not specifically of Potomac Edison.
And is there testimony in this case that you can point me to that that states that the adjusted credit risk-free rate of First Energy can be imputed to Potomac Edison?
Well, that would seem to imply that I was able to develop responsive testimony in rebuttal to a question about credit adjusted risk-free rate from interveners direct. That was not brought up in interveners direct. It was brought up in their rebuttal. So this is my first opportunity to address it.
Mr. Valdez, did you familiarize yourself with Mr. Spanos's direct testimony? The other witness in this case for Potomac Edison?
Yes.
Okay. Would you agree that he mentioned FAS 143 in that testimony?
Yes.
And you're familiar with FAS 143 because that's in your rebuttal testimony, correct?
That's correct.
So you knew that FAS 143 required under the standard in FAS 143 for a legal asset retire obligation, or ARO, that FAS 143 requires a credit-adjusted risk-free rate in using the 143 present value methodology for calculating net salvage. Isn't that correct?
I'm sorry, can you repeat that question?
Yes. I'll break it down.
Okay.
In Mr. Spanos' direct testimony, he mentions FAS 143, correct?
That's correct.
And in your rebuttal testimony, you reference FAS 143, correct?
Yes.
So can I gather that you're familiar with the basic elements of FAS 143?
Yes.
Okay, and isn't one of those elements using a company using for its legal asset retirement obligations, or AROs, when they apply FAS 143, that part of that is using a risk-adjusted, credit-adjusted risk-free rate?
Yeah, for that very narrow definition of legal AROs, or asset retirement obligations, yes.
Okay, so you knew that as part of 143, both from Mr. Spanos' direct and your rebuttal, you knew that this issue would come up.
To be clear, the company is not proposing the use of this present value method. It was mentioned in Mr. Spanos' testimony and my testimony as not to be used. And so it would make little sense to delve deeply into the mechanics of a methodology that the company does not support.
So you had in rebuttal the opportunity to discuss and distinguish FAS 143's requirement of a credit-adjusted risk-free rate, but you didn't take the opportunity to do so because you didn't agree with the application of FAS 143 in the company's view of this case.
There would have been no need to, because we are not advocating for the use of this present value method. And so to go into a long discussion of the parameters and breaking down each individual parameter of this present value method would have served no point.
I'm still a bit confused. Are you saying, in reference to that answer, that in none of the testimonies from either Mr. Spanos or yours filed in this case, the direct or rebuttal, that you or Mr. Spanos don't critique the proposals of either Mr. Guerin or Mr. Pattison or Mr. McAuliffe? Are you saying that nowhere in there is a critique of OPC's or staff's proposals?
There is a discussion of why not to use FAS 143 or the Maryland present value method in quite detail in Mr. Spanos' testimony.
So wouldn't that have given you notice that because of that huge application, and then you're mentioning it in your rebuttal, that you should have just ignored a main requirement of FAS 143, just completely ignore it? Is that what you're saying?
I'm saying it's not relevant to the discussion.
So when you mention FAS 143 in your rebuttal, it's not relevant at all about the requirement of a credit-adjusted risk-free rate.
No, that's not what I'm saying. What I'm saying is to dive into the individual mechanics of each individual piece present value SFAS 143 was not necessary because that is not our position. We are not putting forth any advocacy of SFAS 143. It wasn't until the discovery portion between the company's testimony and intervener's rebuttal did the topic of the credit adjusted risk-free rate come up in terms of what may be applicable to the company. The company responded accordingly, and the first time that we saw this is in intervener rebuttal testimony.
So you just said that you get into the mechanics of FAS 143. You didn't see a need to get into the mechanics. Did I get that right?
Yeah, because we are not advocating or supporting SFAS 143.
I understand that, but you said that you didn't feel the need because of that to go into the mechanics of FAS 143, correct?
Yeah, there would be no need to dive into the minutia.
That dive into the minutia. Isn't it a fact that there are only 5 basic requirements of FAS 143?
I couldn't broadly categorize it as just 5. I think it's been laid out in Mr. Spanos's rebuttal testimony.
Your Honor, is that me?
I'm sorry, I may have lost connection there temporarily. Can you hear me now?
Yes.
Okay. I'm sorry, can you repeat the question since we lost connection there a little bit?
The judge is on mute.
I could short circuit this, Mr. Alexander.
We can't. It's too low.
Sorry.
Yeah.
If I could short circuit your okay.
Please.
Mr. Valdez is saying that they didn't dive into all the details of the SFAS 143 method. You're saying really it's only a few. And I think what your point really is everybody knew the discount rate was at issue in this case. So why didn't he talk about all the possible discount rates, including the credit adjusted risk-free rate, right? Is that your question?
Right.
Okay.
Yes.
I think that is what it is. I think you're asking a question that he's not really able to answer. I think it is a little bit of a puzzlement. But do you have another question about this?
Yes, I'm gonna move on from that for a second, and I might revisit it. If you'll give me a second, Your Honor. Okay, I can now say it. Do you, Mr. Valdez, do you know what a risk-adjusted discount rate is?
Do you mean a credit adjusted risk-free rate, Mr. Alexander?
Yes, that I use it again.
Yes. Start with the word credit. Go from there.
A credit risk-adjusted.
No. Credit adjusted risk-free rate.
Okay, wait, I have it.
Maybe put a little sticky note on your
That's
laptop.
what I'm going to do.
Okay.
Thank you, Your Honor, for your patience and your help. Okay, Mr. Valdez, let's see if I can get it right. Do you know what a credit adjusted risk-free rate is?
Yes.
Okay, so let's start with this. What's a risk-free rate?
Risk-free rate, as was discussed earlier in this hearing, is generally described as the Treasury yield.
Okay, on Treasury bills.
Yes.
Okay, so what is the credit adjusted risk-free rate?
Well, the credit adjustment would be literally what it is an adjustment to represent a deviation from or increment, I guess I should say, to that risk-free rate. So it's credit adjusted.
And what is the adjustment comprised of?
I don't know the details of what comprises the adjustment.
Okay, so your testimony is first of all, that First Energy, the parent of Potomac Edison, its most recent credit adjusted risk-free rate is 2.5%. Is that right?
Yes.
Okay, and you know what the risk-free rate is, correct?
Mr. Alexander, I
Yes.
have to stop you because I want the record to be clear. The
Yes.
testimony you just quoted did not say what you said. If you're looking at staff phase 2 4.4, that's where I see reference to First Energy. That has the rate of 4.54.
Right.
You said 2.5. Can maybe we want to go back,
All right, let me clarify.
please.
Thank you. Mr. Valdez, I thought I heard you say that the current credit adjusted risk-free rate for First Energy was not 4.5, roughly 4.5%, but rather it was 2.5%. Did I hear wrong? And I certainly may have. I'd like you to correct me, please, if you would.
No, you're correct. Is that the most current or recent valuation is 2.5%.
And what's the rate of inflation?
I do not know. I probably varies based upon the point in time that you're looking at.
Okay, so what is the current risk-free rate?
When looking at this this valuation that was provided to me by our Treasury Department, I took a look at the risk-free rate, and the risk-free rate for that time period, which was December 9th of 2020, the risk-free rate was about 1.5%. So it looks to be about a 100 basis point adjustment, credit adjustment between the 2.5% and the Treasury yield of about 1.5%.
And you're saying that based on your knowledge, First Energy's credit adjusted risk-free rate is the rate of the consumer price index inflation that Mr. Spanos was testifying about and in his pre-file testimony.
I am not saying that they are the same. If they happen to be the same, then that is the case. I am just simply stating the fact that the credit adjusted risk-free rate for the most recent valuation is 2.5%.
Okay, so I'll ask you this: where is the testimony that says that the credit adjusted risk-free rate for First Energy can be is properly imputed to Potomac Edison?
Well, this is my first opportunity to respond to that, so it's my live testimony right now.
Well, I understand that, but where are you saying that it can be imputed to Potomac Edison?
Well, First Energy is the holding company for 10 electric utilities, all of which are fully regulated distribution utilities. So the fact that the parent company information being applied to Potomac Edison is about as reasonable as using an affiliate of ours, which is also a regulated entity.
Now, you're stating that as a fact. Is that correct?
That you're saying that.
That you're saying, I'm sorry. You're saying that all 10 regulated utilities of First Energy, that each one of them respectively has a credit adjusted risk-free rate of about 2.5%. Is that right?
I can't speak for all 10 of the operating companies. What I'm saying is that it's a credit adjusted risk-free rate for utility holding companies. So it's specific to a utility.
I understand that. But your testimony, I'm seeming to say, is that the credit adjusted risk-free rate for First Energy can be imputed to Potomac Edison, because that's the only way that information would be relevant to this proceeding. So is that what you're saying?
That is the most recent information we have. That is all the information that we have with regard to it. And so we provided, in response to discovery, what the most recent valuation is.
So you don't know if that's Potomac Edison's credit adjusted risk-free rate. Isn't that correct?
Well, I can't say that in black and white. It certainly seems very reasonable in the fact that, as noted in my testimony, I'm the director of rates for not only Potomac Edison, but also for Monongahela Power. And Monongahela Power and Potomac Edison have the same credit ratings. And last week, Monongahela Power issued 200 million first mortgage bonds at a rate of 2.05%. So the fact that this 2.5% from First Energy and the 2.05% from last Wednesday falls into relative alignment.
But you don't know for certain. Well, let me ask you this. Don't each of the, now, let me step back. If I want to buy in the market shares of Potomac Edison alone, I can't do that, right?
Correct.
Because the only thing I could issue the only thing I can buy in terms of shares is First Energy shares, right?
That's correct.
Okay. But doesn't, I'm hearing the echo, Your Honor. Doesn't Potomac Edison issue its own debt, its own bond issuances?
Potomac Edison issues its own debt, yes.
And when was the last time Potomac Edison had a debt issuance?
Oh, it would have been the summer of last year.
Okay. Is that an evidence in this case?
No.
Okay. And what is in evidence in this case is that in the phase one of this case, according to the cost of capital experts, including yours, Potomac Edison's debt was, I believe, 4.55%.
Objection,
right?
Your Honor, to what is in evidence.
It's in evidence in phase one, Your Honor. This is the same case.
Mr. Valdez went here with regard to cost of debt. So Mr. Alexander can ask a follow-up question.
Thank you.
Okay, so you don't know what Potomac Edison's cost of debt was in phase one of this case.
I know the long-term debt that you're referencing is made up of a series of issuances over a period of multiple years. And so any weighted value covers quite a long span of different periods of what may be higher cost and what may be lower cost.
So, but again, I'll say you don't know that average number from that was in evidence in phase one, and that was referenced by the commission.
I don't recall it off the top of my head.
Okay. And okay, so instead of looking at the average for Potomac Edison, you're saying that because I can never pronounce it right. Monongahela had a debt issuance of, I think you said 2.5%?
2.05. And to help you out, everyone just calls it Mon Power. That might make it
Mon Power, thank
yes.
you. Okay. But you're not averaging in all of those history of debt issuances that Potomac Edison as you just said, did for long-term debt without citing the number. You're just referring to the most recent and cutting out all of the previous ones that would average out to something higher, correct?
Yes, in all the instances, whether it's the First Energy, the Mon Power, or the reference to Penelec, it's the most recent.
Right. But you just acknowledged that the long-term debt that factors into the capital structure of Potomac Edison is an average of a history of the debt issuances going back that are all still those cases that are still not fully paid, correct?
Yes.
If I could have a second, Your Honor.
Sure.
Would you agree that the credit adjusted risk-free rate includes a inflation premium over the risk-free rate?
There's a credit adjustment. I think as I testified previously, I'm not sure of the pieces that comprise the credit adjustment, but there would be a credit adjustment above the risk-free rate.
Okay, and you said there were 10 subsidiaries of First Energy that are regulated utilities, correct?
That's correct.
Okay, can you state what their most recent credit adjusted risk-free rates are
Objection, Your Honor.
respectively?
There was an objection.
Oh,
What's the objection?
Objection to going through all 10 of First Energy's subsidiaries. Mr. Valdez is assigned to 2 of them, and I don't know the relevance of all 10 of these subsidiaries beyond Mr. Valdez's, the scope of his testimony.
Okay, well, the scope of his testimony at least now includes Mon Power and Pennsylvania Electric Company. So I don't know which 2 he's responsible for, but
Mon Power and PE.
okay, well, his testimony goes beyond Mon Power to include Pennsylvania Electric Company. So apparently he has some information about additional affiliates. So to the extent he can answer the question, I think it is relevant.
Thank you, Your Honor.
In response to the question, I don't know what it is for all 10 affiliates. I use the most recent one, and the most recent one is from Penelec, Pennsylvania Electric Company, which is now over 2 years old.
Mr. Alexander, you're muted.
Thank you. I was trying to get rid of an echo. Your Honor, with your patience, can I have 1 minute, please, just to look for something?
Sure. Did he answer your last question?
Well,
Or you're moving on, that's fine.
yeah, I'm going to move on here. If you go, Mr. Valdez, to your rebuttal
Okay.
on at 1 to 5.
Page
Well,
5.
actually, yeah, I'm looking for your page number. Page 2, I'm sorry.
Okay. Page 2.
You
I
state
am
that,
there.
thank you. With regard to the proposed Maryland present value method, it's flawed since it creates an intergeneral inequity where future customers are subsidizing current customers. Now, do you testify to that for the same reasons as Mr. Spanos?
Yes, I do.
Okay, so I'll ask you basically the same question. If I'm 23 and currently a Potomac Edison customer, and then 10 years later, 33, I'm still a Potomac Edison customer, and at 43, I'm still a customer, and at 50, I'm still a customer. Are you saying that me at 43 is subsidizing, that me at 23 is subsidizing me at 43?
I'm sorry, could you repeat that and the last part again?
Sure.
Okay, just the last part.
Well, I could ask the court reporter to
Okay.
do it back, but let me try to rephrase it. The hypothetical is that I am 23 years old and a Potomac Edison customer, and I'm now 33 and I'm still a Potomac Edison customer, and then I'm 43 and I'm still a Potomac Edison customer, et cetera, et cetera. Now, you say that the PV method creates an intergenerational inequity whereby future customers are subsidizing current customers. So my question was, when I'm 43, am I subsidizing myself at 23?
Yes, and I guess how I can paint this is in the lens that I work with in terms of rate establishment and rate making, and that's primarily the matching principle, that you would design rates and revenues according to cost. And if you undervalue those costs, then it's essentially kicking the can down the road, that it's an IOU for a future generation to pay, whether it's the same customer or future customers. It's an eventual IOU that ultimately gets paid because of the mismatch that the revenues are not equating to what the costs are.
When I'm 33 at 43, if the present value method is applied throughout, when I'm 33, don't I get the benefit of the present value method, whereby I am paying in discounted present value dollars for the never ending asset account, for an ever ending asset account? Did you understand the question?
I did. It goes back to the kicking the can down the road analogy, that if you're paying very little now, it's going to build up into a regulatory asset and eventually get collected from some future generation of customers. And since we know that at the current level that it's under recovering the net salvage, that regulatory asset is going to continue to keep growing and growing. And then as future rate cases and future depreciation studies try and collect that regulatory asset, it has a tendency to cause upward pressure on rates.
But when I'm 33, aren't I still paying in discounted cash flow dollars?
I believe you're talking about new assets that the future present value or the future amount gets present valued. You still have the existing assets, and primarily the problem really gets to be whenever those assets have been retired and removed from service. And so now, not only is there upward pressure on rates, you're now telling customers you have to pay for a removal cost for an asset that doesn't even exist anymore.
And when does that happen?
In the cycle of rate cases and updated depreciation studies and trying to catch up with this regulatory asset, if you know you have a regulatory asset per se, that's of a certain value, and it continues to grow each year and grow and grow, then it would be unwise to ignore a growing regulatory asset. It's just a larger and larger burden eventually for customers to ultimately pay. It makes sense to address that asset before it becomes a problem, or if it is a problem, provide some measure to reduce that asset, or else the asset will just keep on growing and growing and growing.
Do you know why Potomac Edison waited 25 years to not file a depreciation study and have to be ordered by the commission to do so?
There are a multitude of reasons, namely the last, well, prior to 2018 case. The last case was like, I believe it was 1993, and Potomac Edison was vertically integrated in the sense that it owned generation at the time. And it had established rates through that mechanism, and then several years had transpired, and Potomac Edison was involved, as all the other electric utilities were in Maryland, in deregulation. And there were long periods of time where we could not go in for a rate case, even if we wanted to, due to stay-out periods agreed to in settlements. And after that had transpired, then our earnings were sufficient. And we did not want to file a rate case for the sake of filing a rate case. As Potomac Edison, we're very proud of our rates, and proud.
Can I interrupt you for a second?
Yes.
You didn't
Yes.
come in, Potomac Edison didn't come in for a rate case because they were over-earning. Isn't that correct?
No.
Your Honor, if he could finish his answer, I mean,
Well,
I
it's a
don't think
long
this is
answer to my
necessary. Hold on,
question.
Mr. Alexander. I don't think it's necessarily relevant, the history of when they filed cases, but Mr. Alexander asked, and Mr. Valdez should have an opportunity to respond.
Yes,
Your Honor,
Mr. Alexander, I think
stopped.
it's somewhere in the testimony that the reason that Potomac Edison filed the case when it did was related to the Tax Cuts and Jobs Act. They wanted to file because the commission wanted them to return some money, and they wanted to do that as part of a rate case. Isn't that why they filed when they did? Isn't that in the testimony somewhere?
Are you talking about phase one, Your Honor?
Yes. You asked why they waited 25
Yes,
years.
if Your Honor says so, because I was not the attorney in that case. I didn't read
Okay,
all.
it's my understanding that it's admitted in the testimony somewhere that the reason
That's
they
fine.
filed when they did after waiting 25 years is all related to the case. I don't have the case number, but related to the Tax Cuts and Jobs Act. Order number 88860 in case number 9473.
Oh, that's okay, Your Honor. I accept that.
So I don't know if that helps you, but we seem to get
Just
stumbled on
going to
something
move
that
on.
we didn't need to stumble on.
No, and I'm just going to move on, Your Honor. Thank you. That was very helpful. And I don't want to take time that isn't really going to be productive. I'm sure you agree.
I do.
Mr. Valdez, can you tell me that if the commission allows the company to use the traditional straight line methodology, as you are also advocating, its cash flow will be much higher than it would be if the commission directs the company to use the PV methodology?
No, that's not true.
So you're saying, I just want to make sure that if the rates recommended by staff or OPC are implementing, it won't have any effect, negative effect at least, on the company's cash flow.
No, the rates proposed by staff and OPC would have a detrimental effect on cash flow. The rates proposed by the utility Potomac Edison would have no effect on cash flow.
And if those rates recommended by staff and OPC, as you said, would affect cash flow, it would negatively affect the company's cash flow by millions of dollars. Isn't that correct?
Yes.
Okay. Your Honor, just one more minute, and then I'm gonna bow out. Your Honor, I'm not going to look for more questions through this. That'll be the end of my cross-examination. Thank you, Your Honor, for your patience.
Okay, Mr. Dean, do you have any cross-examination?
One or two questions, Your Honor.
Okay.
Mr. Valdez, good afternoon. This is Michael Dean, staff attorney.
Good afternoon.
On page 8 of your rebuttal testimony, do you believe that your recommendation to implement the results of this phase of the proceeding, the new depreciation rates in the next rate case, is consistent with the direction of Commission Order number 89072, which you quoted at the bottom of page 7?
The question is ultimately whether it be by the answer by myself or by staff is a matter of interpretation. And how I read that is that the commission wanted to be sure that whatever the results were of this proceeding resulted in a change in depreciation rates and expense, but it did not dictate exactly when. It gave them the latitude and the discretion to implement it now or implement it in the upcoming base rate case, which the commission has ordered as well. So that will be filed shortly. And base rate cases, distribution base rate cases, I should say, are the manner in which base rate items such as depreciation are typically handled. And since a depreciation case, I think as everyone can understand, is complicated and detailed, this case affords the commission and the parties time to dive into the details of that, and then the results of that can be layered into the next base rate case.
Thank you for your answer. Turning to page 5 of your testimony.
Is rebuttal?
Rebuttal.
Okay, thank you.
On the question at line 15 indicates that you believe that the present value method results in higher costs to customers. And I believe that you're referring to the answer just above that as explaining why higher costs to customers occurs. Is that correct?
Yes, generally that couldn't take a look at just one specific line item. It's more of the whole context of the answer in page 5 and going over into page 6.
In that case, could you explain how use of the present value method step-by-step results in higher costs to customers?
It's very similar to the conversation or the cross-examination recently from Mr. Alexander. The one item I did not mention is that was already covered earlier in the hearing, is that obviously if there's a decrease in depreciation expense, it results in an increase in rate base, and therefore more dollars associated with that. But also it's the deferring of cost for some future generation. So I am essentially no longer following a tried and true rate principle of matching revenues with costs. Now I'm devaluing those costs, knowing that my actual costs are substantially higher than what this present value method would afford me to recover. So as that has to get recovered in future generations, now whether that's future years or however long that period is, it ultimately results in higher cost to customers through a combination of building up that regulatory asset and ultimately satisfying that regulatory asset, as well as the higher rate base.
And by higher costs, you're referring to the comparison with using the traditional method.
I'm sorry, yes, that's correct.
Okay, so thank you very much for your testimony. Staff has no further questions.
Thank you.
Mr. Valdez, can you turn to your direct testimony, please?
Okay.
Pages 4 to 5.
Okay.
You set forth the company's proposal regarding the costs associated with this depreciation study.
Yes.
Okay. And then that was actually the question. And then in your answer, you say the company is requesting authorization to defer costs associated with this proceeding into a regulatory asset.
Yes.
What do the costs incurred during this proceeding include?
The costs for this proceeding are the cost for our consultant, which is Gannon Fleming, as well as legal fees that we would incur.
Okay, so even though you used you see in the question you used associated with this depreciation study, and then in the answer you used this proceeding. You recognize those are two different things, right?
If I use the incorrect terminology, I apologize.
Okay, so you actually would like to defer all the costs associated with this phase 2 into a regulatory asset.
To be clear, is the costs associated with our consultant Gannon Fleming and legal fees that would go into a regulatory asset for recovery in the upcoming base rate case. And that would be the only cost. In terms of actually implementing the change in depreciation rates and the resultant effect on depreciation expense, we propose that be implemented as an adjustment in our upcoming base rate case.
Right, but when you say your consultant, Gannon Fleming, you don't just mean Mr. Spanos's testimony, you also mean the depreciation study itself, which was completed and filed in this proceeding on September 22nd.
Yes, Your Honor, you're correct.
So you mean costs incurred prior to September 22nd, correct?
Yes, it would be costs that were leading up to, as you're correct, that would result that were incurred in preparing the study, testimony today, any follow-on cost, as well as our legal costs that we incurred in conjunction with this proceeding.
Okay, because it's a little different than your testimony, which talks about costs during this proceeding.
Okay.
And I think that when staff responded to your testimony, and we can, of course, ask Mr. Patterson, but if we look at Mr. Patterson's direct, at page 10, the question on line 3 is, how does PE propose to account for the depreciation study costs? And the answer is PE witness Raymond Valdez proposes that the costs for the depreciation study be placed into a regulatory asset and that the costs will be considered in PE's next distribution rate case. So I took it to mean that what staff is agreeing to is the cost of the depreciation study. Do you see the difference there?
I do.
I don't see that in Mr. Patterson's direct, he accepted a proposal to include all of the rate case expenses into a regulatory asset. Would you agree?
I don't see that delineation.
Okay. So we have a small issue there. Now, in your rebuttal, pages 7 to 8.
Okay.
If Potomac Edison files its next base rate case at the end of 2022 or early 2023, do you know about how long it is between the filing of a rate case and when the rates go into effect?
It should be about 7 months.
Okay. So new rates based on the depreciation study in your case, at least pursuant to your proposal, would go into effect sometime in the fall of 2023?
If it was filed as late as early 2023, that's correct. If it was filed in late 2022, it would obviously be earlier.
Okay. But could be as late as fall of 2023.
That's correct.
Okay. So Potomac Edison customers would continue to pay the rates based on Mon Power's actual plant, those Mon Power estimates, until the fall of 2023. Then they would start paying more accurate rates based on Potomac Edison's actual data. Is that what you propose?
Yes, because if I could just add, the updated rates result in a near identical depreciation expense. That's why there's no adjustment or effect on cash flow.
Under Mr. Spanos's analysis.
That is absolutely correct, yes.
But not under staffs and OPCs.
That is correct.
Under staffs and OPCs, there would be a reduction, correct?
That's correct.
Okay. The procedural schedule in this case has reply briefs, and I intend to ask the parties, someone remind me if I forget whether we still need reply briefs, but the date for that is May 25th. So a proposed order could go out shortly after that, and if there's no appeal of the proposed order, it would become a final order at the end of June 2021. So you're suggesting that 14 to 18 months is a short period of time for ratepayers to possibly pay rates that are too high?
I would not say that the rates that the customers are actually paying, or the individual depreciation rates, I guess I should say, would be different, but the actual rate that the customer pays on their bill wouldn't be too high or too low. It would be the same because there's generally the same amount of depreciation expense.
Under your proposal?
That's correct.
Okay,
I'm sorry.
Work with me for a minute.
Okay.
If OPC and staff's proposal or one or the other is accepted, the depreciation rates would be such that once incorporated into distribution rates would go down, all other things being equal, correct?
Correct.
So we have a scenario that for a period of 14 to 18 months, if OPC or staff's proposal is accepted, ratepayers would be paying too much money, correct?
I hate to qualify it as too much money. I guess I would say qualify it as paying, if new rates were established based upon that, paying too little, because we would be under collecting our net salvage cost. And so we're anything.
Let me stop you there.
Okay.
If the commission orders certain rates, those are the rates, right?
That's correct.
Those rates, again, follow my hypothetical. OPC or staff's proposal is accepted. That order becomes a final order. 14 or 18 months until those rates can go into effect. Those commission ordered rates, I understand you don't agree with them, but those commission order rates would be lower, correct?
That's correct.
Okay. In phase 1 of this case, Potomac Edison proposed to institute deferral accounting for storm expense. Do you recall that?
I do.
And in your testimony in that case, in phase 1, in your rebuttal testimony, you testified that deferral accounting could be established to net a timing difference to 0. Do you recall that?
Yes.
What is deferral accounting?
Deferral is commonly used, for example, in say a surcharge. I'll give it as an example, that you have a stream of cost and then the stream of revenues. Now the costs can be pretty stable, but the revenues can certainly vary based upon consumption or weather. And the difference between the revenues and the costs, if that was a over collection, it would be deferred into a regulatory liability. If it was under collection, it would be deferred into a regulatory asset. But that's the general concept of deferral accounting, is that the delta, or the difference between the costs and revenues, are deferred as either a regulatory liability or asset for future refund or collection from customers. And
netting a timing difference to 0 means that interest is somehow incorporated, correct? Time value of money?
Interest can or cannot be included. It can be done either way.
Okay, well, what were you proposing in phase 1?
I don't recall in phase 1. It may have
if
been.
we were going to establish something to net a timing difference to 0, it had to have incorporated a time value of money element.
Well, when referencing that timing, without looking back at it, my recollection is the timing between costs and revenues, not the time value of money.
You were proposing to establish a regulatory asset or liability in phase 1, defer recovery for a period of time, that when you eventually recovered, if it was a regulatory asset, it would have had interest on it, correct? Probably at the rate of return, the company's authorized rate of return?
Not necessarily. Just because it's an asset or a liability doesn't mean that it accrues carrying charges. That asset, it could. But
if you're wanting to make someone whole and you put off paying them, generally you pay interest, right? That's how you make someone whole for having to wait to receive money.
That's one way to do it. Although I don't.
And I agree with you that you don't always have to have a return at a company's authorized rate of return, but often when companies come in and they propose setting up a regulatory asset, they expect to collect at their authorized rate of return, do they not?
I think maybe it depends upon the situation. I know that assets that have been authorized by the commission for the utility have not included carrying charges. So I guess I can't say that as a blanket statement of whether.
What are you proposing for your depreciation study, your consultant expenses, and your rate case expenses that you're putting into a regulatory asset in this case? Carrying charges or no?
No, that would not include accrued carrying charges.
Is that clear from your testimony?
I don't think it does. I don't think it draws that distinction.
I certainly wasn't clear on that. But Potomac Edison, again, proposed deferral accounting in phase 1, knows how to use deferral accounting. would it be appropriate with respect to the delta in depreciation rates in this case?
It's an avenue that can be done. I don't think it would be appropriate. It's something that I would prefer to handle within the context of a base rate case, because that's whenever all aspects of the utility service is considered, not just one aspect associated with depreciation.
Maybe I didn't ask that correctly. I'm asking if the commission were to accept your proposal to not put the new deferral rates into distribution rates until you file your next base rate case, would deferral accounting be appropriate to make ratepayers whole again if, given my hypothetical that their rates are going to go down, would it not be appropriate to use deferral accounting such that you could get your wish of not incorporating these rates until the next base rate case, but at that time you have to make ratepayers whole by adding a carrying cost onto that delta that they've overpaid, under my hypothetical?
It's difficult for me to say appropriate. It's not something that we support, but it is an option obviously the commission can choose.
Okay, so that was what I was getting at. I understand completely you don't support it, but is there an accounting reason it would be inappropriate?
I'm sorry, I understand the question now. There's no accounting reason that would prevent it.
Okay, you just didn't suggest it.
That's correct.
You'd like to, if OPC or staff, if one of their proposals is accepted and the difference in depreciation rates results in lower distribution rates, you'd like to just hold off for 14 or 18 months until those go into effect and just kind of save that money for Potomac Edison.
Yeah, it not only alleviates a cash flow issue, and obviously the cash flow issue is certainly a problem right now, not just for Potomac Edison, but for all utilities. But it's related obviously to COVID and the massive arrearages that have been occurring due to COVID. But it also synchronizes a decrease with what obviously in this hypothetical, if there was a decrease in depreciation and there was an increase associated with the base rate case, if they net to a near zero, for example, under a hypothetical, then the base rate case can get resolved with little or no effect to customer rates.
Right, but that could be done again by utilizing deferral accounting.
That is one avenue, yes.
Okay. All right, I really tried to follow Mr. Alexander's questions, and understand these two data responses, but I do not. So I'd like to revisit them, as painful as it may be.
Okay.
All of us. Okay. So I'm looking at staff phase 2, 4.4 attached to Mr. Patterson's testimony, and then I'm looking at PE marked for identification exhibit 21, staff phase 2, 4.3, and I don't understand how staff seemed to ask a similar question and got two incredibly different answers. So I need to understand why the difference here. And yeah.
Okay. Yeah, it would, if you can refer to 4.4, if you have that in front of you.
I do.
The distinction is actually within the question itself, is they were asking for credit adjusted risk-free rates for asset retirement obligations, for AROs.
Yes.
And so the response is specific to just a credit adjusted risk-free rate for AROs. Now, credit adjusted risk-free rates aren't applied to just AROs. They can be used in other instances. And that's why in 4.3, when staff asked a similar question, it's a little different because it doesn't reference AROs. It instead just asked about a credit adjusted risk-free rate. So the difference between the two is one is specific to just AROs, and 4.3 is the credit adjusted risk-free rate. That is not specific to AROs.
Okay. Did you also distinguish between legal AROs and AROs?
It's my understanding that all AROs are legal AROs, and so I did not draw a distinction between legal AROs and AROs.
Okay. But AROs are what the SFAS 143 method is dealing with, correct?
Yes.
The SFAS 143 method isn't really interested in whatever you provided in response 4.3, correct?
Yeah, and that's correct. And that's because the AROs are not frequent, especially for distribution utilities. And so that's why in 4.3, it gives the most recent information we had available.
And then in 4.3, I don't see a reference to First Energy. So I wanted to clarify. That is First Energy's most recent credit adjusted risk-free rate?
That's correct.
Okay, so can we say for the record that your response includes some reference to First Energy there? Because otherwise I find it a little bit misleading.
Yes, that's correct.
Okay. Because I don't have, maybe it would be cleared up in attachment A, but I don't have attachment A. Maybe not, I don't know. Okay, so you testified that one of the Potomac Edison's affiliates recently issued debt at 2.05%. And I think your point was they are, they have a great credit rating, I guess. They are able to get credit at such a low rate. And then you made the sort of assertion that Potomac Edison has a similarly good credit rating. And so I think your point was they should be able to issue debt at a similarly low rate, but you weren't in any way suggesting that the recently issued debt at a rate of 2.05 is equal to Potomac Edison's credit adjusted risk-free rate, were you?
No, I was using that as a basis, a litmus test for reasonableness per se. That the rate from Mon Power is quite low, and so the credit adjustment for a similarly situated company as Potomac Edison is relatively low, and so
But you don't know what that is.
I do not.
You're just, again, you seem to be sort of implying that it would be around 2.05, but it has no direct relationship to the debt issuance.
Well, I guess I should clarify, for Mon Power specific, the credit adjustment was 120 basis points.
From what to what?
From that was for the 2.05. If you subtract the 120 basis points from it, that was the rate without the credit adjustment.
To get to the T-bill or similar rate?
Whatever rate was used in the ultimate issuance. I'm not sure what the reliance was. And so whenever I saw 120 basis points from Mon Power and then took a look at the 100 basis points delta for the 2.5% in response to staff 4.3, those basis points were fairly close. So it seemed reasonable.
What 100 basis point difference in the response to staff? What are you
I'm sorry,
referring to?
I'm sorry, that was earlier in the line of questioning with Mr. Alexander when discussing that when I received this information from our Treasury Department, I took a look at the Treasury yields on December 9th, and they were about 1.5%. And so to get to the 2.5% that was used by First Energy was the 100 basis point delta.
Okay, but that doesn't necessarily have anything to do with the debt issuance again.
No, it was just to kind of put parameters around what a credit adjustment could be.
not related to asset retirement obligations.
Not specifically related to asset retirement obligations, but just generally to credit adjusted risk-free rates.
And you testified you don't really know how to arrive at a credit adjusted risk-free rate for Potomac Edison, correct?
I do not.
But do you know that determining what to add to a risk-free rate involves observing market data, such as the pricing of corporate debt and other things?
I don't know. I can't speak to that, unfortunately.
Okay. Do you recall that Potomac Edison used Dylan DeSendis, director of Scott Madden Inc., as its cost of capital witness in phase one?
Yes.
So Potomac Edison could conceivably hire someone such as Mr. DeSendis to calculate Potomac Edison's credit adjusted risk-free rate?
Presumably, I'm not sure what falls within his realm of expertise or responsibility, though.
Okay. I don't expect you to recall it, but maybe you do, that in phase one, staff's witness testified that the risk-free rate was 3.68%. Do you recall that?
I do not.
Okay. Do you know if the risk-free rate used in the capital asset pricing model, CAPM, would be the same as the risk-free rate that would be used and then adjusted for the creditworthiness?
I do not.
Okay. So we have a lot of questions that we don't have the correct expert for, right?
Correct.
Okay. You responded that Potomac Edison, based on First Energy, considers 2.5 to be the most recent credit adjusted risk-free rate. What do you, how do you explain the difference between the 2.5 in your response to 4.3 and the rate of 4.54 from January 2019 for Penn Electric?
I would attribute that to the passage of time. That the response from Penelec is, I guess, a little over 2 years ago. 2 years ago, it was in January of 2019, and so it's getting a little bit staler, if that's the word, stale. And the more recent number from First Energy is the most recent value that we have.
But again, the number for First Energy isn't for asset retirement obligations. So
It is not.
you think that if we went back to Penn Electric and said, hey, 2 years have passed, what's your ARO now? They would say 2.5%?
To do it updated, it would not surprise me because that rate obviously has changed. The credit adjusted risk-free rate obviously has changed. So if that
Why is that
hypothetical,
obvious? I'm sorry, why is that obvious?
oh, I'm sorry, that the credit adjusted risk-free rate 2 years ago was 4.54%. And now, as recently as a few months ago, it's 2.5%.
For two different entities, though, that you're not comparing apples to apples.
No, but it's still a credit adjusted risk-free rate for, whether it's AROs or goodwill impairment or any item, it's still a credit adjusted risk-free rate. And so regardless of what it's applied to, we're using more recent data.
Okay, but we don't really know, do we, whether the 2.5% that you're attributing to First Energy related to entity valuations performed for goodwill impairment analysis. We don't really know whether that would be what an expert would say was Potomac Edison's credit adjusted risk-free rate related to asset retirement obligations, if it had any, do we?
Potomac Edison has some very old asset retirement obligations. But what that value would be, I guess if there was doubt cast on 2.5%, I think the same doubt would be cast on the 4.54% since it's an affiliate. But they're both in the utility operating sphere, owned by the same corporate entity.
Would you agree to clear up this doubt? We would need an expert such as Mr. DeSantis or a similar person.
To determine the credit adjusted risk-free rate?
For Potomac Edison. I mean, I understand it's similar to, return on equity. These are estimates. And so that expert wouldn't, with respect to Potomac Edison, be able to find the credit adjusted risk-free rate because you've testified they don't have any with respect to AROs, but couldn't an expert be used to estimate what that figure would be?
Possibly. I just don't know who is out there in the marketplace to do or to not do such an evaluation.
But it's possible that we could hire an expert to get us the figure that we really need here. Because again, you testified that the SFAS 143 method requires the use of a credit adjusted risk-free rate, correct?
Yeah, using the SFAS 143 method for AROs, yes.
But we don't really know what that is for sure, correct?
Not specifically.
So
not specifically for Potomac Edison.
Right. So our best hope to try and get that information, we would at least consult with an expert to see if we could get that, right?
Yes, presumably. I don't know for sure as I don't operate.
No, I understand you don't know if such an expert exists, but we should at least consult with one to see if we can get the figure that we don't have. Does that seem like a prudent course of action?
I think that's one course of action. I unfortunately am struggling a bit on this as this is a bit outside of my realm.
Right, which is another reason that perhaps a different expert would help us out here. Okay, I'm just looking to see if I have any other questions. Okay, any redirect based on my questions?
None, Your Honor. None for Potomac Edison.
Mr. Alexander?
I have two, but you'll tell me, I know you will tell me if this is beyond the direct, but I think you were asking a number of questions about what we've done before of the relationship between First Energy and Potomac Edison. So I have two questions. And Mr. Valdez, I think you in phase one of this case, there was testimony that the credit agencies have rated the bonds of Potomac Energy and First Energy differently. Do you recall that?
I don't.
Okay. So there's no evidence in this case of any updating of that I know of. And when I'm asking, do you know of any evidence in this case about the updated bond ratings for both First Energy and Potomac Edison and Mon Power?
I don't know of any evidence introduced regarding that.
Okay, thank you, Your Honor. I'm out.
Mr. Dean, do you have any questions based on my questions?
No, Your Honor, staff does not.
Okay. Mr. Valdez, you're excused.
Thank you.
I guess that's it for Potomac Edison witnesses. OPC, are you prepared to call your first witness?
Yes, Your Honor, and I would say it's my first and last witness. Good. James S. Garin, take the stand, please.
Wait, I need to swear him in.
Right.
Mr. Garin, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thanks. Now you can go ahead.
Thank you, Your Honor. Mr. Garin, would you kindly state your name for the record and spell it for the court reporter?
My name is James S. Garin. The last name is spelled Garren. Would you like me to spell my first name as well?
No, I think you can get James. Would you please state the name of your business and its address and location?
I am employed by Snavely King Majoros and Associates, Inc. The business address is, one moment, apologize. I've never managed to be ready for this question. Apologies. A business address is Suite 350C, PO Box 727, Millersville, Maryland, 21108.
And would you please state the position that you hold in the business?
I'm vice president.
All right, Mr. Garin, do you have before you a document entitled Direct Testimony of James S. Garin on behalf of the Office of People's Counsel, pre-filed in this proceeding on about January 29, 2021, comprising about 49 pages of narrative testimony, followed by an Appendix A, an Appendix B, and Exhibits JSG1, JSG2, and JSG3? Your
Yes.
Honor, I'd request that Mr. Garin's direct testimony be marked for identification as OPC, I guess it's Exhibit 1.
So marked.
Mr. Garin, was this document before you either prepared by you or under your supervision and direction?
Yes.
And do you have any corrections or deletions to make to this pre-filed prepared written testimony?
I do not.
Actually, you do.
I apologize, Gary. I thought we'd done this.
No. Well, yes, but it's not in the record.
My apology. Yes,
That's
I did.
okay. All right. I am going to show you a response to PE Phase 2 data request 1-27 directed to OPC. Your Honor, I request that this document be marked as OPC Exhibit 1B for identification.
So marked.
Were you the sponsor of this response?
Yes.
Okay, did this data request pertain to errors in your direct testimony about a table contained in Exhibit JSG-1 related to average service lives of Potomac Edison plant, retirement curves, and net salvage percentages?
Yes.
All right, do you have it in front of you? It was emailed to everybody. Do you have it in front of you, or can you get the 1-27, your response?
I do have it in front of me. Yes.
Okay, good. Can you briefly explain what the error was and how you corrected it?
Yes. So the error was in the account that with the average service life and curve that I had initially listed as being proposed for account 362 station equipment was incorrect. And I corrected that life and curve to reflect the correct one being that I was proposing in my exhibit from a 65 R2.5 to a 75 R1.5.
Okay, and go ahead, please.
Sorry, I was just going to say the table included in the response lists the correct life and curve.
Okay, you sponsored this response to data request 1-227 from the company. correct?
Yes.
Okay, and it is correct now based on that answer.
Yes.
Okay, now I'm going to show you a response to Potomac Edison Phase 2 Data Request 1-28 directed to OPC. And Your Honor, I'd request that this document be marked for identification as OPC Exhibit 1-B.
Your last exhibit was 1-B.
Oh, okay, well then I'll tell you what, we'll do this one as 1-A. Can we do that?
So marked.
Thank you. Mr. Guerin, were you the sponsor of the response to Potomac Edison Data Request 1-28?
Yes, I was.
And this response to that data request 1-28 inquired about your Table 2 on page 6 of your direct testimony, correct?
Yes.
And in your response, you provided a corrected Table 2, correct?
Yes.
Can you briefly explain what the error was and how you corrected it?
Yes. In the column in Table 2 under OPC's adjustment, I had initially incorrectly totaled the numbers, or I believe that there was in fact an artifact from a previous version that had remained. The total showed in the initial table 16.4, excuse me, negative 16.4 million. It's a difference. And that was incorrect. It was corrected to be 10.4, negative 10.4 million.
Thank you. And were these responses to these two data requests prepared by you or under your supervision or direction?
Yes.
Aside from these two corrections, do you have any additional corrections or deletions to make to your pre-filed written direct testimony?
No.
Okay. And if you were asked today the same questions in your direct testimony today under oath, subject to your responses to Potomac Edison Data Request 1-27 and 1-28, would your answers be the same?
Yes.
For these reasons, do you adopt your prepared written direct testimony, including the aforementioned corrections, as your sworn testimony in this matter?
Yes.
Your Honor, I move that these three documents, document OPC Exhibit 1, OPC Exhibit 1A, and OPC Exhibit 1B, and Mr. Guerin's direct testimony be admitted as evidence into the record of this proceeding.
Any objections?
No, Your Honor.
So admitted.
Thank you, Your Honor. And Mr. Guerin, do you have before you a document entitled Surrebuttal Testimony of James S. Guerin on behalf of the Office of People's Counsel, pre-filed in this proceeding on about April 2, 2021, comprising about 26 pages of narrative testimony, followed by Potomac Edison response to OPC data request number 32-34 and Potomac Edison response to staff data request number 1.4.
Yes.
Okay. And was this document before you either prepared by you or under your supervision and direction?
Yes.
And Your Honor, I request that Mr. Guerin's pre-filed surrebuttal testimony be marked as OPC Exhibit 2.
So marked.
Okay, Mr. Guerin, do you have one correction to make to your pre-filed prepared written surrebuttal testimony?
Yes.
Okay, see, I did it differently. Mr. Guerin, I'm going to show you a response to PE, Potomac Edison Phase 2, Data Request 2-4, directed to OPC. And Your Honor, I request that this document be marked for identification as OPC Exhibit 2-A.
What is it? I mean, you just referenced it, and I think we all have it, but can you tell us how we have it?
Oh,
Is it in your email?
Yes, it was.
Okay.
If not, I'll send it again, but I'm pretty sure it was in there.
And it's 2-4? Yeah.
It-
Okay.
it-
I see it now.
Yeah, you got it?
Correction of surrebuttal. Yeah.
Okay. So I'd ask that it be marked as for identification as 2-A.
So
And
marked.
Thank you, Your Honor. Mr. Garin, were you the sponsor of this response?
Yes.
And did this data request pertain to an error in your rebuttal testimony?
Yes.
And can you briefly explain what the error was and how you corrected it?
Yes. On page 5, line 14, as pointed out by the data request, I make a reference to depreciation percentages. In that, I miswrote that. It should refer to net salvage percentages.
Okay. And was the response to this data request prepared by you or under your supervision or direction?
Yes.
And aside from this correction, do you have any additional corrections or deletions to make to your pre-filed written rebuttal testimony?
No.
If you were asked today the same questions in your rebuttal testimony today under oath, subject to your response to Potomac Edison data request 2-4, would your answers be the same?
Yes.
For these reasons, do you adopt your prepared written rebuttal testimony, including the aforementioned correction, as your sworn testimony in this matter?
Yes.
Your Honor, I move that these two documents, Mr. Garin's rebuttal testimony and his correction, be admitted as evidence into the record of this proceeding.
Any objections?
No, Your Honor.
Exhibit 2, rebuttal, along with 2A, the correction, are admitted into the record.
Thank you, Your Honor, and I turn over the witness for cross-examination.
Mr. Gunderson?
Thank you, Your Honor. Mr. Garin, my name is Chris Gunderson, represent the Potomac Edison Company in this matter. I have a few questions for you today. I'm going to start off by asking you just a few questions on your background. Am I correct that you do not have a master's in business administration?
That is correct.
And you are not a certified public accountant, is that right?
That is correct.
And as a result, you are not an expert on financial accounting or reporting, is that right?
That's correct.
And you are also not an economist, correct?
That is correct.
And you are not a finance expert, is that correct?
That is correct.
Thank you. Can you please, do you have a copy of Mr. Spanos's rebuttal testimony with you?
I do.
If you can turn to page 15 of his rebuttal testimony. And I'm focused on his figure 1. Just let me know.
Yes.
Okay. And you understand, well, I don't need to explain what figure 1 is, we've all read it, but you have no reason to dispute the calculations that Mr. Spanos provided in figure 1, is that right?
I do not.
Okay.
Well, I do, I guess, insofar as he doesn't show specific amounts for each of these columns, I'm sort of if we look at column 19 and say, it's not entirely clear to me what amount that column is supposed to represent. To the best of my knowledge, that the net salvage that I'm proposing accrues about 3.6 million per year. And that doesn't seem to line up with this graph, but I can't tell what the exact amount he's representing here is.
Okay, and you're referring to the bar on the furthest to the right of figure 1.
That's correct.
That bar you're just not sure about. You think it may be 3.6?
If we look at my exhibit JSG2, which I'm in the process of pulling up here, the difference between the accrual for plant only and the total accrual, including net salvage, is about 3.6 million.
Okay. Other than that one figure, you have no reason to dispute the calculations that Mr. Spanos provided in figure 1?
That's correct.
Okay. All right, thank you. Nick, now turn to your rebuttal testimony.
Mhm.
And go to page 4, please.
Yes.
And so this is table, I'm going to ask you a couple of questions on table 1 of your rebuttal testimony. And here you list out by year the negative net salvage values that were accounted for in each year. That's right, correct?
Mm-hmm. Yeah, that's correct.
My first question is, you don't contend in your rebuttal testimony that the company has not actually incurred any of these salvage costs, correct?
No, I do not contend that.
And you also don't contend in your rebuttal testimony that any of these incurred salvage costs were imprudent, correct?
That's correct. I do not contend that.
Good. And so based on this data, since 2013, the company's net salvage costs have increased significantly through 2019, correct?
That's a bit, I'd say that's a bit reductive. I would say that on the whole, they have increased, well, on average, they've increased from 2001 to 2019. Obviously, the highest point is in 2013, and then there are several years past that where the amount is significantly lower. I would say on average, the average has increased over time.
Okay. Well, if you turn to page 5 of your rebuttal testimony, lines 1 to 2, I think what you say in your own words that after 2013, net salvage increased significantly through 2019. Is that what you said?
Yeah, including 2013. Yeah, that's right.
Okay. And
Excuse me.
so based on this,
Excuse me, can we get a yes or a no and not a yeah or whatever, because it's very difficult to write that down.
I apologize. I will attempt to answer yes or no as best I can.
so I'm sorry. Based on this data, 2019, the company incurred net salvage costs of about $8.6 million, correct?
Correct.
However, in your opinion, you expect that over the next 5 years, net salvage costs will drop down to around $3.1 million. Is that right?
I believe that in the next period, call it 5 years, the company is likely to experience some regression to the mean. The overall mean being $3.1 million, the 5-year mean being $5.4 million. And I would expect, just based on general statistical concepts, that the company's average cost of removal would regress towards that mean over the next period.
Okay, well, turn to page 5 of your rebuttal testimony, lines 3 to 5.
Mm-hmm.
I believe what you testified to is that you expect over the next 5 years that the company's net salvage will revert closer to the average over the entire period, which is 3.1 million. That's what you said, correct?
Yes, the key difference in the phrasing here is closer as opposed to 2.
Okay. Now, you understand, and you discussed this on page 8 of your rebuttal testimony, the 2 components of net salvage. They are gross salvage on the one hand, and then cost of removal on the other.
Yes.
And gross salvage is basically the amount of money that the company can sell retired plant for after it's removed for service. Is that fair?
Yes.
And then the cost of removal is how much it costs the company in labor costs or cost to comply with safety regulations, environmental regulations in order to actually remove the plant out of service, correct?
That is correct.
And in fact, if you go to page 8 of your rebuttal, table 3, you reproduce by year the gross salvage amounts that the company has experienced since 2001, where in 2001, they were able to get about $950,000 in salvage, to the point where more recently, gross salvage is essentially zero, correct?
That is correct, yes.
And I believe what you've said in your rebuttal testimony on page 9 line 1, is that you suggested the shrinking of gross salvage is a primary cause for the sharp increase in net salvage costs since 2001, correct?
Yes.
Mr. Garrett, do you have Potomac Edison's hearing exhibits, pre-marked hearing exhibits? Do you have access to those?
I do, yes.
Can you pull up what we marked as Potomac Edison Exhibit 6,
Yes.
which is an Excel file?
Mm-hmm.
All right, and in this document, which was provided to us by Mr. Alexander as a spreadsheet that you created based on data that the company provided to you, is that right?
That is right.
Your Honor, just want to formally mark this as Potomac Edison 6. I know we're skipping over 5, but rather than relabel, I thought we'd just keep this 6, but I'll defer to Your Honor.
We can't hear you, Your Honor.
Potomac Edison, the spreadsheet will be pre-marked for identification as Potomac Edison 6.
Thank you. So what this spreadsheet is showing is, let's say in column J of the spreadsheet, that is the annual cost of, or the cost of removal that have been recorded annually by the company since 2001, correct?
Correct.
And then in column K is the gross salvage amounts that were recorded annually since 2001 to 2019, correct?
Correct.
And in order to get the net salvage cost, you would take the cost of the removal cost, subtract out any salvage amounts that they could get for that year, and then you get for the year the net salvage cost. Is that correct?
That is correct.
Okay. And in your rebuttal testimony, you did not provide a table of the company's annual recorded cost of removal from 2001 to 2019, correct?
Sorry, in which table?
I'll just repeat the question. In your rebuttal testimony, you did not provide a table of the company's annual costs of removal from 2001 to 2019. Am I right?
That is correct. I've only provided the total negative net salvage.
Okay. I think, as you can see from the data in Potomac Edison Exhibit 6, that in the 2001 to 2001 to 2003 timeframe, the company was experiencing cost of removal of under $1 million. But you look at the more recent year and 2019, and the company's experiencing cost of removal in the order of 8.6 million. And then as compared to the gross salvage amounts in the early years, 2001, 2002, you're looking at gross salvage of 900,000, 950,000, 730,000, and then gets down to about 0 in 2019. So, I mean, am I correct that based on this data that the company's cost of removal since 2001 as compared to 2019 have been increased by about $7 million, whereas gross salvage has only dropped by $700,000 to $900,000? Is that right?
That's right.
If the commission were to adopt your proposed depreciation expense in this case, using the net present value method with a rate of return discount rate, the company would only accrue about, and I'll use your $3.6 million for this question, would only accrue about $3.6 million for net salvage costs beginning, I guess, in the first year of the new rates, correct?
That is correct.
And even if costs of removal were to stay generally at the same level, that means that the only way that the company's total net salvage costs could drop down to the $3 or even $5 million range over the next 5 years would be if gross salvage, the amount that the company can get from scrap to offset the removal costs, suddenly jumps up from near zero to $3, $4, or $5 million, correct?
Well, no. Cost of removal could drop year over year significant amounts, as it has increased significant amounts year over year over time. And I would expect, as I've said, that would happen, that there would be some regression to an overall mean. That would mean that the cost of removal in future years would be significantly lower than it has been in the last 5 years, regardless of any change in the gross salvage.
Well, you agree that cost of removal generally go up over time, correct?
On average, over time, yes.
Okay. And you wouldn't expect going forward that the companies would be able to recover a significant amount from gross salvage, correct?
I'm not really in a position to speculate about what the future of gross salvage will likely be. I'm not a expert on salvage markets or anything like that. What I can say is that over time, I have watched gross salvage go down. I don't think that it can go down any further. And therefore, the only possible option is for it to go up somewhat. But I don't anticipate that that's likely.
Okay. Now, Mr. Guerin, you agree that the traditional straight line method of estimating future net salvage can produce reasonable net salvage rates, correct?
I believe that straight line net salvage using a net salvage percentage can produce reasonable net salvage rates. If we're including in that the traditional method of estimation of future net salvage, I'm not sure that I agree, but you can arrive at reasonable net salvage rates without using present value or historical accrual method.
And am I correct that in a couple of cases, you yourself have proposed depreciation rates that incorporate the traditional method of estimating future net salvage?
Yes.
And you've been a certified depreciation professional for about 6 years, is that right?
That's right.
And since that time, you have only proposed using the present value methodology for calculating net salvage in cases pending in Maryland. Is that correct?
That's correct.
And when you testified over the past 5 years regarding net salvage calculations in jurisdictions other than Maryland, you have never proposed to those state commissions to adopt the present value methodology that Maryland has used in recent years, correct?
That is correct.
And you're aware that FERC has expressly considered and rejected the present value methodology for calculating net salvage, correct?
Correct.
Is it your understanding that the District of Columbia is the only other state regulatory jurisdiction that uses a present value method for calculating net salvage?
That is my understanding, yes.
Okay. Can you please turn to page 18 of your rebuttal testimony? And at lines 13 to 15, just read to yourself the question and answer there.
Okay.
Now, is it your understanding that the District of Columbia Public Service Commission rejected the idea of using a present value method based on the rate of return discount rate and instead held that if a present value method is used, the discount rate must be based on an inflation rate?
That is my understanding, yes.
All right, can you pull up or turn to Potomac Edison Exhibit 11, what's been pre-marked as Potomac Edison Exhibit 11?
Oh, 11.
And this is, just for the record, this is a, this is a copy of the opinion and order of the District of Columbia Public Service Commission in case number, is it 1076? Yes, 1076. Okay, do you have that before you?
I do.
Okay. And Your Honor, we just asked that this be marked as Potomac Edison Exhibit 11.
So marked.
And if you turn to page 89 of the PDF, which is paragraph 251 of the order.
251, you say?
Yeah, paragraph 251.
Very well, I'm there.
Okay. And can you just go ahead and read that to yourself, the whole paragraph?
Very well.
Okay. And based on this, the commission's description of the positions of the parties in the case in paragraph 251, is it your understanding that PEPCO's argument in that case that OPC's proposed annual accruals would be far below historical incurred costs of removal is basically the same argument that Potomac Edison is making in this case? Is that right?
Certainly one of the arguments that Potomac Edison is making in this case, yes.
Okay. And are you aware that Mr. Majoros was the DC Office of People's Counsel depreciation witness in the DC case 1076?
I am, yes.
And he is connected to your consulting firm, correct?
Yes.
Was he a founding member of it, or?
Not a founding member, no. I'm not going to be able to accurately recite the company's history, unfortunately, but I believe he came along sometime after the founding.
Okay, but his name is in the title of the firm.
Indeed.
Actually, next go to what's been pre-marked at Potomac Edison Exhibit 12, which
Yes.
is I think it's an excerpt, or is it the whole? I think it's his testimony, Mr. Majoros' testimony in that DC case.
Mm-hmm.
And I'd ask you to go to page
Please give me a yes or
23.
no.
I'm sorry.
I'm sorry, I did not mean to interrupt, but
Oh,
I
okay.
can't use something. I've got to use a yes or no, please.
Yes, I'm there.
Okay. And Your Honor, I asked that this Mr. Majoros' testimony in DC case 1076 be marked as Potomac Edison Exhibit 12.
The testimony will be marked as Exhibit 12 for identification.
Mr. Gary, if you could turn to page 23 of the PDF, which is page 20 of Mr. Majoros' testimony.
Yes, I'm there.
Okay, sorry, I needed to get there. The second Q&A on that page which starts, the question is, why should the 7.96% discount factor be replaced with factors solely reflecting inflation? Can you just read that Q&A to yourself?
I've read it.
Okay. So in that case, Mr. Majoros was explaining that the purpose of using a discount rate in the context of using a net present value method is to remove the effects of future inflation from the utilities charges to current customers. Do you agree with that?
I do not agree with that, no.
Okay. Well, let's turn to page 15 of your SIR rebuttal.
Okay.
Okay. At the bottom of this page and going over to page 16, you quote the commission's order in case 9092. And there's a block quote where the commission held that because future costs are discounted to a present value, today's ratepayers will pay only their fair share of recovery costs in real dollars. You see that?
I do.
And you agree that definitionally a discount rate based on inflation would most closely match accruals to real dollars, correct?
Yes. I'd like to just sort of interject here that I believe the full phrase here will pay only their fair share of recovery costs in real dollars encompasses more concepts than merely inflation. And that's been my understanding of the commission's intention since 1992, as it has upheld it since this case.
All right, I'm next going to have a few questions for you about your service life adjustments.
Very well.
You're recommending adjustments to service lives in 3 distribution accounts, 362, 364, and 365, correct?
Correct.
And you were recommending that the service lives on each of these 3 accounts should be longer, correct?
Correct.
And lengthening the service lives will reduce depreciation expense, correct?
Correct.
And you agree that those 3 accounts hold a substantial amount of the company's net distribution plan?
None of them are the largest account the company has, nor the second. Looks as though 362 is the 3rd largest account. Then 365 is the 4th. Then 364 is the 5th largest account.
Mm-hmm. And in fact, if you total those 3 accounts together, that's going to total about 1/3 of the net plant of the company, correct? Net distribution plant.
Approximately.
Okay. So it's fair to say that adjusting the service lives of those 3 accounts to be longer than what the company proposes would substantially decrease depreciation expense, correct?
That's correct.
And the average service lives that you recommend for these 3 accounts are actually substantially longer than the service lives that you yourself have proposed in other rate cases in Maryland for other Maryland utilities, correct?
I believe that's correct in some cases. I'm not sure. Can't speak to whether that would be the longest I've ever proposed a life for one of these accounts, but certainly longer than some.
Okay. Can you, I'd like to direct your attention to what have been pre-marked as Potomac Edison exhibits 8, 9, and 10. Get those handy. And for the record, Your Honor, Potomac Edison Exhibit 8 is a demonstrative exhibit of the three accounts that Mr. Guerin has recommended adjustments to in this case as compared to the service lives he recommended in two other cases, 9424 and 9355. We asked that that demonstrative be marked as Potomac Edison Exhibit 8.
Be marked for identification as Potomac Edison Exhibit 8.
And then Potomac Edison Exhibit 9 is Mr. Guerin's testimony in case 9355. We asked that that be marked as Potomac Edison Exhibit 9.
So marked.
And then the third exhibit is Mr. Guerin's testimony in direct testimony in case 9424, which we asked to be marked as Potomac Edison Exhibit 10.
So marked.
Okay. Mr. Guerin, did you receive copies of these three exhibits prior to the start of this hearing?
I did, yes, although I actually had to find the more recent version of Exhibit 8, as I appeared to have only had this version that had been sent around on Friday, but I found it now. I have it.
Okay, thank you. Sorry for that confusion. Are exhibits 9 and 10 accurate copies of your direct testimony in cases 9355 and 9424?
To the best of my knowledge, yes.
And does Potomac Edison Exhibit 8, the demonstrative exhibit, accurately reflect the service life years that you recommended in those cases as compared to the service life years that you recommended in this case?
Yes.
Okay. Now, in this case, for phase 2 of this case, you did not conduct any of your own site visits or field reviews of Potomac Edison's plant. Is that correct?
That is correct.
You agree that site visits or field reviews can be helpful when determining the appropriate service lives of the utilities plant?
I believe that they can be helpful at the margins. I do not think that they are, in the main, particularly helpful. I think, in particular, interviews with company management, in particular with respect to future plans, can be very helpful. Site visits can tell you some things about the condition of company's plant, but I do not think that they are usually particularly helpful.
Well, you yourself have conducted site visits or field reviews in other cases, correct?
I have, yes.
And in this case, you understand that Mr. Spanos conducted his own site visits and field reviews for his service life analysis?
I do, yes.
And you relied on Mr. Spanos's notes, field notes, to in this case, correct?
I have.
Mr. Guerin, do you recall that in the case 9424 that the public utility law judge held that you were picking and choosing accounts in a service life analysis in order to project longer service lives for the purpose of decreasing depreciation expense?
I do recall that, yes.
Your Honor, I don't have any other questions at this time. I ask that Potomac Edison exhibits 6, 8, 9, 10, 11, and 12 be moved into evidence.
Your Honor?
Alexander? Yes.
Your Honor, let me just see if I can. Where did I put him? You said, I'm sorry, can we just go one at a time, Mr. Gunderson? Which is the first one you wanted admitted?
6.
Okay. 6, I have no objection to, Your Honor.
6 will be admitted.
Okay, and the next one?
8?
8 is not coming in. That was a demonstrative exhibit that you haven't laid a foundation for who prepared it.
Very well. 9 and 10?
9. It's hearsay, Your Honor. It's not this case. Mr. Guerin answered questions about it, and he'll answer more questions about it. But I just think that it's bringing in things from other cases is incomplete because, for example, this is his direct testimony, but you'd also want to see his surrebuttal. You'd also want to see the transcript of his oral testimony to get the full context. Also, I think that, as you know, Your Honor, I didn't object to any question. And Mr. Gunderson did ask questions. He got straightforward answers. And if he has any more questions, Mr. Guerin, I think we'll be pleased to answer them. But I don't think it's right that it be admitted into evidence in this case.
Mr. Gunderson,
Just respond.
I don't know how exhibits 9 and 10 are particularly relevant.
Well, I mean, so if really Exhibit 8 summarizes the information from 9 and 10 that the company felt is relevant.
But you haven't asked Mr. Guerin, you haven't asked him why the difference. You're pointing out a difference, but without investigating why there's a difference, I don't see the relevance. All you have is a difference without any information.
I'd be happy to explore that, Your Honor.
You or me.
Okay. Mr. Guerin, can you pull up what's been pre-marked as Potomac Edison Exhibit 23?
I'm sorry, Potomac Edison Exhibit 23?
Yes.
Hold on a second. I apologize. I don't. Yeah, there it is. I just didn't have it in my file. Here it is.
I have a question, Your Honor. I'm not sure I've got the right one. I've got MD 9490 P exhibit number 36. So this is 23 in this phase, and it was 36 in the first phase. Is that right?
Yes.
Okay, go ahead. Thank you, Your Honor.
And Mr. Guerin, this, as Mr. Alexander pointed out, this is a data request that staff sent to the Office of People's Counsel in phase 1 of this case. Is that correct?
That's correct.
And in this data request, staff asked you whether you compared your recommended service life parameters with those that you proposed for other Maryland utilities, correct?
Yes.
And I'll direct you to the second sentence of this response, in which you stated that you have conducted and reviewed numerous life studies on electric plant in Maryland, and that knowledge is brought to bear in determining whether the results of the analysis of Potomac Edison service lives are reasonable. Is that what you said?
Yes.
Okay. And isn't it true that in conducting depreciation analyses that, as you said here, comparing the service lives of other similar utilities, either geographically similar or otherwise, can be useful in determining whether the mathematical service life calculations that you came up with should be adjusted based on your informed judgment?
Well, I wouldn't go that far. I would certainly potentially use it as a barometer to judge whether the mathematical curve fitting results are accurate or reasonable. In this particular case, you're comparing, or you're referring to comparison to service lives that I proposed in I believe a Delmarva case, and apologies, the other company was a BGE. You're talking about two companies with very different service areas, very different geographic considerations, obviously very different management decisions. And I believe that my proposed lives in this case are reasonable based on all of the factors that pertain to this company, despite being different from the most appropriate service lives for those companies.
Well, is it your belief that Delmarva Power uses substantially different transformers than Potomac Edison uses?
I can't off the top of my head speak to that. I can say that I am familiar with Delmarva's service map, the kinds of geographic considerations that go into a company that is much closer, for instance, to the shore, that is much more urban, much different retirement factors and those kinds of considerations, despite the fact that transformers are the same. The narrative depreciation manual specifically lists all these factors that you must take into consideration in making the service lives, and all of those factors are taken into consideration in both of these cases.
Is it your opinion that Delmarva Power has a urban service territory?
It's my opinion that it has a more denser, more urban service territory. Yes, that's my understanding.
And is it your understanding that Delmarva Power uses substantially different poles than Potomac Edison?
I don't know that. I can't speak to that.
Is it your opinion that Delmarva Power uses substantially different conductors than Potomac Edison?
I can't speak to that.
And how about BGE? Do BGE substations use substantially different types of equipment than Potomac Edison's?
I can't speak to that.
Does BGE use substantially different types of poles than Potomac Edison?
I can't speak to that.
Does BGE use substantially different types of conductors than Potomac Edison?
Can't speak to that.
Your Honor,
What I can say, having reviewed these cases since they were put into the hearing exhibits, is that having reviewed the data in each of these cases, the data suggests for both of those companies that the much shorter service life was appropriate, the historical data. And that is going to be my first consideration in any service life study.
So no, actually, leave it there. All right, Your Honor, that covers my questions, and I guess at this point I would ask that I would ask you to reconsider admission of Exhibit 8 because Mr. Guerin did testify that it accurately summarizes his service life recommendations in the cases 9355 and 9424. I think there is a foundation for the demonstrative. And in addition, the admission of Potomac Edison Exhibits 9 and 10.
I got to, Your Honor, let me get this. I still remain my objection to I'm just making sure to 9 and 10 for the same reason I said they're taken out of context. You don't know what was followed and you don't have the transcript, and they're not like phase 1 in this case. And they are by definition hearsay. And even though hearsay can be relatively allowed in administrative cases, I just think these two are insufficient as it is to give the full picture. Now, as to 8, Your Honor, if you're going, I don't think Mr. Gunderson asked the full questions that Your Honor was referring to, but Your Honor also said that she has questions. And so I still have my objection, but I think that by the time, if you are going to ask questions, I think I will withdraw the objection. Does that make sense?
Your Honor, I believe you're on mute.
Mr. Alexander, are you withdrawing your objection to Exhibits 8, 9, and 10?
Gary, you're now muted.
Still.
Okay. 9 and 10 are the testimony in other cases. And yes, I am, I still am objecting to these two because they are not, they're hearsay, but even with liberal hearsay, that you'd want the full testimonies in the surrebuttal,
Are there elements of those that you could get through your witness? If you were allowed to ask him some redirect questions, could you clear up your objection on that basis?
well, Your Honor, I would just,
I mean, Mr. Gunderson asked him some questions and Mr. Guerin was able to, I heard some of the reasons the numbers would be different, but if you wanted to further expound upon that and touch on the items that you think would complete the record, the surrebuttal and the transcript, other items, you're welcome to go ahead.
okay, well, I'll do that, but my only reservation for the objection is Mr. Gunderson asked his questions, he got direct answers. And so, and I don't know why you need the testimony as evidence in the record, because Mr. Gunderson got direct answers to all of his questions. They're not, so I don't see what admitting these into evidence, as such they are. I don't see the relevance of hearsay that is from other cases and is not complete. And to ask Mr. Guerin, which I can do, if he can discuss his whole surrebuttal testimonies and his testimony on the stand in these cases without having it in front of him, I just think is unfair. If Mr. Gunderson has some more questions about these, I'm fine.
Okay, how about if we allow 8 to be admitted, but not 9 and 10?
Yes, Your Honor, I'm fine with that.
Okay, we'll admit 8 and not 9 and 10. I think that is a good compromise between everyone's positions.
Yes, and Your Honor, I have to say something because I forgot it. Mr. Guerin has a toddler in daycare, and at 4:45, he's got to leave to pick up his 2.5-year-old son, but he can be back in case this is going on at about 5:15, and he can continue testifying. He didn't think it would go this long, that's all. So he is available until 4:45, and he can be available again at 5:15.
Okay, thank you for letting me know. So for the record, PE Exhibit 8 will be admitted. Exhibits 9 and 10 will not. And does anyone have anything else for Mr. Guerin? No. Okay. Okay, Mr. Guerin, I think you've been here all day, so you've been here for the discussion about credit-adjusted risk-free rates.
I have, yes.
Okay, and Mr. Spanos testified that the SFAS 143 method requires use of that credit-adjusted risk-free rate, correct?
Correct.
And I think your counsel actually submitted an exhibit that was we could read from. Isn't that correct, Mr. Alexander? The FASB 143 excerpts would give us paragraph A21.
Yes, let me, if I can, let me pull that up, but I won't have any, I won't have any objection to it. Let me get the, did I send this on Sunday or?
Yes.
Is this the FASB excerpts from 143?
Yes.
Okay, Your Honor, I have no problem if it's read, if it's admitted. I'm fine.
Okay, so not only did Mr. Spanos testify to that, but paragraph A21 of the FASB 143 excerpt states that an entity shall discount estimates of future cash flows using an interest rate that equates to a risk-free interest rate adjusted for the effect of its credit standing, open parens, a credit-adjusted risk-free rate, close parens. You see that, right?
I do.
So do you agree that based on that paragraph, the SFAS 143 method requires use of a credit-adjusted risk-free rate?
As it is applied to legal asset retirement obligations, yes.
But not as it applies in this case?
I don't believe so, no, Your Honor.
Can you tell me why?
Yes, the conditions contemplated by SFAS 143 as it pertains to legal asset retirement obligations includes several assumptions about the asset retirement obligations that I don't think apply here, and that I think make a higher rate more appropriate. On the first place, legal asset retirement obligation, as the name implies, is a retirement obligation that the company is legally required to incur. And further, the company is required to make specific engineering estimates of the amounts that it has as legal AROs. And so what we have in that case is a clear and specific estimate of an asset retirement obligation that the company is legally required to incur. Now, in the rest of these asset retirement obligations, which I will refer to as non-legal asset retirement obligations, although that's not a technical term, I don't believe, the company does not have a legal obligation to incur them. That is to say, they're ultimately, it is up to their discretion whether or not they incur all or some of these costs. And further, the estimate of the amount of that cost is not based on an engineering estimation, but based on what I would consider very rough ratio of two other numbers, retirements and net salvage. And in the face of that much lower certainty about the amounts and likelihood of those costs being incurred, I think it's appropriate for the discount rate to be higher to reflect that greater uncertainty and risk.
You think that regulated utilities in Maryland have discretion on whether to retire assets or not?
To a degree, yeah. There are definitely some, as Mr. Spanos was discussing earlier, there are some safety and environmental regulations that the company has on it to, for instance, retire poles or certain other accounts. So I can't list a full set of examples, but Mr. Spanos was discussing them earlier, do have some obligations, although how much those obligations are or how much it will cost to meet those obligations, it has not attempted to estimate.
Well, and actually, the record in this case is that Potomac Edison doesn't have any current AROs. Right?
Legal AROs, that's
legal
correct.
AROs. So you
but-
make a distinction between legal AROs and AROs. Correct.
And what I call non-legal AROs, but are there other costs of removal.
So just to, I guess, for my understanding, a legal ARO is where there'd be a regulation in place. I know it sometimes relates to decommissioning of nuclear plants, but there's a legal obligation because there's a regulation or law in place that's requiring the utility to retire something, right?
That's correct.
But as you were referring to non-legal or more casual AROs, you seem to be talking about kind of the general notion that as a regulated utility, it's going to have to remove any plant that it needs to remove, right?
That's right. Although for many types of plant, the company may abandon that plant in place.
Not too many substations are being abandoned in place, are they?
No,
Not too many poles are allowed to just sort of fall down.
no, poles in particular are not allowed to remain in place.
What kind of plant would be allowed to be abandoned in place?
It's less the case for an electric company. For gas companies, obviously, mains are not infrequently abandoned in place. But I can't think of any plant for an electric company where the plant would be routinely abandoned in place.
I can't either. So I think we kind of have an understanding that although there's not a legal ARO, there is a notion that for an electric utility in particular, they have a whole bunch of plant that they're gonna have to retire at some point.
They are, yes. Although, go ahead.
So it's my understanding that Potomac Edison doesn't have on its books a figure for this ARO, right?
That's right.
Did you follow my line of questioning of Mr. Valdez about whether, similar to an ROE expert, a utility could hire an expert to determine the appropriate credit-adjusted risk-free rate?
I did, yes.
Did that? Do you have any thoughts on that? In
Um,
other words, if you don't have a credit-adjusted risk-free rate because you don't have any legal AROs, can one be estimated based on market data and your plan and your creditworthiness and things like that?
Yes, you would want to hire an expert, presumably a cost of capital expert, to make that estimation.
Okay. And there are no cost of capital experts in this depreciation proceeding, right?
There are not.
So just to clarify, your analysis doesn't incorporate a credit-adjusted risk-free rate, either actual or estimated, correct?
Correct. I would, Your Honor, if I may, point out for a moment that Mr. Charlie King, who was a former colleague, now retired, was a cost of capital witness and was one of the witnesses who testified specifically to the use of the rate of return as the discount rate in this case. One of the few cost of capital witnesses to have rendered an opinion on the appropriate discount rate.
Did you say this case?
No, not in this case, Your Honor. In a previous case, as noted in my testimony.
Several years ago, right?
That's right.
Okay. I wanted to talk briefly about the issue of your survivor curves versus Mr. Spanos's, if we could.
Yes, Your Honor.
Okay, so let me get to your rebuttal, I think is where it no, that must be in Mr. Spanos's rebuttal.
I'm sorry, Your Honor. What are you looking for?
I think it's Mr. Spanos's rebuttal that has the comparisons of the curves.
Oh,
Yes. Starting
actually, Your Honor, if you go to Mr. Garen's direct testimony, and James, tell me if I'm wrong, please, but he plots both Mr. Spanos's curves for the three accounts and as well Mr. Garen's own, and along with this, with the data, the full data on this, and I'm looking now, Your Honor, so I can give you it.
yeah, it looks like page 26 of his direct.
Yeah, and at the end, there's a bigger, if you need it, there's the same chart, but larger.
Okay. All right, so Mr. Garen, page 26 of your direct for account 362 station equipment, you have a figure that is comparing, I guess, your curve based on the data and Potomac Edison's proposed curve based on the data. Is that true?
That's correct, yes.
And with the yellow, I have a color version, yellow being the company's and blue being yours. Can you tell me, Mr. Hispano said that the import of choosing the correct curve not only gives you the average service life, which you use in the calculation, but he said something about dispersion rate. Do you recall that testimony?
I do, yes. Would you like me to explain?
Yeah, if you could.
Sure, yes. So the average service life, if you imagine the service life recommendation as a set of a number and then a letter and number combination here. So I'm proposing a 75, increase the zoom on this for myself. I'm proposing for this account a 75-R 1.5. Now the 75 refers to the average service life. That's the number there. Then R 1.5 refers to the dispersion pattern. Elsewhere in my direct testimony, I go into a little detail on this, but essentially the R, L, S, or O refers to where the mode falls relative to the average service life. So an R-shaped curve means that the mode, or the sharpest point in the decline in retirements, decline in survivors, falls to the right of the average service life. Left falls to the left. S broadly is symmetrical. And the importance of this is that it helps us to calculate a remaining life based on the lives of the existing plan. So because these are remaining life rates, you need to know not only what the average service life will be, but how you would expect retirements to go in the future. And that's the point of the dispersion curve.
Okay. So is it correct that for account 365, overhead conductors and devices, and now I am a few pages down. Sorry, page 28, you have a similar. Mr. Spanos criticized your analysis because he said that you are proposing maximum service life, I guess, of 150 or, well, at least greater than 140 years. Is that correct?
That is correct. It looks to be just shy of 150. Yes, that seems right.
So that dispersion, which would take the service life out that far, has an effect on the remaining life, which goes into the calculation.
It does, yes. I would say that it has a relatively small impact. You're talking about a pretty small percentage that you'd expect to live that long. But that is not unusual or completely out of the realm of reason for utility plant. I myself have studied the electric plant, the plant of I've studied the lives of electric plant that has survived over 100 years in New Jersey. And I do not expect that will be the last time that I encounter that. I would, hasten to caution that this will not have a dramatic effect on the remaining life because we are talking about such a small number of plant that's going to live this long. But it does have an impact, and it's, I don't think, unreasonable.
What's more important, getting the average service life correct or the, I guess, maximum?
Well, it's certainly more important to get the average service life than the maximum service life correct. There are going to be some curves. For instance, any L curve is going to have a very steep decline in the retirement in the survivors early in the life, and then it's going to have a very long tail where there's going to be some very small amount of plant that has a very long survivor. And that long tail is going to have a very minimal impact on the remaining life and therefore the depreciation expense, whereas the average service life has a very significant impact on the depreciation expense, regardless of the curve dispersion.
So is it your opinion that it's more important to fit the curve guess up to and including the average service life than it is to fit the curve past that point? I know that we have no data there, so we can't really see whether it fits or not, but we can see how it fits up to about, I guess, in this account, what is that, age 75? Is that right? Am I
I
reading?
apologize, Your Honor. I'm not sure I understand the question.
Okay, let me try to rephrase. So am I reading this right, that we have data points to about age 75?
That looks to be about right, yes.
Okay. And that is your proposed average service life?
And
It's also 75?
yes.
Okay. Is it
76 are 0.5.
Oh, I'm sorry, 76. Yes, you're correct. So is it more important to match the data to a curve from, I don't even want to go back to 0, but let's say years 10 to 76, or is it more important to match the curve from age 76 to age 148, let's say?
Well, the function of the Iowa curve beyond the oldest existing, if you're looking at the portion of the Iowa curve that extends beyond the oldest plant in the study, which is here beyond 75 or thereabouts, the purpose is to try to estimate how long that oldest plant is going to last, and how long the oldest plant is going to last going into the future. So inherently, trying to fit the path, the point of the, excuse me, trying to fit the portion of the survivor curve beyond what you have data for is inherently more speculative. It can be done based on the data that you have and based on the data you see. Sometimes the data is going to give you a better or worse indication of what the extension of that survivor curve should or will look like. Sometimes you have to base it on the data you have combined with your knowledge of the plant. It's not possible to sort of generalize about that. I would say, you want to fit the historical data that you have to the curves that exist as best you can, and then try to make judgments about what the curve is going to look like in the future.
Okay, so I'm looking at this account 365, and it's pretty clear that the curve that you're proposing matches the data better, especially around the average service life. So my question is, Mr. Spanos says your maximum service life of over 140 years is unreasonable. So should one pick a curve that ends with a more reasonable, in someone's opinion, maximum service life, even if it means not really matching the data that you do have prior to the average service life?
I certainly do not believe so, Your Honor.
Okay. Is it possible that,
Can I elaborate on that a little bit, Your Honor?
sure.
I just want to point out that we talk about one or the other maximum life being more or less reasonable, but in reality, we don't know what is more or less reasonable. We have estimations based on the management expectations. We have, our expectations based on historical data. But to say unequivocally that maximum life over 140 years is unreasonable is just inaccurate. He does not have a sort of there's no evidence-based reason to conclude that that's unreasonable.
Okay. But would you look at just the average service life and pick what's reasonable?
You can look at the average service life and compare the average service life to other average service lives being used in the industry.
So say your curve, the blue curve, fits the data.
Yes.
And you end up with an average service life of 76.
Mm.
But you look at data in the industry and you decide, No, it should really be 70. At that point, you're kind of disregarding the data points.
You are, yes, and that's not infrequent. You will frequently look at a account where, for instance, there simply isn't a lot of retirement data. You may be looking at an account where, for some reason, you only have a limited range of data, 30, 40 years of retirement data, and there aren't very many retirements. There, you certainly are, in many cases, forced to look at other. I would tend to focus on average service lives that have actually been adopted by commissions around the industry, to arrive at a reasonable conclusion. And there are many cases where you might put a maximum constraint on the average service life to be fitted to the data. And
Have you done that in this case?
that was the question I was just anticipating. Let me look to see.
So it sounds as though you would adjust the average service life based on information in industry, but not based on where that curve takes you to a maximum.
No, not based on the maximum, where the curve takes you to a maximum. I would not say so.
But the industry, yes.
I would also point out that in this particular case, right here, and as you were asking questions, I really do want to make clear that the data for this account, 365 overhead conductors and devices, is not a very good fit to either of these curves. The best fitting curve that was available to my mathematical curve fitting was a 01 curve, which is just a straight line. And if I'm remembering correctly, was an 8601. Maybe misremembering that. I have to look. But the purpose is to say that I've not gone with the best fitting life and curve for this account because I don't think that an O curve makes the most sense for this plant category. I've attempted to compromise between the data and what I would expect to see for an account like this, which, as Mr. Spanos has selected, an R1 curve, I think is a low modal R curve would be appropriate. I would expect retirements to gradually increase as the age increases on this plant. I've selected a somewhat more gradual curve than Mr. Spanos. I've selected a longer average service life, which is in keeping with the data. But I've actually compromised here away from the best fitting curve, which I don't think is a good fit for this count.
Because it's a straight line and that's just not what would happen with this type of equipment.
Not generally what you would expect to see.
Okay. Would something between 62 and 76 be reasonable?
Yes.
Okay. If we go back up to 364, and I know you need to leave in 5 minutes. We can come back to this if we want. 364, your curves are the same curve, but yours is just a longer average service life, which seems to fit the data out a little better. Would you say that's correct?
That's correct.
And 362, what do you say about that? It looks, again, like your curve fits the data pretty well. You're both suggesting R curves, but yours is 1.5 and the company is proposing 2.5.
Yeah, and I didn't include, I've run you can see the T-cut, which is the yellow triangle here. It runs all the way to the end of the data. But in fact, I've run versions of this where the T-cut is further up. They were not provided in my study, but my curve is a better fit to the data, even if we make that cutoff somewhat further up the data.
Okay.
As you can pretty much see from this, the curve that I've proposed here is a better fit to the data, really at any point on the curve.
What's your response to the significance of what you're proposing in this case versus what you proposed in phase 1?
The only place that I could find where there was a really significant difference between what I proposed in phase 1 and in phase 2 here is for 365, where I have proposed that the R 0.5 curve, as opposed to the O1 curve, which I did propose in the first case. And I would say that I selected the R 0.5 curve in part in this case in sort of acknowledgement of the information that Mr. Spanos was able to glean in his field trips and interviews. I reviewed those notes and essentially came to a different conclusion regarding the best fitting curve shape for this. And the curve, selecting the R 0.5 curve as opposed to the O1 curve in this account had a much more significant impact on the average service life selected than it might for a different account. Hopefully that answers your question.
Okay, why don't you go? I'm not sure I'm going to have more questions, but I'd like to reserve the right to ask you some more questions, but I know you need to go. So do you mind hopping back on when you get back?
I don't mind at all, as long as you don't mind a little bit of toddler screaming.
No, it's fine.
Thank you, Your Honor, very much. I will come back as soon as I'm able.
Okay, great. Thanks.
Thank you.
Mr. Dean, are you still with us?
Yes, Your Honor.
Do you have a witness you'd like to call?
We have two staff witnesses. The first would be Mr. Felix L. Patterson.
Mr. Patterson. I see he's here.
Your Honor, can we
Yes.
have a 10-minute restroom break?
Oh, certainly. And then hopefully I'll give Mr. Patterson time to join us. Okay, we'll be in recess for 10 minutes.
Okay,
Oh, there
thank
he is.
you.
We'll be right back with you, Mr. Patterson.
Thank you very much. Can you hear me?
Yes, I can.
Thank you.
Thank you.
Hello. How you doing?
Okay.
Mr. Dean, are you back?
Yes, Your Honor.
Okay. How about Mr. Gunderson? Okay. We're back on the record. Case number 9490, phase 2. Mr.
Well,
Patterson. Thank you. Mr. Patterson, can you please raise your right hand?
Yes.
Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead, Mr. Dean.
Mr. Patterson, do you have before you a document entitled The Direct Testimony of Felix L. Patterson, consisting of 11 pages and some exhibits?
Yes, I do.
Do you also have before you a document entitled The Sir Rebuttal Testimony of Felix L. Patterson, dated April 2nd, consisting of 7 pages and 1 exhibit?
Yes, I do.
Were both of these documents prepared by you or under your supervision?
Yes, they were.
Do you have any changes or corrections to these documents?
No, I do not.
Taken together, do these documents constitute your testimony in this proceeding?
Yes, they did.
Your Honor, I'd like to mark these 2 documents as staff exhibit number 1 and number 2.
So marked.
The witness is available for cross-examination.
Mr. Curran?
Yes, Your Honor, thank you. Good afternoon, Mr. Patterson, and thank you for hanging in there.
Thank
My
you.
name is Joseph Curran, and I represent Potomac Edison in this matter. My understanding, Mr. Patterson, from reviewing your testimony, you are a public utility auditor for the commission. Is that correct?
That is correct.
And as part of your assignment in this matter, your testimony indicates that you conducted an evaluation of the depreciation study that was conducted by Mr. John Spanos in these proceedings. Is that correct?
That is correct.
And my understanding is that you analyzed the average service lives and net salvage costs to assess their reasonableness in this matter. Is that right?
That's correct.
Your Honor, I'm going to object to this line of questioning because it's friendly cross. There are certain areas where I'm hearing an echo. There are certain areas where the company and Mr. Patterson agree, and there are certain areas where they don't. There are certain areas where OPC agrees with Mr. Patterson, and certain areas we don't. I think on the survivor lives that since Mr. Patterson accepted them, I don't think any questions would be appropriate from the company because that's friendly cross. There are other areas that are not. I'm not saying that all cross is done. I just want to make that clear. Since he accepted the curves, what's there to cross?
Mr. Curran, are you getting to a point?
Yeah, first of all, I hadn't even asked him a question yet, Your Honor. I'd like to be able to get to that. But as for friendly cross or not, I'm just trying to explore Mr. Patterson's testimony, and that's all we're doing.
Okay, let's get to a question that has some relevance.
Yeah, just I've asked Mr. Patterson, I'll ask you again, as a part of your analysis in this case, you conducted a study of the average service lives as well as the salvage cost in this matter to determine their reasonableness. Isn't that correct?
That's correct.
And as for service lives, you're not recommending any changes at this point, are you?
That's correct.
All right. And as for net salvage costs, my understanding is that you are recommending that the commission continue to use its SFAS 143 method for determining salvage costs. Is that right?
That's correct.
And you're making that recommendation based on commission precedent.
That's correct.
Now, in reviewing your testimony, sir, I have not seen any area in which you conduct any analysis of whether or not Potomac Edison will be able to recover its actual incurred set net salvage costs using the depreciation expense recommendations that you're making in this case. Is that right?
That's correct.
So, and along that line, do you have, Mr. Patterson, in front of you, a copy of Mr. Spanos's rebuttal testimony?
Yes, I do.
And if you don't mind, can I direct your attention to page 15 of Mr. Spanos's rebuttal testimony?
Okay, I'm there.
And before preparing your surrebuttal testimony that you filed in this matter, did you have an opportunity to review the figure that is identified on page 15?
Yes.
And in this figure, it demonstrates that based on the recommendation of staff, the company would not be able to recover its actually incurred net salvage costs from 2015 to 2019, with the exception of 1 year. Isn't that a true statement?
That's a true statement.
Right. And as part of your surrebuttal testimony, you did not take issue with any of the figures presented on page 15, did you?
No, I did not.
And Mr. Patterson, I didn't see in your testimony of whether or not the commission, as a part of your review, looked into any impact on the company's cash flows as a result of the recommendations you're making in this case.
That is correct.
All right. Do you agree, sir, that the company would have a significant reduction in its cash flow as a result of staff's recommendation?
I think we don't know until it actually happens.
But you're recommending a decrease in depreciation expense, correct?
That's correct.
And all things being equal, that reduction in depreciation expense would impact the company's cash flows, correct?
From that standpoint of view, yes.
Thank you, Your Honor. Those are all the questions I have for Mr. Patterson.
Mr. Alexander, do you have any questions for this witness? You're muted.
I'm going to try to avoid friendly cross.
I
But
really
hope-
prefer the unfriendly cross.
Yeah, I know. Hi, Mr. Patterson. I'm Gary L. Alexander for the Maryland
you.
Office of People's Counsel. It's good to see you healthy and well.
Nice seeing you as well, sir.
Thank you. All right, I have got you, as you just answered, you have accepted all of the service lives proposed by Mr. Spanos, correct?
That is correct.
Okay, and would you agree that there are 3 different aspects of choosing an appropriate survivor curve? And one of them is visual, and one of them is mathematical, which is the sum of the squares, and the other is applying some judgment from an expert judgment. Would
That's
you agree to
correct.
that? I'm getting junk calls, Your Honor. That's
Yeah, you know, your phone has a button, you can turn it off on vibrate, then we don't hear it.
yeah, yeah. It's a
How's
new
that?
phone, so I don't really know what I'm doing. But let me do
And then
that.
just put it in the other room.
I can figure it out
Okay, excellent.
there. But it's the other phone that's driving me nuts. Okay, so Her Honor was discussing some charts in Mr. Garen's direct testimony. Do you have a copy of that?
Yes, I do.
Okay, so I'd like to turn your attention to page 26 of Mr. Garen's direct testimony. And on there, you'll find a survivor curve graph for account 362 station equipment. Please tell me if you're there with me when you get there.
I'm there with you.
Okay, so the X's are the actual data, correct?
Correct.
Okay, now would it? I already talked, and I assume you were listening that in this account, Mr. Spanos did not include all of the actual data because he thought it was insignificant to to what he considered to be, in his judgment, a better curve. Did you hear that?
Yes, I did.
Okay, then would it surprise you that at the horizontal line at 0.4 and at the between the 80 and 100 age, do you see those X's there?
Yes, I do.
Were you aware that they were not on Mr. Spanos's curve, that they weren't put there at all?
Yes, I understand.
Huh? I'm sorry?
Yes, I noticed that.
Okay, so now looking at that, can you tell me from a visual curve fitting, if you take a look at the at 0.06, all of that data, and then between the ages of 60 and 80, and then at 0.4 survivor between 80 and 100, from a visual curve fitting, would you tell me whose you believe better fits the data? The actual data.
Well, this is just recall. It looks like the graph, it does better fit the actual data. But when you look at it from a judgment standpoint of view, the other one can be well as done as good. It'd be good as well.
I'm sorry, he's cutting off on me. I'm not really picking up every word he's saying. Could Mr.
I said
Patterson?
the company's curve could be just as well.
Mr. Patterson, you're up twice. Do you see that? You have, it's like you have the WebEx account up twice. Okay, if you delete the one or get out of the meeting in the one, then I think we'll do better. Do you see on your screen that you're at the top now, but then Marty is also on my third row?
Yeah, my issue is how I get out of it. Just come completely out.
You want to be out of that other one. Yeah, because I think that's why we're getting that horrible feedback. Do you see an option to leave meeting on that one? I hope we don't lose them all together. He's there. Maybe, hopefully he'll come back on the other one.
He will.
It was a risk, but I had to take it.
Your Honor, he's still showing up on my screen, Marty, underneath Gary Alexander.
Yes, that's where we're hoping he comes back. We're giving him a minute to get over to that one. Okay, that was totally my fault, but
That's okay.
wait, now we have him in both places again.
Still in both places.
Yeah, but Can you turn down the other one, or is it the same? You have both places on the same laptop?
On the bottom menu bar, do you have
How's that?
do you have a
that
second
better?
circle?
That's actually seems to be better.
Is that better?
Yeah, let's try to move forward. Sorry. Mr. Alexander, do you remember your question?
Yes, and I think, Mr. Patterson, just tell me if I remember your answer correctly. You said that Mr. Garen's curve does appear to fit the data better, but there's also an application of expert judgment.
That's correct.
Okay, now, what judgment would you apply to this to go with to stay with Mr. Spanos's curve rather than Mr. Garen's curve?
Well, staff looked at what the labs were for some of the other companies within this area, and they're pretty close.
Okay. Okay. Let me ask you this. If while we're on Mr. Garen's, where is it now? I think there it is. On his direct testimony, can you go to page 365? And are you
Do you
Are
mean
you
account
aware?
365?
Yes,
Yeah,
account
yes.
365, and it's page 28 of Mr. Garen's direct testimony. Mr. Spanos also did not include some of this actual data. Are you aware of which he did not include?
You say that some is actual data?
Yes, just like he cut off on 362, he cut off on 365 as well.
Oh, yes, he was consistent. Yes.
Yeah. Do you know what he cut off?
I can't.
Okay, so I think the best way, and make sure, I want to also make sure that I'm saying the right thing. So if we go to Mr. Spanos's direct testimony, which has his depreciation study,
Yeah.
and I'm going to look for his curve for account 365, because maybe I got it wrong, and I do not want to mislead either you or the other parties or the judge.
My depreciation study, what page are you looking at?
I'm getting there.
Okay.
I assure you, before I talk about it, I'm going to tell you. 364, 360. This is it. Okay. Let me just make sure. I have to. All right. I had to turn around the document, and let me make sure that it's on page. I'm going to say, instead of Roman numeral 5II, let's just call it 7-19 of the depreciation study. It'll say account 365, and I do want to make sure that I'm saying the right thing, because if not,
Okay, I have
it goes to 0.06 and then short of 80. Because if I'm wrong, I'm going to withdraw the question, obviously. A little below 0.6, and a little close to 80. Yeah, if you take a look at the depreciation study where we just said,
Yes.
Okay. Do you see that the actual data ends at a little above 60% surviving and say 66, 67 age in years?
Yes. Yeah.
Okay, now if we go back to Mr. Garen's, which I have to find too. The actual data goes to closer to 80 and below 0.6 on the survivor. So again, looking at this curve, this visual thing, would you agree that Mr. Garen's better fits the actual data than Mr. Spanos's curve?
It's close. It's close.
Mr. Garen's is closer. Is that your answer?
Yeah. It kind of goes back to what Donna was saying. Do you want to set something in somewhere in the middle?
Oh, okay.
But both would seem very reasonable.
Okay.
It's by judgment.
Yes, and I understand that, and thank you. And I'm going to move on to something else, and it's going to be very short. You, in your testimony, and I don't have it right at hand, maybe I do in this thing here. Your main recommendation for the discount factor is using the overall rate of return that you say is commission precedent, and you give some reasons why that's your recommendation, correct?
That's correct.
Okay, now you also say that it shouldn't, whatever the commission picks, it shouldn't be below the, say it right here, the credit risk, no, the credit adjusted risk-free rate, that it shouldn't go below that. Is that correct?
That's correct.
And do you state the rate in your testimony that you believe it shouldn't go lower than?
Well, staff believes that it should be the commission's president authorized rate of return. That is our recommendation. That is our position. However, if you're referring to serve rebuttal, where we make the statement about the 4.54, we're just saying here that if the commission were to look at a different rate, it should be a credit adjusted risk-free rate tied to the ARO, the company's ARO.
And in your, you believe that it's 4.54 for this case, which is from the January 2019 Pennsylvania Electric Company, and you give a cite for it. It's Potomac Edison response to staff DR 4.4. Is that right?
We use that because PE said that they didn't have a rate, a credit adjustment risk-free rate. So when we asked this data request, we asked the two ways. One was 4.3, one was 4.4. 4.3, we wanted to know why the company kept saying 2.5, because they said 2.5 in Columbia's case. So we were trying to get the company opportunity to explain to us why they were using 2.5. They didn't tie it in 4.3, they didn't tie the 2.5 to ARO. So that's why we asked this backup question here and said, what are they using? Now, they didn't say in this question here, 4.4, that 2.5 was being used currently for a Pennsylvania Electric Company. What they said they were using is the 4.54. So we use that as a surrogate. That's correct.
Okay, Your Honor, I think everything else would be friendly cross, so that's it for me.
You're on mute, Your Honor.
I keep doing that. I'm sorry. Mr. Patterson, in your sir rebuttal, at page 5, line 7, you testified that the SFAS 143 method requires use of a credit-adjusted risk-free rate. Correct?
That's correct.
And then you went on to see if there's anybody I can mute. Mr. Alexander, I'm muting you. You went on to say the discount rate proposed by staff using the utility's authorized rate of return is in line with that standard. Do you see that testimony?
The reason why we're saying that is because at the time that, although there's not a clear indication as to why the commission chose the authorized rate of return back in 2007, we do know that SFAS 143 was around and it said credit adjustment risk-free rate and the ARO. So we have to think that commission took in consideration in making determination that the authorized rate of return would be the correct credit adjustment risk-free rate. That's why they made that decision. They looked at that.
Okay, so you're not
143 was here at that time.
okay. So you're saying that it's in line with that standard because the commission decided the way it did. You're not at all
Exactly.
suggesting that 7.1% or thereabouts for ROR is in line with a credit-adjusted risk-free rate of 4.54 in terms of
Another one, we
numbers.
would say that it would have to be what you got two elements to SFAS 143. One is the credit adjustment risk-free rate, and the other one is the ARO. So if you're going to consider anything else, we would say that it would have to be something tied to those two variables. And that would be that's why we asked the question in 4.4, what credit adjustment risk-free rate were they using for their ARO?
And with that, you got the answer of 4.54. Do you still think that using the authorized rate of return of 7.1 or thereabouts is in line with a rate of 4.54?
We think it's in line with the commission's precedents until it can be proved differently. We haven't seen anything that proved that it should move away from from the authorized rate of return at this point.
Okay, but using a rate of 4.54 would arrive at very different depreciation rates than 7.1, correct?
That's correct.
Okay. Do you have any familiarity with deferral accounting?
A little, yes.
Okay. Do you see anything, does staff have any issue if there comes to be a delta in depreciation expense out of this case, which would result in lower distribution rates? Do you see an issue with deferring that delta until the next base rate case, applying carrying costs on that delta to make ratepayers whole?
I believe what you're referring to is it's going to have a decrease in the revenue requirement because depreciation rates. And staff's position is that should take place now at the end of this case and not be deferred.
Yeah, no, I understand it, that staff's position that it should take place now. But if it were deferred until for 14 to 18 months, is there a way to make ratepayers whole for that deferral in time?
There's a way to make ratepayers whole, but what will be happening there is ratepayers are going to be paying a higher rate than what they should during that period. You probably could go back and put carrying costs on it, which is what I heard early in the hearing. That was nothing that the company suggested. So, and we're looking at the order, we interpret the order saying that should happen at the time that this case was decided.
Okay. Did you review Mr. Guerin's testimony regarding service life estimates?
Yes.
Okay. Oh, and to clear up, Mr. Alexander showed you the comparison of curves, and he asked you about data that wasn't included. And you seemed to answer saying, I see that now. But did you know at the time you reviewed Mr. Spanos' testimony that not all the data was included on his figures with respect to the survivor curves?
Yes, I knew.
You knew at the time you reviewed his testimony? Okay.
Yes.
Now, turning to Mr. Guerin's testimony, you reviewed that, but you didn't provide any testimony with regard to Mr. Guerin's testimony, did you?
No, the reason why we didn't oppose Mr. Guerin's testimony is because it's judgmental. Is we're looking at what's going to be reasonable. We thought what the company preferred, what the company came up with was reasonable based on our review, looking at what was done with the other companies in the area when we looked at them, as far as what their curves were and their lines were. That's not to say that Mr. Guerin's study is not right, because when you say it's a judgment, it's really an opinion. That's his opinion of what it should be. It could be any place in between.
But did you review his estimates in particular to see if they were reasonable? Did you find them unreasonable, or did you not really look at it that closely?
Well, I won't say we won't find them unreasonable. We found that the labs they stretched out pretty far.
To an unreasonable degree, or still within a range of reasonableness? Help me out here.
I wouldn't want to say it was unreasonable. I think if I have to find a happy medium in between the two of them, that would be more reasonable.
So it's your testimony the most reasonable estimate for average service life would be somewhere between the two experts' testimony in this case?
But to say that, not to change my assessment, I would say that the companies, it seems more reasonable, but we would have no problem with something in between.
Okay. Did you listen to Mr. Valdez's testimony with regard to the regulatory asset they are proposing in this case, with regard to the depreciation study?
Yes, I did.
Was it your understanding that all of the costs of this case, not only the depreciation study itself, which occurred prior to this proceeding, but also all the costs of testimony associated with depreciation during this proceeding, and then all of the outside counsel fees, all of that was included in Mr. Valdez's, what he's proposing to put into a regulatory asset?
Well, we saw it as, we read and interpreted it as being the depreciation study. But this whole case is basically depreciation study. So if it was if there's a certain amount more that had to go into the regulatory asset, we wouldn't have a problem with it. It's probably not going to be that great.
You don't know that, do you?
Most of it.
You don't know how much counsel for Potomac Edison charges, do you? So are you saying that in part because they're proposing no carrying costs on that regulatory asset?
We didn't discuss whether to put carrying costs on that. That's something maybe the commission might want to consider if they want to put carrying costs on, since they're going to defer it. Yeah.
Well, as I understand Mr. Valdez's testimony, they are not asking for carrying costs on that regulatory asset. Is that not what you understood?
That's what I understood.
Okay, so they're just going to take the amount that this proceeding cost, and they would like it all to be considered in the base rate case, right? But no carrying costs on that amount.
We could agree to that, yes.
I'm sorry, what did you say?
Staff could agree to that, yes. No carrying costs on that.
Okay, but the prudency of all the costs would still be up for debate in the rate case.
That's correct.
Okay. All right, Mr. Patterson, that's all I have for you. Any redirect of Mr. Patterson?
No, Your Honor.
None, Your Honor. I'm sorry.
Questions based on my questions? Okay. Thank you, Mr. Patterson. This witness is excused. Mr. McAuliffe, are you still with us?
Yes, here.
All right, I'm going to give you your choice. Do you want to testify today or tomorrow morning?
I'd rather take care of it now.
Okay, then we will proceed. Mr. Dean. Actually, I assume you're going to call him to the stand. So raise your right hand, Mr. McAuliffe, please. Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, Mr. Dean.
Mr. McAuliffe, do you have a document entitled The Direct Testimony of Drew McAuliffe on behalf of the staff of the Public Service Commission dated January 29, 2021?
Yes.
And do you have a second document entitled The Rebuttal Testimony of Drew McAuliffe on behalf of the staff of the Public Service Commission dated April 2nd, 2021?
Yes, I do.
Were these documents prepared by you or under your supervision?
Yes.
Do you have any changes or corrections to these documents?
No.
Taken together, do these constitute your testimony in this proceeding?
Yes.
Thank you. Your Honor, staff would like to mark.
I'm having a little trouble hearing. Mr. Patterson still has his mic on. Okay, now let's try it again because I'm getting really weak sound out of Mr. McAuliffe.
Do you want me to repeat any of that?
Just the last part of what you were just saying when I interrupted you. I apologize for that.
Okay. Your Honor, staff would like to mark these documents as staff exhibits number 3 and number 4. I assume you said.
You're muted, Your Honor.
Mr. Dean, if you're going to do the same thing you did with Mr. Patterson and make Mr. McAuliffe available for cross without entering his testimony, you run the risk that you don't ever enter it like we did with Mr. Patterson, which I assume you would like to move Mr. Patterson's testimony, direct and rebuttal into evidence.
Yes, Your Honor.
Does anyone have any objection?
None, Your Honor.
Okay, we're going to go backwards and enter staff exhibits 1 and 2 into the record. And does anyone have any objection to Mr. McAuliffe's testimony exhibits 3 and 4 coming into the record?
No, Your Honor.
No, Your Honor.
Okay, so let's go ahead and enter Mr. McAuliffe's testimony exhibits 3 and 4 into the record. Now, is he available for cross?
Yes, Your Honor.
Okay, Mr. Gunderson or Mr. Curran?
No questions, Your Honor.
Okay, Mr. Alexander?
No questions, Your Honor.
Okay, I guess that leaves me. Mr. McAuliffe, are you familiar with deferral accounting?
No.
Okay. So I understand your testimony in this case is that there is no reason not to implement new distribution rates based on the new depreciation rates that come out of this case. Do I have that correct?
Yes. I think what you meant to say is, yes, I believe there should be new base distribution rates based on these depreciation rates. Correct.
Okay. And Mr. Valdez didn't provide any reason that you found to change your opinion in that with regard to lining up, the change of rates, that kind of thing.
No. Considering this was a phase 2 of an ongoing base rate case, I felt it necessary to flow through any changes with the distribution rates into the base rates.
Okay, and I think that's all I have for you. Okay, thank you. You're excused. Oh, I'm sorry.
Your Honor, no. It's not McAuliffe. James is back. Mr. Garin is back, and I just wanted to know if, hi Jane, if you have any additional questions. He's back.
Okay. I don't know if any council will find this unfair, but Mr. Garin, with respect to at least one account, you answered me to say that it would also be reasonable to come up with an average service life between what you proposed and Mr. Spanos, what he proposed. Would you say that was true for all three of the accounts that you recommended a difference in?
Reasonable? Yes. Yes. I would say that for accounts 362 and 364, I think that my proposed curve, life and curve are significantly better fit to the available data, but I think there are reasonable life and curve could be found between them for sure.
Okay, and then 365?
Same, yes. 365, I would say the data there is complicated, is difficult enough that it would be very reasonable to find an intermediate point.
Okay. I think that's all I had for Mr. Garin. Thank you very much for coming back.
Of course.
Council, as I alluded to in looking at the procedural schedule, I just wanted to verify that everyone feels it's necessary to have both a initial brief and a reply brief in this case, seeing as it's a one issue.
Your Honor, should I go first?
You may.
I think one brief is fine. The commission has had much more complicated cases and allowed 80 pages for 4 or 5 subjects. I mean, this is just, it's just a depreciation case. And so I don't see any reason why it shouldn't be one brief. And I mean, I think 60 pages more than do it, but if the company wants 80 and Your Honor wants to read it, I'm not going to stop it. But that's my opinion, Your Honor. One brief, whatever page limits the other parties want, I'm fine.
Okay, Potomac Edison.
Your Honor, I think it would be beneficial to have a reply brief. I don't think it needs to be very long, but I think it is helpful to have a reply brief to respond to any arguments that are made. However, as an alternative, we could also do this in a way where OPC and staff file an initial brief and the company files a response brief. Since, you know, we have the burden of proof, we can have the final word. We can do it that way. But I think it is, if we do it the more traditional commission way, then we would still like to have a reply brief, even if it's more limited in page length.
What are you proposing for page limits for the initial and reply?
I think the initial could be 30 pages, 35 pages, and then a reply of like 10 to 15 pages.
Mr. Alexander, I assume you did not like his second suggestion of you guys file initial and he files a reply.
No, Your Honor. I would probably say 45 or 50 pages for the initial. And as I said, if the company or staff or both want to reply, say 15 pages, 17 pages, whatever.
Okay.
Not going to
Staff?
jump up and down about it.
Okay. Staff, does staff have an opinion on the page limits?
Staff will go along with whatever is reasonable with the other parties.
Okay. The initial brief will be limited to 35 pages. The reply brief will be limited to 15. Do we have anything else we need to deal with today?
Not that I know of, Your Honor.
Okay. Thank you, everyone. Thank you for sticking it out and getting this done today. And we are adjourned.
Thank you.
Thank you.
Thank you.
We're off the record, Your Honor. Thank you.